Hello, everybody. Hello. Welcome to today's episode of the Law of Self-Defense. So pleased you can all be here today. Of course, you all know by now, but in case anybody doesn't, I am attorney Andrew Branca for Law of Self-Defense. I don't know if my... Thank you so much for the applause. Thank you. I don't have my usual audio going, but I guess you guys can tell me if it's working okay. That would always be appreciated. Let me make sure all the streams are working. It looks like they all are. Let's see. The last one would be Rumble. Let's see. My content. All right, looks like everything is going just fine. Court should probably start up in just about half an hour. Let me get that stream ready. I'll go with the, let's see. Yeah, coverage will begin soon. This should be... Well, I don't know. Let's see. Maybe I'll have to start with the law and crime. Stream. I hate to do that because they do such a bad job, but... Okay. Well, they're ready to go, so I'll start with law and crime and see how things go from there. Oh, we got some weird light coming in here, don't we, today? Okay, I'll try to keep out of that. Oh, I see. Okay. All right, folks. So we're covering the trial of Aaron Dean. I'm going to do a quick readout of my notes from the last couple of days. So far, I have to say the trial seems to be going very well for the defense and rather poorly for the state. But before we do that, I do want to mention today's sponsor, and that sponsor is none other than our very own American Law courses. These are law school level courses. Taught through Law of Self-Defense with professors we've selected for their expertise and entertainment value. These are law school level courses taught for normal people, people who would like to have the experience of law school level courses, much as they're taught in the first year of law school, but at the fraction of the cost and time of law school and without the toxic politics of law school today. We have classes in... we're just finishing up criminal law. Today is the last criminal law class of the fall semester, taught by none other than our very own Steve Gosney. The second week of January, we have 2 spring courses starting, American Property and Evidence Law. Those are semester-long courses, just like they would be in law school. And then we also have courses coming up in criminal justice, constitutional law, criminal procedure, and so forth. We're still in the pre-registration period for a few more days for this spring's property and evidence law courses. You can save half off on the tuition, folks. That's over $1,000 per course if you sign up during the pre-registration period. You can learn more about all that at AmericanLawCourses.com. There is a constitutional law class. I'll have to check. I believe it's scheduled for the fall, next fall 2023 semester. And yes, I think con law will be a lot of fun. Might just teach that one myself. We will have to see. So that's AmericanLawCourses.com. All right, folks. Thank you. Thank you all very much. Let me put my banner up here for our... Get your free copy of The Law of Self-Defense Principles, the best-selling book. You can find it on Amazon. It's 5-star rated, well over 1,000 reviews, maybe 1,200 reviews. But don't buy it on Amazon. They'll charge you $25 plus shipping and handling. We only ask that you cover the shipping and handling. We'll eat the cost of the book. It's a real book, folks. It's not just a PDF download. You can get this book for free at lawofselfdefense.com/free book. Make sure, if you're hard to kill, which is very prudent, the first priority has to be to survive the fight, but you want to be not just hard to kill, but also hard to convict. And this book shows you how to do that if you're ever compelled to use force in defense of yourself, your family, or your property. And during this gift-giving season, keep in mind, a beautiful hardcover version of that same book, Law of Self-Defense Principles, looks great on the bookshelf, makes a wonderful, beautiful gift, and it might keep your husband, boyfriend, father, brother out of prison if they're ever compelled to use force in defense of themselves or a loved one. And it makes a wonderful gift. Now, this one's not free because they cost too much to manufacture, but if you'd like to get a copy of this for yourself or as a gift for a loved one, we all have family members. We don't really know what to get them for Christmas, right? This would be a fantastic gift for that purpose. And you can get this hardcover version of the Law of Self-Defense Principles at lawofselfdefense.com/gethard. lawofselfdefense.com/gethard for the hardcover of Law of Self-Defense Principles. And with that out of the way, let me do my quick rehash here. So this is the trial of former Fort Worth police officer Dean Taylor. Let me make sure I have this open and ready to go for sharing the trial stream. Did I say Dean Taylor? This is the trial of Aaron Dean. Aaron Dean, former Fort Worth police officer Aaron Dean, charged with murder in the death of Atatiana Jefferson. Dean happens to be white. Atatiana Jefferson was a 20-year-old black woman. She was babysitting her 8-year-old nephew at home. A neighbor across the street saw that the front doors of her home had been wide open for more than 4 hours, and at roughly 2:30 a.m., that neighbor was concerned enough that he walked across the street, couldn't see anything, but was concerned, went back home, called the police. And the police response was lead officer Aaron Dean and backup officer Carol Darch, female officer, both of them relatively new. They had both graduated the police academy in the same class in early 2018. This event takes place October 12th, 2019. Carol Darch had actually been delayed in being commissioned as a police officer because she'd broken her foot. She'd only been on the job for 3 weeks at the time of this event. Aaron Dean had perhaps a year on her, but pretty spanking brand new. The case is being tried in the courtroom of Judge George Gallagher, who looks to be a damn good judge. No drama in this courtroom so far. Everything moves very, very, very efficiently, timely. No overreach by either state prosecutors or defense counsel. And I believe that's because they know this is a no-nonsense judge, and they're not even going to try to sneak anything by him. So no Binger-esque type of drama here. Very, very well, efficiently run courtroom by Judge George Gallagher. It's very impressive. He's doing a great job. Mostly you don't notice him. That's how smoothly things are running, and that's a great sign. So the prosecutors are a female and a male. The lead prosecutor so far has been Ashley Diener. She's supported by prosecutor Dale Smith. On the defense, we have two prosecutors. Mostly we've been seeing attorney Miles Brissette, Brissette. He's been doing a very good job. And he's accompanied by attorney Bob Gill. Both of them are relatively new to this case. They were brought on board just this past summer because the initial lead counsel on the case, lead defense counsel, Jim Lane, died. He died last week. In fact, the first day of the trial on Monday, they only had a half day of trial because everybody went to his funeral Monday afternoon. So they're relatively new to the case, but they've been doing a great job so far. It's helpful for the defense, of course, that the law and evidence appears to be soundly on their side. Dean Taylor is, Aaron Dean, the defendant, is charged with murder in this case. His defense is self-defense. When he arrived at the scene, this was treated as an open structure call, which is essentially a silent alarm or burglary in progress call. You're not supposed to announce when you arrive at the scene, according to standard procedures of the Fort Worth Police Department. until you assess what's going on. So they had begun their assessment. They were at the house for about 1 minute, 57 seconds, working their way around the outside of the house. Darch, who testified yesterday, would describe the house as apparently the subject of a burglary, ransacked, was her impression. They're going around the outside of the house. This is 2:30 a.m. with flashlights. They get by a window. They shine the flashlight, Aaron Dean does, into the window. On the other side of the glass inside the home is Atatiana Jefferson. She raises a gun at Aaron Dean. He says, "Show me your hands." She raises the gun. He shoots her, fires once, strikes her in the heart, immediately mortal wound. So he's charged with murder in this case. Legal defense is self-defense. It seems a pretty sound legal defense to me. He was not acting unlawfully. He was facing an imminent threat. The threat was deadly force in nature. His conduct, his perceptions were according to police department policy. He hadn't violated anything in any substantive way. And all this went down pretty quick, 1 minute, 57 seconds, really less than that. From the time they approached the house to the time the shot is fired, more like 1 minute, 30 seconds, probably. I'll have to double check that. All happens pretty quickly. Now, a lesser included charge of murder, which of course is an intentional, unjustified killing, is reckless manslaughter. So that'll be on the table for the jury as well, I expect, unless for some reason the state wouldn't want it, I guess. Reckless manslaughter, a killing done in a reckless manner. Recklessness being the unjustified creation of a risk of death, or the creation of an unjustified risk of death, and then death results. The Alec Baldwin situation where he shot Helena Hutchins comes to mind. He pointed a real gun at her without first ensuring it wasn't loaded. The gun discharged and killed her. The pointing of a real gun at someone without ensuring it's not loaded is inherently reckless conduct. Here we don't appear to have reckless because no procedures were violated. Everything he did was according to the book. So I think it would be very difficult for the state to prove recklessness beyond a reasonable doubt here. Of course, the state would also have to disprove self-defense beyond a reasonable doubt, which also seems unlikely for the reasons I've already put forth. Now, the jury is 14 people. That's 12 jurors will be final jurors deliberating, and 2 alternates. Of course, the alternates don't know who they are yet. It's 8 men, 6 women. It's described as no black jurors, but it's not described as all white, so I presume it may be a mix of white, Hispanic, Asian, who knows. And it's not surprising that you wouldn't have black people on a jury in this county, Tarrant County, in Texas. This all happened in the Fort Worth area. So let's take a look at my notes and see if we can get through those quickly. This is the notes from Monday and Tuesday, so 2 days ago and yesterday. Let's see. So the first day of the trial, we had an whoops, I mean, we may be starting. I may have to do, well, the courtroom camera is live, but not much is happening yet. So I'll continue with this review. So the first day of the trial on Monday, it started with a change of venue argument. The defense wants the venue changed. There are protests outside the courtroom of the usual sort. Lee Merritt, a Benjamin Crump type, is the family lawyer for the victim here. And so we've had the usual protest, outrage, and so forth. Unfortunately, white cop, black suspect, female suspect, it becomes a racially energized case. Ought not be. There's no evidence of racism here at all, of course, as is invariably the case. But there it is. That's what we have. So the defense wanted a change in venue, and it was denied by the judge. This argument for change of venue has been made multiple times. We've even had a change of judge in the case, by the way. Gallagher, who's the judge now, only came on relatively recently in the last few months. The judge that had been in charge of the case was removed from the case because of allegations of bias against the defendant and his defense team. So there's been a little bit of drama in the background. There was also a discussion about excluding from evidence the toxicology results for the victim. Apparently, she had some kind of tox levels, but they probably ought not be relevant to the facts of this case. So it looks like they will not be admitted. The jury was seated. The indictment was read. That's just the murder charge. And then we had the opening statements. The state opening by prosecutor Ashley Diener was very emotive and very light on actual law and evidence. She basically just summarily, after a lot of emotional talk, told the jury, hey, we're going to prove murder, that it wasn't self-defense. Okay, there was no argument to support that, but That's what she tells the jury she's going to do. The defense opening by defense attorney Miles Brissett was much more substantive. It was kind of casual in demeanor. He was kind of standing with his hands in his pockets, but he focused much more on law and evidence. He stepped through the fact that Dean, the defendant here, was the primary officer. Darch was backup. It was a priority 2 call, which is a relatively high level of call. The only level higher is priority 1. That's where there's an imminent danger to life. It's a lights and sirens call. People are standing up. Looks like maybe the judge came in. This was for an open structure call. That's a technical term of art for the police. That's what the neighbor called about, of course. They looked across the street. They saw an open structure. Okay. It looks like the courtroom is still muted. The judge is seated. A little bit of discussion, a little bit of banter going back and forth. So open structure call is treated like a burglary in progress, a silent alarm call. The police are not supposed to announce when they arrive. That's the policy until they assess the situation. It's risky enough that it's mandated that 2 officers, 2 patrol cars are on the scene. That's why Darch was there as well as the defendant, Aaron Dean. They had begun to search around the structure when Dean looked in the window, saw the gun being raised at him, and that's when he fired the fatal shot. So quite good defense opening statements. And then we had after the opening, we had the first witness, which was Zion Carr, currently 11 years old, 8 years old at the time. He was a child that was being babysat by the victim in this case. He was an eyewitness to the shooting. Now, notably, in his direct examination by the state, he testified on the stand that his aunt, the victim here, kept the gun by her side, did not point it at the window, and he was not able to identify what was on the other side of the window. This is contrary to every prior statement he's made about this case, including a videotaped interview he did 2 hours after the shooting, in which he explicitly says that his aunt did point the gun at the window and that he could see a badge on the other side of the window. So this was noted explicitly by the state as they had to state openly to the judge that this was inconsistent with all his prior statements. That's required by Brady. Brady is a Supreme Court decision that says that if the state comes across exculpatory evidence that's helpful to the defense, they're obliged to point it out. And they did that following Carr's direct testimony. Cross-examination by the 11-year-old was pretty mild, as you might imagine. And that was really the end of the day. Then the court recessed on Monday, and everybody got to go to Jim Lane's funeral, the initial lead defense counsel for this case. Then we got to day 2 of the trial, which was yesterday. There we were shown initially the videotape interview of then 8-year-old Zion Carr, only 2 hours after the event, where he tells the social worker or whoever it was that his aunt did, in fact, point the gun directly at the window, and that he could see that there was a badge on the other side of the window. So that's the prior inconsistent statement, much more credible 2 hours after the event than this in-court statement on Monday, 3 years after the event. He also rather incredibly told the court on cross that he hasn't discussed his testimony with anybody, which seems unlikely because his family is suing the police department, the city, the officer for many millions of dollars. And it seems likely that their civil attorney would have discussed the case with the only surviving eyewitness to the event other than the people being sued. But there you go. He is an 11-year-old child. Then we heard testimony. A large bulk of the day yesterday was testimony from police officer Carol Darch. She was the backup officer to the defendant at the scene. Her direct examination was 2 hours and 20 minutes, and then there would be a redirect of another 20 minutes. So 2 hours and 40 minutes on direct and redirect by the state of their witness, Carol Darch, police officer Carol Darch. I've already covered her a little bit. She was a brand new officer, 3 weeks on the job, had been a waitress before, went through the same academy class as Aaron Darch. Her testimony was, even on direct by the state, was completely favorable to the defense. There was no substantive violation in policy. They were in the process of doing policy when ultimately the shot was fired. Her perception was that the home was the scene of a burglary, had been ransacked. She affirmed that it was an open structure call, which means you treat it as a burglary in progress. You don't announce, that's not the policy in those cases until you've evaluated what's going on. If it's a burglary, she explicitly said, and that's what it looked like to her, and that's what an open structure call is typically treated as, you don't want them to know you're there until you've had a chance to evaluate, maybe secure exits and all that kind of stuff. It was not a wellness check, a welfare check, which is what the media has been reporting this on. Then you would just go up and knock on the door and say, hey, is everybody all right? It's treated quite differently when it's an open structure, AKA burglary in progress, AKA silent alarm kind of case. And much of this came out again in cross-examination, as well as some other matters. They asked her about no-shoot training at the academy, having to defend yourself against suddenly appearing or presenting deadly targets, that you can skip your less than lethal tools on your belt. If you're faced with imminent deadly force, you can go right to deadly force. There was more on cross about why she perceived the scene as having been that of a burglary. The fact that there was not much room to maneuver for Aaron Dean when he fired the shot. Darch was directly behind her. There were obstacles to either side. She could not see the gun in the victim's hand. She just saw the victim's eyes through the window. The officer did not, Aaron Dean did not shout gun. He did give a command to raise hands. It's worth noting, of course, he's not required to shout gun, especially when he has only a second to respond to an imminent deadly force threat. But the fact is that he didn't. The prosecution likes to talk about that, and they brought that out here. Now, it is also noteworthy that as young as she is, and I believe she's about 24 years old, Officer Carol Darch had a couple strokes the year after this event, and those strokes have caused memory loss for her. So things may have been said or may have been done at the scene that she just doesn't remember. In fact, there's an entire post-event interview she did with the equivalent of Internal Affairs that she has no recollection of at all. So that was, let's see. Okay, looks like we're going live.
Several lawyers, okay?
Yes, sir.
Statement, please.
Good morning, how are you?
I'm doing well. How are you?
Good. We're just about going to have a brief hearing today, okay, to talk a little bit about your training experience as it pertains to the Leica scan, okay?
Yes, ma'am.
All right. So we know you're a crime scene officer. How long have you been a crime scene officer, sir?
5 years.
And have you gone through training with the Fort Worth Police Department for crime scene?
Yes, ma'am.
When was that, sir?
That was from December of 2017 through March of 2018.
Okay. And so in the 5 years, have you been in crime scene the whole time?
Yes, ma'am.
All right. And so how long have you been a Fort Worth police officer?
Close to 8 years.
So tell me about that. There is a particular type of technology with the Leica scan. I'm going to call it a Leica scanner. Is that the right verbiage?
Yes, ma'am.
What would you call it?
A Leica scanner.
All right. So tell the judge what a Leica scanner is.
So a Leica scanner is a 3D imaging device that utilizes a laser and a panoramic camera to create a 3D model of the crime scene.
How is a Leica scanner done at a crime scene?
So in this particular case, we used the Leica PS40. And at each station where we would elect to collect a scan, we would set up the device, let it run. The device spins in a circle, shooting a laser out over 1 million times a second, and collects individual points in space. Those points come together to form a point cloud, which is essentially a bunch of dots in space that create a 3D world. Once the scan is complete, we remove the scanner from the tripod, place our panoramic camera on top, and take a panoramic image from the exact same spot that the scanner took its scan. We can then overlay that image onto the scan world to give us the 3D walkthrough of the scene.
And when you are taking these scans at the scene, you're there at the scene, correct?
Yes, ma'am.
So you were able to testify also that the Leica scanner and what you see from those images does appear to be what you saw out there at the scene.
Yes, ma'am.
Things are where they are on the scanner, just as you remember it at the scene.
Yes, ma'am.
Now, are you going to be testifying about any measurements regarding the Leica scanner?
No, ma'am.
And are you going to be testifying about any measurements at all?
No, ma'am.
All right. And have you been trained in how to operate the Leica scanner?
Yes, ma'am.
Tell us about that.
So after the initial crime scene training period, I had an additional 2 weeks specific to the Leica scanner, put on by another crime scene officer. And then throughout the following year, as you are on probation in the crime scene unit, you are continuously evaluated on all of your work, and in my case, the scanner was included.
And have you testified before the area of crime scene?
Yes, ma'am.
Have you testified with the Leica scanner before?
No, ma'am.
Has the Leica scanner and that technology been utilized in district courts before?
Yes, ma'am.
All right.
Presumably, he's going to give dimensions of where the victim was located and so forth.
I'm going to pass a witness for purpose of this hearing.
That's it.
Van Gorkum, sir.
Van Gorkum, my apologies.
Yes, sir.
Rosette's kind of hard to say sometimes, too. You were trained by a fellow crime scene officer on the Leica, is that my understanding what you just said?
Yes, sir.
What's the error rate on the point cloud when it starts doing the million points per second?
At 50 meters, it's accurate to within 3 millimeters.
How do you calibrate it each time? Because it's, if I understand the system, there's a tripod that you have to set, and you have to level it.
Yes, sir.
How do you go about leveling it?
So there are leveling bubbles for a general to get you close, and then the device itself has a level built into it that you actually calibrate on the device each time you put it in a new location.
So let's break that down then. The tripod has what I would call an analog bubble level.
Yes, sir.
3 of them, it sounds like?
Just one.
Just one. So we're only doing one dimension, not X and Y, when we're doing the level. I know it's a tripod, but we've still got 2 directions, X and Y.
It is a spherical bubble level, so it actually calibrates both of those.
Okay, so it's like a round 1-inch bubble?
Yes, sir.
You know what the error rate on that is?
No, sir.
When you mount this Leica device on top of the tripod, how do you go about calibrating it to say this is level, or does it adjust its own level? Does it have mechanisms or gyros that get it level?
So this particular scanner does not. It is we manually have to do it. There is an LCD screen that gives us a readout, and it's essentially like lining up crosshairs.
What is the error rate on your ability to line that up and get it actually level?
I don't know, sir.
Would that be part of the training materials from Leica?
I don't know, sir.
When you were in your 2-week training, did you have training materials actually produced by Leica to be proficient in this gear?
There is a training manual in the office, sir. It was not specifically given to me in the training. It is available.
What was given to you for the 2-week training?
It was mostly scenario-based training, step-by-step instruction, field training.
Sure. You've done it in an office setting. I imagine you probably scanned crime scenes office more than once in your training there.
Yes, sir.
After you unhook, is it a 1/4-20 traditional tripod mount for this device, or is it bolt on some way different?
It is a completely unique tripod mounting system.
When you mount the camera on it, tell us who makes the camera?
It's an NC Tech. It's an iStar camera.
You're gonna have to help Lisa with that. How you spell it?
So NC Tech, TECH, and then iStar, like lowercase I, STAR.
And what kind of output does the iStar make?
It's a panoramic image.
Okay, what format does it come out in?
I'm not sure, sir.
If you're not sure the format it comes out in, how do you validate that it's accurately been recorded?
I view the image, sir, and if it is what I saw on scene,
Is there a hash value that is provided with the file as it comes off the system?
I'm not sure, sir.
Do you know what a hash value is for digital photographs or digital evidence?
No, sir.
You've been in a crime scene for 8 years, and you deal with digital evidence on a regular basis?
5 years, sir, but yes.
Have you had, it was 5 years at the time, so 3
2 years at the time.
And when were you trained on the Leica before this event in October of 2019?
March of 2018.
If I were to, there are different ways to ensure that data, electronic data, if we have it in one file is moved over to another folder, there's algorithms to check if the whole file comes over. Much like an evidence.com body-worn camera transfer where it gives you the hash value. It's a series of numbers and letters that says this is what it was when it came off the camera. If it matches over here on the Fort Worth PD server, you have exactly all the bits. Do you see any type of hash values for the stuff you did in this case?
I never saw it, sir.
Once you upload it to the server, when you get back to the office, who handles the point cloud from there?
I did, sir.
So how do you validate everything you got off of, I guess it's a SD card?
It is, it was transferred directly from the memory on board the scanner, sir.
What type of memory is on board the scanner?
I don't know, sir.
How is that memory prepared before each scan?
We create a subfolder on the scanner with which all the data from that site is added.
And where I'm going with that type of stuff is memory, like on your Canon camera, we're still a Canon camera shop for crime scene photos, yes?
Yes, sir.
So where I'm asking on that question is, do you format the hard drive like you have to format a memory card for your camera before each use, so we know that only the data from that is in there and there's no corruption since we don't have a hash value?
No, sir, we don't do that.
How did you go about transferring the data from the hard drive on the device to your computer or server at the police department?
It is an Ethernet transfer, so plug into the back of the computer, plug into the device, and it transfers directly from the device onto the desktop.
What about this star camera? How does that data get to your computer?
That is an SD card, sir.
And I think I asked this, but we don't know if there's a hash value for those either.
Correct, sir.
And we don't know if it comes in JPEG, PNG, or RAW, correct?
Correct, sir.
Hang on, what's that noise? Oh, okay. Well, that's fine. Is that noise, never mind, okay. Go ahead, Mr. Burchett.
Thank you, Your Honor.
Very nitpicky details here by the defense, wondering where they're going.
Stored on the crime scene secure server, are there any validation or verification methods inside the City of Fort Worth Police Department to ensure that the files there and it's not compressed by Fort Worth IT Solutions?
I don't know that, sir.
Do you know what the security measures are around the file when it's stored on your server?
I know only specific people have access to the server where the file is stored.
Are there audit trails for the software that you have to use to process this, so we can see a complete audit trail as to who's worked and what work has been done on this point cloud? Or
The audio comes across fine on my computer, folks,
and because we don't know for sure.
when I take my earbuds out.
Audit trails, because you're doing forensic expert work at this point, those are traditionally turned over in discovery. Did you prepare any audit trails for the software you use to process this exhibit?
No, sir, I did not.
What software, make, model, and version did you use to process this exhibit?
I used a software called Leica, or I'm sorry, Cyclone. I do not know the model, sir.
So we don't, it's Cyclone, is it just called Cyclone?
Yes, sir.
We don't know what version or rev number of the software it is?
Correct, sir.
And what kind of file does it output?
I don't know the file type, sir. It is a unique file type.
Well, you're gonna offer an exhibit, I would assume, in front of the jury, correct?
Yes, sir.
And does that have this unique file type that you don't know on it?
Yes, sir.
How does that unique file type that you don't know on the DVD play?
So the file type put out by Cyclone, the scan data, I don't know that file type. The exhibit I will be presenting is a TrueView, and that is the file type, is a TrueView application.
So how does it get from Cyclone to TrueView?
So So once all the scan data is input into Cyclone, it is optimized using their software. It does give an error rate. I do not know what that is. All, in this case, 15 individual scans are combined into a single scan world. And then the panoramic images are meshed on top of that scan world. Once that is done, we can export it as a true view. It's like saving as a different type of file almost, but you are creating a publishable item.
Officer, you used a new term that we had talked about before, mesh. Can you explain that?
We overlay the panoramic image over the individual point clouds.
Kind of like a layering effect?
Similar, yes, sir.
Similar like Photoshop layering then?
I'm not familiar with Photoshop, sir.
Well, not very impressive.
And the trainer aspect that you talked about with the prosecutor, do you know if the trainer who trained you was certified by Leica to operate this equipment?
I don't know, sir.
Have you ever taken any proficiency tests with Leica to operate their equipment?
No, sir.
They offer a certification program, do they not?
I don't know, sir.
Cyclone software, have you received any specialized training from the manufacturer of Cyclone software to use their software?
No, sir.
I assume then you haven't taken any proficiency tests in Cyclone software.
That is correct.
And is Cyclone software that optimizes with an error rate that we don't know about?
Correct, sir.
And that outputs a TrueView file. Is TrueView a software program or is it a file type only?
Both, sir.
Have you had any training in TrueView?
Yes, sir.
Is that trainer training as well?
Yes, sir.
No specialized crime scene classes around the country or anything like that?
Correct, sir.
No in-service at Fort Worth?
Correct, sir.
Thank you, Your Honor. Pass the witness.
Free, correct?
No, I do not have anything further for him.
Any objection?
Yes.
Go.
State has not met the prongs of Daubert for forensic science evidence. At this point, we object to admission of any exhibit that they can offer in their system.
That objection's overruled, and we have a running objection.
Can we identify the number too as well, Judge?
Is this gonna be, State's Exhibit 3?
It's gonna be State's Exhibit 3, yes, Your Honor.
Okay, your objection to State's Exhibit 3 is, overruled, and you may have a running objection to State's Exhibit 3.
Thank you, Your Honor.
Both sides ready for the jury?
State's ready.
Defense is ready.
Let's go.
Yeah, very no-nonsense judge. So he's going to allow this witness to be presented as an expert. Of course, the defense can bring up all this lack of training, lack of knowledge about the software on cross-examination, and I expect they will. I'll try a different feed, folks. See if we can't get something better. Whoops.
Everyone may be seated.
Sidebar. So they muted the mic, muted the audio. She likes that necklace, that prosecutor.
Ladies and gentlemen, this witness has been previously sworn to testify truthfully. Ms. Diener.
The state morning.
Good morning.
How are you?
I'm doing well. How are you?
Good, thank you. Turn to the jury, introduce yourself, please.
Good morning. My name is James Van Gorkum. I'm a police officer at the Fort Worth Police Department, currently assigned to the Crime Scene Search Unit.
How long have you been a police officer with Fort Worth?
8 years.
What'd you do before you were with Fort Worth?
I was a student and I worked at Target.
Okay, all right. And so your time with Fort Worth for the last 8 years, tell me about what particular divisions you've been assigned to.
I was assigned to the Patrol Division and Central Division, and then Crime Scene.
And what made you want to go from patrol to crime scene?
I was always interested in that kind of work. I feel like I'm more technically inclined, and the level of detail, things like that, appealed to me.
Do you like it?
Yes, ma'am.
Okay. And so how long did you say you'd been in the crime scene unit at this point?
At this point or right now?
At this point in the present?
5
Right.
years.
Okay. And so back in October of 2019, how long had you been in crime scene?
Just under 2 years.
All right. And so tell us about the additional training that you have to go through in order to be in the crime scene unit.
So once you are accepted into the Crime Scene Unit, you go through a 4-month field training program with several different crime scene officers. It ranges from scenario-based or lab-based training all the way to just observational training. You work the call while your trainer observes, and if they see things that need to be addressed, they address them. It culminates in what we call a ghost phase, where your trainer is purely an observer, and at the end of your work offers corrections or additional advice, things that you can change. Once I completed that, I did an additional 2 weeks of field training with the Leica 3D scanner.
What is the Leica 3D scanner?
The Leica 3D scanner is a digital imaging device that uses a panoramic camera and a laser to create points in space and a 3D model of the scene or wherever we are scanning.
Does it have the capability to measure certain locations from one point to another?
Yes, ma'am.
For purposes of today and what was done in this case, did you do any measurements, or did the Leica scanner do any measurements?
No, ma'am.
Did it purely just scan the crime scene?
Yes, ma'am.
All right. And did you actually go out to the crime scene off 1203 East Allen Avenue?
Yes, ma'am.
What day did you go out there, sir?
That was October 12th, ma'am.
And 1203 East Allen Avenue, what city is that in?
Fort Worth.
Is that in Tarrant County, Texas, sir?
Yes, ma'am.
About what time did you get called out to the crime scene?
I was dispatched at about 5 a.m. and arrived on scene shortly after.
And when you got there, were there other officers still there?
Yes, ma'am.
Were there other crime scene officers there?
Yes, ma'am.
Okay, do you remember what other crime scene officers were there?
Yes, ma'am. It was Crime Scene Officer Valderas and Crime Scene Officer Bain.
Do you know what their purpose for being there? What were they doing?
They were the primary crime scene investigators, ma'am.
So why were you called to the scene in addition to them?
Purely to collect scan data for the scene.
And so tell us how you actually do that. How do you do a scan and set it up?
So the Leica scanner utilizes a laser that shoots over 1 million times a second and creates individual points in space. Those points come together to form a cloud, which the cloud itself forms a 3D model of the scene. The way we accomplish that is at various locations within the scene, we will set up a tripod with the scanner on top. Once the scanner is running, it spins in a circle, shooting that laser out millions of times and creates the 3D model space. Once that is collected, the scanner is removed from the tripod and our panoramic camera is placed on top without moving tripod or anything, and a panoramic image is collected from the exact same location.
And so does it allow for it to be, basically kind of bring the jury into the crime scene as much as we can?
Yes, ma'am.
And has the Leica scanner and this technology been used before in other district courts?
Yes, ma'am.
And have you testified before as a crime scene officer?
Yes, ma'am.
Few or many occasions, sir?
A fair amount, ma'am.
Okay, all right. May I approach the witness, Your Honor?
Yes, ma'am.
I have a hand here that's been pre-marked as State's Exhibit 3. Does that appear to be a disc that contains the Leica scan for this particular case?
Yes, ma'am.
And did you and I meet and have an opportunity to go over what the actual scan was and look at the photographs?
Yes, ma'am.
And did that appear to be a fair and accurate depiction of the crime scene that you remember, as well as the Leica scan that you did?
Yes, ma'am.
Your Honor, we'd offer State's Exhibit 3, and this has been previously provided to defense as well.
Any objections other than those previously stated?
No further objections, just guidance on the court on how we're gonna publish on the disc.
Well, and Your Honor, we've transferred it over to the desktop for purposes of this publishing to the jury.
I renew my objections to what's being displayed under the hash theory that covered in here.
Those objections remain overruled and State's Exhibit 3 is admitted.
Thank you, Your Honor. I'm now going to show you State's Exhibit 20 through 23, and then State's Exhibit 28 in order to 68. And if you'll just look at those for me.
The officer quit 2 days after the event because he was charged with murder 2 days after the event. I'm sure he wasn't given a choice. It's not a minor circumstance when they get an open structure call. It's considered a burglary in progress. That's among the most serious calls. So serious it requires 2 officers to respond. So serious that their policy is not to announce until they determine what's going on at the scene. I have the same booster all the other YouTubers have, folks, and it's cranked up to 600%. So
Do all those exhibits appear to be a fair and accurate depiction of the crime scene as you remember it from that night?
Yes, ma'am.
And Your Honor, for purpose of the record, it's 20, 21.
this is the WFAA feed,
and then
folks.
28 through 68, all in order. I'm going to offer all of those exhibits, and these have also all been provided to defense.
Your Honor, I understand they've given us discovery, but I haven't seen them marked. Can I look at them?
Absolutely.
And that you can not like the policy all you want, but that's not criminal liability for the officer. Change the department policy. Maybe the department will.
Your Honor, for purposes of the record, States Exhibit 20 and 21 and 22 is already in evidence, already been admitted.
I have 22 admitted, but I don't have 21 or 23.
Oh, okay. So just 22, that's what the gap is between 20, 21, and 23.
Correct.
Okay.
There are reasons why the police don't announce, why the policy is don't announce at a burglary in progress call. Maybe if you give it some thought, maybe you can think of a few reasons why they wouldn't want to announce.
May I take this on witness on Rhode Island, Your Honor?
Yes, sir.
May I approach?
Yes.
Hit that thumbs like up on YouTube, folks, and hit that plussy on Rumble. Please. Nobody's here to waste their time.
Your eyes will get there one day. Looking at state 63 and 67, you didn't take these photos, did you?
That is correct, sir.
These are Valderos's crime scene photos, but you were out there, correct?
Yes, sir.
States 63 and 67, do you know at the time that former officer Dean discharged the weapon if the interior lights are on
I do.
in the residence in the room of issue?
I do not know, sir.
So 63 and 67 may not be a fair and accurate depiction at the time of the event. All these photos are post the time of the event, correct?
Yes, sir. It's fair and accurate to when I was on scene.
Okay. Judge, we don't have any further objection to this fact.
All right, so states exhibits 20 and 21, and 23, and then 28 through 68 are the,
It's okay. I'm gonna, permission to publish those? You
yes, yes, ma'am. Middle sweep.
Okay, so Tiffany, they're just basically trying to enter evidence in, right? I mean, this is kind of
Yeah.
the normal stuff.
Oh, good heavens.
Pretty mundane, but not very exciting.
But it's the important stuff. It
but
has
it
to
is.
happen.
Yeah, so they had a hearing outside the presence of the jury where they were trying to enter in their expert as an expert so that they could get certain evidence in.
Well, WFFA has commentary. That's
Okay,
how
hold on.
awesome.
Start back
States
up.
Exhibit 20, we're looking at the front, the outside of 1203 East Allen, correct?
Yes, ma'am.
And we can see in States Exhibit 20, there appears to be, and I'm just going to use a laser for purpose of the record, crime scene tape around the very front, and then we also see there appears to be a white car, is that right, in the driveway?
Yes, ma'am.
Okay. And now States Exhibit 21, what is this?
Oh, that's
This is
nice.
looking down
Okay.
the western edge of the home.
So if you were walking up to this house, coming from that red building, walking across, you look to the left, if you're looking at the house, you're gonna see that there's a fence in the backyard, is that right? At least to the side,
Yes, ma'am.
okay. And States Exhibit 22, what is this?
A photograph looking at the eastern side of the house.
And now coming into view, there appears to be a darker vehicle that's also parked in that driveway, is that right?
Yes, ma'am.
And for purposes of the record, in States Exhibit 22, the white car and then the darker colored car that's parked in the driveway, are they actually facing each other? Which would be nose to nose. There's space between, but they're facing each other. Is that right?
Yes, ma'am.
Okay. And now what are we looking at in States Exhibit 23?
So this is the open lot to the east of the residence.
Is it quite a bit of space to the right or the east of 1203 East Allen?
Yes, ma'am.
Now where are we in States Exhibit 28?
We are standing inside of corner of the home.
And State's Exhibit 32.
We are along the northern wall of that bedroom, standing over the deceased.
Why is it important to take photographs and in your case, take the Leica scan of the positioning of the body of the deceased?
Our primary duty is the documentation of the scene as we see it, so photographs are a major component of that, and the scan is becoming
Well, the coffer is back.
imperative too. Sometimes positionings of bodies and things can indicate certain things. I'm not sure in this case if it was.
And are you given a pretty small amount of information when you go out to a scene?
Yes, ma'am.
And so you're just taking photographs of everything you possibly can. And from a crime scene perspective, when photographs are taken, they're just trying to take as many photographs as they can, not knowing yet what may be important later.
Correct.
Okay. All right, State's Exhibit 33 is just a different view of some items that were by Tatiana's body.
Yes, ma'am.
And 34, tell us what that yellow thing is right there that says number 2 on it.
That is a number placard. It is an evidence marker.
And now State's Exhibit 35, what is that?
The deceased's face.
State's Exhibit 36, what is that?
The deceased's right shoulder and chest.
State's Exhibit 37, what is that?
The deceased's left side.
And State's Exhibit 38. Now we see the left side as well as some additional numbers, those placards 3 and 4. What is the purpose of those 3 and 4?
There are additional evidence markers.
And State's Exhibit 39, is that her left hand?
Yes, ma'am.
State's Exhibit 40, what is that?
It is another shot of her left hand.
And State's Exhibit 41, is that now a photograph of her right hand, or right arm rather?
Yes, ma'am.
Okay. 42, right hand,
Yes, ma'am.
and 43 on the top of her right hand, correct?
Yes, ma'am.
44, what are we looking at?
We are standing in the living room looking at the front doors to the residence.
This is all foundation so they can publish these photos to the jury.
It is a photograph of a firearm on top of a box. Oh, I'm sorry. It is a photograph of a firearm sitting on top of a box by the front door.
State's Exhibit 46.
It is a close-up photograph of that same firearm.
47.
Another angle of that firearm.
I'm going to go back just for a second. So 45, and then we zoom in a little bit closer, 46 and 47. Why is it important to take photographs of the various different parts of the gun?
We need more than 50%
We tried to
likes on
document
YouTube,
the
folks.
state of the firearm.
There's 600 of you
When it
here,
was
300
recovered,
likes. Hit that
was
like
it
button.
Loaded, was it even capable of firing to the extent of our knowledge? That's the primary reason. And also for documentation so we can identify it later.
Okay. Are there unique identifiers on guns that can help us identify them later?
Yes, ma'am.
What is that?
A serial number.
And State's Exhibit 48, what's that?
That is a close-up photograph of an attachment at the front end of the firearm.
And 49, is that just the other side of the firearm?
Yes, ma'am.
And now on State's Exhibit 48, I can see that there appears to be an unfired cartridge right here. Was that found with the gun, to your knowledge?
I don't know, ma'am.
Okay. But photographs were taken of it that were at least close to, or looks like right on the gun.
Correct.
Okay. State's Exhibit 50, what are we looking at?
This is the front or south-facing door.
51, what is that?
The door frame of that same door.
Why is it important for crime scene officers to document the condition of doors and door frames for offenses?
It allows us to document whether there were obvious signs of forced entry.
Was there any obvious signs of forced entry?
No, ma'am.
State's Exhibit 52, now we can kind of see that white car a little bit more. Tell me what we're looking at here.
So this is the carport on the eastern side of the residence. We're looking towards the detached garage in the backyard.
This object that we see here, State's Exhibit 52, I'm going to circle kind of to the middle bottom. What is that?
It looks like lawn equipment, weed eater.
And does the lawn equipment or the weed eater, does it also have a cord that appears to be coming from it?
Yes, ma'am.
Okay. And now, looking here on State's Exhibit 53, where are we?
We are standing on the carport still, looking at the second door, which would be on the eastern side of the residence.
54.
Inside of the living room, looking at that same door.
Were there any obvious signs of damage or tampering to the side door, from what you can tell?
No, ma'am.
55. Where
Stand-
are we here?
Standing near the white car, looking to the north towards the detached garage.
And 56, is that just another view of that darker car towards the house from the empty lot?
Yes, ma'am.
57, just another view of the car, that second darker car, is that right?
Yes, ma'am.
All right, 58, what are we looking at?
So we are looking at the area between the dark colored car and the edge of the house.
I want to go back just 1 second to ask you about, are you able to see, and if you can't, that's all right, but we see that there's a weed eater of some sort. Can you tell what this item is behind the chair?
I don't know, ma'am.
That's okay. All right. So keeping on the right side of the house, now we go into State's Exhibit 59. What are we looking at here?
So we are standing at the front of the detached garage, looking to the west into the backyard through the gate.
And is the gate open?
Yes, ma'am.
And there appears to be an orange cone. Why is there an orange cone there?
Orange cones are sometimes used to mark evidence before a crime scene arrives so that it isn't overlooked or forgotten about before we can mark it.
And State's Exhibit 60, is this just now looking the other direction? Better picture of the bike just to the right of that darker colored car.
Yes, ma'am.
State's Exhibit 61, a view of the outside looking into the backyard with the gate open. Can you tell which way that gate opens? Does it open towards you or going a different direction?
It opens outward, so towards the camera in this photo.
I mean, the coughing's just unbelievable.
62, where are we now?
So we are standing in the backyard looking at the northern side of the home.
The victim had a concealed carry permit, according to media
Let me
reports.
go back just a second. On 61, if, as the crime scene officer, I believe Valderas, you said, if he's standing right here outside of the gate is open at this point, are you able to see on State's Exhibit 61, the very top of this window, if you were standing outside of the gate?
It appears so, ma'am.
And the gate's the same height all the way across, so even if that door is shut, this gate door is shut, you can still see the top of that window, is that right?
Yes, ma'am.
All right, and State's Exhibit 63 and 62, a backyard picture facing those windows, and State's Exhibit 63, does that just appear to be with no light, no flash?
Yes, ma'am.
64, now we see there's the cone, but there's also a number 5 placard. What's that for?
That's another evidence marker.
And 65, is that just a closer up view of that number 5 evidence marker?
Yes, ma'am.
What can you see in State's Exhibit 65? What is that item, number 5?
It is a fired cartridge casing.
State's Exhibit 66, is this just a closer up view of that window?
Yes, ma'am.
67, does that give us a better perspective as far as being dark outside, no flash being used?
Correct.
And 68, what is that?
An even closer view of the hole in the window.
And are we able to see in all these last few exhibits, 66, 67, and 68, that the blinds appear to be drawn at least halfway or so inside the bedroom?
Yes, ma'am.
All right. Now, permission to publish State's Exhibit 3, Your Honor?
Yes.
Okay, in the State's Exhibit 3, now this Leica scan of the house, you have a stylus up there just like I do on the screen. Will you start taking us through the crime scene and give the jury a perspective of what it looked like?
Yes, ma'am.
All right. And so we can see there appears to be an object over in the bottom left. What is that?
That is what we call a NIST pole. That is our known standard. So the measurement between those two targets is a calibrated standard, and that helps us calibrate our measurements on the machine.
And so take us around just the exterior and show the jury. So we have a lot of police cars. And now her house comes into view. All right. Now it's daylight outside at this point, correct?
Yes, ma'am.
When you get out there. All right. So take us through the next point. Take us through inside the house.
It sounds like there's multiple coffers.
Now we go inside. We're looking inside the living room. Is that right?
Yes, ma'am.
And take us over to the left a little bit. All right, we come into view. We can see there's, looks like a TV of some sort, kitchen. Okay. And we can see these little red dots that are in the background. What are those for? Red circles.
So each of those red circles represents the location where an individual scan was collected.
All right. Take us to the next area, if you will, or the next, yeah. Okay. Okay, so just a different perspective now looking towards the doors. Taking us down the hallway here in just a second. And let me ask you, yeah, I'll let you, there you go. Going down the hallway of the house, does there appear to be some additional doors or rooms to our left a bit?
Yes, ma'am.
Okay. All right, continue taking us down the hallway. And now looking into Atatiana's bedroom. Let's go into her bedroom. And now inside of her bedroom, there appears to be a TV over there to the right, and then there appears to be like a computer desk over there as well. Is that right?
Yes, ma'am.
And then there's two gray dots out on the window. What is that?
So those are called geotags. Those are inputs that we were able to put into the TrueView that are photographs from the crime scene.
All right. And then take us to those two that are on her body. Okay. And then take us to the next one. And what does that appear to be on placard number 2, sir?
An unfired cartridge.
All right, and so let's go out of her room. And go back into the living room. And let me ask you a question, if you will. Just scan us around into the living room for a second. Now, does that appear to be somewhat of a messy house? Fair to say?
Yes, ma'am.
All right. Have you seen in your time with crime scene and as a patrol officer as well, so 8 years, have you been into houses that have been messy or dirty before?
Yes, ma'am.
Few or many occasions?
Many times.
All right. Have you been into houses that have been ransacked before?
Yes, ma'am.
Okay. Have you in your experiences seen a difference between a messy house and a ransacked house?
That's hard to answer, ma'am.
Okay. Tell me why it's hard to answer.
I have been in houses that I have found out were ransacked that looked messy, and I've also been in houses where that's just how the house was. So
Sure.
it's hard for me to make any kind of conclusive statement on that.
Sure. All right, so take us now outside. And if you will, real quick, let's go back to the right just a little bit. So you can see now, it gives the jury a little bit more perspective. There's this big open lots, and then keep going over to the right just a little bit, and we can see, keep going just a little bit, we can start to see these houses. There's a couple different houses that are across the street, is that right?
Yes, ma'am.
Okay, all right, so take us back, going back to the driveway. Okay, and let's go down the driveway into the backyard. And let me stop you real quick. So right there, this view looking at this white car, are we able to see this object that appears to be to the right of the car?
Yes, ma'am.
What is that?
A lawnmower.
Okay. And so continue on to down the driveway into the backyard. Okay, and turn over a little bit to the left there. Okay. And so now, be able to see here that we've got this gate wide open here, but standing outside the backyard, you see the top of the window. Is that right?
Yes, ma'am.
Okay, so take us in the backyard. Okay. Now, go over in front of the window. There appears to be two objects on the ground, and then there's also a placard for evidence. What are those two objects? Can you tell?
I believe they are gloves.
Okay. And now click on the object that we see that's marked with the crime scene placard. Does that appear to be that fired casing that we've seen earlier?
Yes, ma'am.
And will you click on the 2 points that we see on the window? And that's that photograph we've seen earlier,
Yes, ma'am.
and that's just a different view a little further away of that window. Is that right?
Yes, ma'am.
All right, all right. So when you went out to the crime scene and you did all of these scans, what is the next thing that you did after you completed all the scans?
So once we are done collecting scan data at the scene, we transport all the equipment back to the office, and then I transfer from the device onto our desktop computer at the office, all of the scan data that was collected, and input that into a program called Cyclone.
And then at some point, is that file given over to our office so that we can see it?
Yes, ma'am.
Okay, all right. May I approach the witness, Your Honor?
Yes, ma'am.
And then that's pretty much all you had to do in this case, correct?
Correct.
Okay. Now, did I ask you to bring evidence with you yesterday in this case?
Yes, ma'am.
I'm going to show you what's been pre-marked as State's Exhibit 111, State's Exhibit 113, State's Exhibit 96, State's Exhibit 106. So let's start with 113 and 111. On 111, does that appear to be, well, all of these exhibits, but 111, does that appear to be one of the envelopes that you brought with you yesterday?
Yes, ma'am.
And where did you get State's Exhibit 106, 96, 113, and 111?
It was checked out from the property room.
Okay, explain to us what the property room is.
So the property room is the designated evidence storage area for the city of Fort Worth. It is a secure location that allows us to maintain a chain of custody over a long period of time of evidence items. They are the custodial entity for evidence in Fort Worth.
Who has access to the property room?
To the evidence storage area of the property room,
Correct, where the evidence is kept.
only staff for the property room.
Okay. And so whenever you went to get those items, did you have to check those items out and sign for those?
Yes, ma'am.
And whenever you brought them here to the court, did we then go through and open each one of those items of evidence?
Yes, ma'am.
Are there items inside of those boxes and envelopes?
Yes, ma'am.
Did all of those items, including the boxes, do they today appear to be in the same or substantially similar condition as when you brought them yesterday?
Yes, ma'am.
And did I actually ask you to open those and cut the evidence tape so that we could access each one of these boxes and envelopes?
Yes, ma'am.
Okay. So before you did that, were they all sealed up with evidence tape and had different markings?
Yes, ma'am.
Okay. I'm gonna ask you, if you will, without showing the jury, just look inside of 106, and do those items all appear to be, which would be 107, 108, 109, and 110, do those all appear to be in the same or substantially similar condition as when you brought them and when we opened them yesterday?
Yes, ma'am.
Okay. Same question on State's Exhibit 96. If you'll open that without showing it to the jury. Would those all appear, State's Exhibit 97, 98, and the contents inside of 98? Which is gonna be 99 through 104, 105. Do those all appear to be in the same or substantially similar condition?
Yes, ma'am.
Is there a unique number that is assigned to each and every incident as far as a report number with the Fort Worth Police Department?
Well, while they're going through all this, folks, just a reminder, it's not necessary that the victim have been doing anything unlawful in order for this shooting to be justified. They could both have been acting lawfully. It's not necessary that the police have absolute proof of some crime being committed before they can come on the property. They're allowed to investigate whether or not a crime is being committed based on the information they have. You don't have an absolute Fourth Amendment right not to have the police come on your curtilage. The Fourth Amendment protects you against unreasonable searches. Reasonable searches are permissible depending on exigent circumstances, which is the case here with a burglary in progress call, which is how Fort Worth trains its officers to treat a open structure call, especially at 2:30 in the morning. Yeah. Fort Worth Police Department explicit policy is to not announce at an open structure call.
So now to State's Exhibit 111, the contents, which is 112, State's Exhibit 113, and the contents, which is 114, do those all appear to be in the same or substantially similar condition as when you brought them yesterday?
Yes, ma'am.
Thank you. Is a firearm, sir, is that considered a deadly weapon?
Yes, ma'am.
And shooting a bullet through a window, is that considered not clearly dangerous to human life, sir?
Yes, ma'am.
I'm gonna pass the witness, Your Honor.
Cross-examination.
Pointing a loaded firearm at a Fort Worth police officer considered aggravated assault on a public servant in the state of Texas?
Yes, sir.
Is that a felony offense?
Yes, sir.
It's a first-degree felony, isn't it?
Yes, sir.
Good for 99 years.
Is deadly force available if you're met with deadly force as a peace officer?
Yes, sir.
And any means necessary is part of the general orders when it talks about deadly force, correct?
I'm not sure of the specific verbiage, sir.
Okay. We had a chance outside the presence of the jury to visit a little bit. You agree with that?
Yes, sir.
I forgot to ask you, there's general orders, but when you get selected, it's a competition to get into crime scene, correct?
It's an application process, yes, sir.
you have a basic peace officer license in Texas. The jury heard about T-Cole certifications for communications yesterday. There's also one for peace officers such as yourself, correct?
Yes, sir.
What level of peace officer certification do you currently hold?
Advanced.
Can you take the members of the jury through the levels?
Yes, sir. The first level, which is upon graduating from the academy, is a basic peace officer. You later, after time and continuing education hours, can earn the intermediate level, and then after that is the advanced level. The final level is master.
And to be part of crime scene, you have to have some advanced crime scene classes once you're selected or get in, either before or after. You have to have the same type of advanced classes for intermediate level TCOL, do you not?
We do not require intermediate crime scene, but everybody does take it once they come into the unit.
And that helps you get your intermediate peace officer certification as well, because you're checking the box off, yes?
Yes, sir.
Okay. Prosecutor asked you on direct about what information you have when you get to a scene. When you're called out to a crime scene, whether it's a burglary of a habitation, a homicide, a critical police incident, a police shooting, or use of force situation, you're going to take a briefing from somebody, correct?
Yes, sir.
Who did you take your briefing from in this case?
Officer Bain, crime scene officer.
Officer Bain, and there's another crime scene, senior crime scene officer, last name of Lee, is that correct?
Yes, sir.
You were paired up with Lee, and Valderas was paired up with Bain.
Correct.
You're not rookies anymore on the street, but once you go back into crime scene, you kind of have that yellow rookie stripe on the back of your stuff for a while, don't you?
Yes, sir.
You got a 1-year probationary period.
Yes, sir.
During that 1-year period, are there different stages like there are for being a rookie on patrol? So there's a start-off stage where you're an observer.
That would be more during the actual field training. The 1-year probation starts at the end of that field training, and you are 100% working calls on your own. Any high degree, like high offense level or intense scene, a senior officer will come out with you.
So you have, can I use FTO, but it's really like crime scene FTO?
Yes, sir.
You have crime scene FTO, then once you're cut loose and the sergeant over crime scene says you're good to go, you have another year of probationary period to stay in the unit.
Yes, sir.
Do you have to give the city of Fort Worth a commitment of time that you'll stay in the unit based on the money they're going to spend on your training?
No, sir.
During October the 12th, 2019, were you still in this crime scene FTO period?
No, sir.
You were in your probationary period?
No, sir.
Help me understand that.
So my probationary period began March of 2018, ended March of 2019, so several months before this incident. Officer Lee went with me because when we deploy the scanner, it is typically a 2-man operation.
In addition to general orders for the city of Fort Worth, does the Fort Worth Crime Scene Unit have what they call standard operating procedures, or SOPs?
Yes, sir.
Are they treated in your world just like general orders?
Yes, sir.
They describe how crime scenes supposed to do certain things. Do you agree with that?
Yes, sir.
And they use the word shall sometimes, and in this building, shall equals must. Do you agree with that?
Yes, sir.
Officer Bain, without going into it, gave you a briefing. Was Valderas, to your knowledge, because it's a tight, small unit crime scene, correct?
Yes, sir.
As big as Fort Worth is, you guys need more resources, right?
Yes, sir.
Pleaded the budget. We need more resources for crime scene.
Yes, sir.
And in fact, like on this case, your SOPs say, since it's a critical police incident, the crime scene sergeant, if they're not on duty, they're waking them up.
Yes, sir.
The chief of police has been woken up. There was a lot of rank out there when you got to the scene. Would you agree with that?
I don't recall.
Was Valderas still in this crime scene field training officer program? Or was he out because Bain was with him?
I believe he was still in field training, sir.
Did Valderas start behind you in the unit?
Yes, sir.
Once you got your briefing, you're able to ask whoever's giving you the briefing for what you're supposed to do additional information, correct?
Yes, sir.
During your period of time, was Lee your training officer when you were in the field, or did you have multiples for a crime scene?
multiple, but Officer Lee was not my training officer at any point.
For all the multiple officers you had, you're welcome to ask them questions at any time if you need additional help.
Yes, sir.
And if they see you doing something wrong, they politely pull you aside and say, hey, what about this?
Correct, sir.
They're challenging you because you want the best evidence before the finders of fact. You agree with that?
Yes, sir.
When you walked up, you have to make, crime scene, you have to make an initial scene assessment on any scene to see if it's safe for you to be in the facility, the property, what have you, correct?
Yes, sir.
On your initial scene assessment, you came up in the early morning hours when it was still dark.
Yes, sir.
Could you tell from walking up to the residence whether the residence had a rear entry door?
No, sir.
Could you tell if it had a gate that opened up into the back property, if there was an alley from walking up from the addressable or the street side, the front side?
No, sir, I could not.
So whether or not there's signs of forced entry on the two doors up front, if you're supposed to secure and observe if there's forced entry around the building, somebody still has to go to the back to check on a call for an open structure. Would you agree with that?
Yes, sir.
Prosecutor asked you if you could see a window when you got to the gate. Do we know what height your camera was at and what its field of view is on the lens? Because it's got a pretty wide angle, does it not?
It can, yes, sir.
You know what the angle was set at to be able to see that window standing outside and what the distance was from the gate when you had that image?
So the photograph I did not collect, but for the scan, no, sir, I do not know.
So we don't know, do you know how tall Officer Dean is?
No, sir.
Do you know how tall his body camera was at the time, where it was mounted on his body?
No, sir.
You had an occasion to spend a lot of hours inside the scene, because that takes a while to scan, does it not?
Yes, sir.
Did we have any malfunctions with the scans? Did it behave like it was supposed to?
Yes, sir.
I noticed from looking at State's Exhibit 3 that you were able to get your tripod back into, there's a dead corner in the kitchen, an L-shaped corner in the kitchen back to the right of the stove if you're looking at the stove. You were able to get your scanner all the way back there, is that correct?
Yes, sir.
Any issues with anybody taking any photos from that area then? They would be able to get back there. If you could get the tripod back there, they could get back there.
Yes, sir.
In your field, is there, because you're trained on a bunch of stuff in crime scene, not just working on residential or a structure, you're taught that if it happens, you have to handle it.
Yes, sir.
You got to figure out a way to process it, whether it's a dumpster or whether it's a structure. Is that correct?
Yes, sir.
Is there a term of art in crime scene called layering an area or a room?
Yes, sir.
Can you explain to the members of the jury what it is to layer? There's many ways to do it in a field where you grid it off with string and stakes and you work sections, but for a room, let's focus on layering just for a room. Can you explain that to the members of the jury?
So my understanding is when layering a room, you observe it, document it as is, and then you can start becoming more intrusive into different parts of the room, opening cabinets, refrigerators, things like that, looking in, because you've already documented the original state of those objects. Once you've documented original states, you can move objects to see what's underneath them, like couch cushions or full pieces of furniture. Additionally, you can section off certain parts of the room and deal with those at each time to basically compartmentalize the scene, make it easier to process and easier to understand at a later date.
And for the jury's benefit, there, at some point on a homicide, a Tarrant County medical examiner district death investigator has to arrive to take possession of the deceased. Is that correct?
If they're still on scene, yes, sir.
And at the time of your scans, from what the state published on the big screen here in the courtroom, Ms. Jefferson's body was still in the room.
Yes, sir.
Were you there when the death investigator arrived?
No, sir.
Do you know, you mentioned couch cushions. You've seen the crime scene photos from Valderas that the couch, the sectional couch in the living room looked like it was layered. Somebody had moved the cushions in some of the photos.
I don't recall. I'd have to see the photos again, sir.
Do you know if any layering searching of the debris, the items that was in the area, the room where the shooting took place? If anybody went through and processed?
Ian,
the area where Miss Jefferson
I
was?
Twitter DM'd you a guest link if you want to come on.
Does your scanner have the capability of also scanning the ceiling when it's scanning?
Yes, sir.
I don't know if you've watched Officer Dean's body worn video or not, but there's audio on it. That would be typical for an Axon camera, correct?
Yes, sir.
If I heard what appears to be a smoke detector going off, was that still going off? A 1 minute chirp? Did you ever isolate or figure out when you were in the room, because you were probably in there the longest, of where that chirp was?
I don't recall, sir.
Would your scan show us if the?
I don't know how people can live with those smoke detector chirps.
It should, yes, sir.
Did you make any notes or observations? That didn't catch your attention.
No, sir. It's common.
Did you make any observations about the structure of those storm doors? Was it glass or was it screen? Or you don't know, or both?
I don't know, sir.
I'm sorry, say it again.
I don't know.
Okay.
Thank you, officer. Pass the witness.
Pretty right.
Nothing further, Your Honor.
Okay, I'm gonna say your name wrong. May he be excused.
No objection from the state.
Thank you very much. You may sit down.
Thank you, Your Honor.
All right, that's it for this witness.
Who do you have next?
State calls Detective Roloff with Forward Police Department.
All right.
Detective Roloff.
Sure. Yes.
Very efficiently run courtroom. Snap, snap, snap. Everything happens right away. Good judge. I'm a fan of this judge. Police are allowed to sneak around your property, folks,
Someone swear or affirm testimony given this cause to be the truth, whole truth, and nothing but.
if they're investigating a crime. They have reason to believe they're investigating a crime.
Says you can't be in court unless you testify. Once you have testified, don't discuss your testimony with anybody else except the lawyers, okay?
Yes, sir.
Mr. Smith.
Detective, would you introduce yourself to the jury, please?
I'm Detective Doug Roloff with the Fort Worth Police Department.
And could you speak up just a little bit?
That was operator error on the judge.
Oh, okay. Thank you, Judge. Let's try that again. Sound check.
Detective Doug Roloff with the Fort Worth Police Department.
Detective Roloff, how long have you been with the Forward Police Department?
31 years.
And what all jobs have you had in those 31 years?
I worked patrol for the first 12 years, zero tolerance part of that. Promoted to detective in 2003. Worked South CIU, which is general assignments, for 5 years. And came to major case for the last 14 years.
You a certified peace officer?
Yes, sir.
What's it mean to be a certified peace officer?
Go through academy, take a state test to get certified that you follow the state required minimum requirements to become a police officer.
And what is your current duty assignment again?
Detective,
And where are you assigned?
major case.
And what is Fort Worth major case?
Major case investigates officer-involved shootings, in custody death, kidnappings, murder for hire, high-dollar fraud, some theft cases, and anything else the chief thinks that we need to investigate.
Were you a part of the major case division back in October of 2019?
Yes, sir.
On October 12th, 2019?
Yes.
And as part of that division, were you assigned to work on a officer-involved shooting involving Officer Aaron Dean?
Yes, sir.
And Did you go out to the scene that night at 1203 East Allen Avenue?
Yes, I did.
How long were you out there?
10 minutes maybe.
And then where'd you go after that?
I went to our office on Calvert Street.
The home where the shooting took place over on 1203 East Allen Avenue, is that in Fort Worth, Texas,
Yes, sir.
Tarrant County?
Yes, sir.
So why'd you go back to the office after the house?
When I arrived on the scene, I spoke with a Detective Rimshes, and we found out that there was an officer-involved shooting, and there was a person inside the house that was deceased, and I knew we needed a search warrant in order to go inside that house.
Once you also went back to, and where's your office again?
1000 Calvert.
1000 Calvert. After you went back to 1000 Calvert, did you ever have the opportunity to meet someone introduced to you as Officer Aaron Dean?
Yes, sir.
Do you see that person in the courtroom today?
Yes, sir.
For the record, the witness of the defendant has stood up. Is the person that stood up the person you recognize as Officer Aaron Dean?
Yes, sir.
So, for what purpose did you meet the defendant?
So,
Well, let me take that back. Did you meet the defendant as part of crime scene collecting his duty weapon that was used on October 12th, 2019?
yes,
And you were present at that time?
yes.
May I approach the witness, Your Honor?
Yes, sir.
Now, were you also present for some paperwork that was done in collecting of that weapon that was fired on October 12th, 2019?
Yes,
And if I may, here's a copy of that if you need it to refresh your memory. Did you fill out some paperwork when you collected that firearm?
yes,
Did you document the serial of that firearm?
yes,
Now I'm opening up State's Exhibit 6, what's been marked as State's Exhibit 6. In that, do you see State's Exhibit 107?
yes,
And is that the same firearm that was collected from Officer Dean in the early morning hours of October 12, 2019?
yes.
And how do you know it's the same?
Because I have it listed as a serial number of one I collected from him.
You collected it from the defendant and it has a serial number. What is a serial number on a firearm?
It's an identification specifically given to each firearm to identify make, model, and serial number when it's made.
And so that helps you identify to say, that is the firearm that I collected from the defendant on October 12, 2019.
As if this is in
And
dispute.
as a result, did you also recover, now firearms have multiple pieces, did you also recover a magazine?
Yes.
And what is a magazine?
Magazine is what ammunition is loaded into and then loaded into the gun.
All right, and is that magazine in State's Exhibit 108,
Yes,
marked as 108, is that the magazine that was part of this firearm?
yes,
Now, were there some bullets in the magazine and the gun?
yes.
Is the baggie marked State's Exhibit 109, does that have the round that was chambered in State's Exhibit 107?
I cannot say for sure.
Cannot say for sure, that's fine. And then what about State's Exhibit 110?
That's ammunition also, and I don't know if that was in the gun. Crime scene did that.
Crime scene did that, okay.
Yes.
But you're for sure that State's Exhibit 107 and 108 are from the defendant?
Yes,
Your Honor, may I take State's Exhibit 106 over to defense for review?
Yes, sir.
Hey, Runkle. Boy, I can't hear me. There we go. Can you hear me okay, Ian?
Your Honor, we don't, the defendant
I think you're muted.
objection to the state's
Are you muted?
position of State's 106 for the record only, which is the evidence box.
Is that better?
Yeah, that's much better.
108,
I don't know why my audio keeps
110,
having trouble.
109 and 110 being baggies.
Nick, I did invite Nick, but he's on a flight today. He's flying back home from Florida, so I don't think he'll be able to join us. I did suggest that he take over the coverage tomorrow because I'll be,
106 for the record, Your Honor.
I won't be available all day tomorrow.
108, 109, and
Oh,
110.
apparently my mic is loud. I'll try to turn that down.
and
There you go.
106 is for purposes of the record.
Yes, Your Honor, and for the record, 107 and State Exhibit 107, the firearm is secured with zip ties to State Exhibit 106. It has been placed in a safe manner with zip ties, making sure that it is inoperable at this time. And State Exhibit 108 is secured the same way with zip ties.
Are they going to point it at the jury?
So, to take a roll off, State
I always
Exhibit
love with the
107,
zip ties because when they're older guns, often they can't be zip
Yes.
tied.
firearms, deadly weapon.
Yes.
Nothing further, Honor.
In the Dean Cummings trial, the prosecution had the defendant work the bolt and it just snapped the zip tie right out of it.
You got to the scene,
Well,
and then you became the.
and I've had trials where officers have pointed guns at me and I'm never super thrilled about that.
Information warrant, you put in there that a weapon may have been displayed at a police officer, do you recall that?
Yes, sir.
And in the state of Texas, that's the first degree felony to point a weapon at a police officer, correct?
Yes, sir.
A police officer is in a full uniform.
Yes, sir.
So to collect evidence at a location such as that, you need a warrant to get in,
Yes, sir.
and, or you could get consent, but there was nobody there that you could find and sign consent, correct?
Correct.
Based on what had taken place. So the evidence that was removed from the scene was removed under a warrant, is that safe to say?
Yes, sir.
Prosecutor asked you about when you got to see former officer Aaron Dean, he went to y'all's location, is it 1000 Calvert?
Yes, sir.
Is that the old training academy on the other side of the river?
Yes, sir.
Were you present when they took who took the photos of Officer Dean and Officer Darch against the nondescript wall to show what they were wearing?
That would have been Crime Scene Officer Duman.
And is that something that's commonplace to document for your world in major cases, exactly how the officers looked at a given time?
Yes, sir.
Done in every critical police incident, any use of force that y'all are investigating.
Yes, sir.
That wall's been used a lot.
Yes.
When you're there, the weapon that is in Dean's holster at the time of the photos, that's the weapon that was just admitted here before the jury, is that correct?
Yes, sir.
Mike's still causing me trouble, I
Dean
think.
issued another weapon that night, is he not?
Yes, he is.
Can you explain that to the members of the jury?
We have in officer-involved shootings, or any time a weapon is used by law enforcement. In the city of Fort Worth, we collect the gun they use so that it can be tested at the crime lab to verify shell casings, projectiles on the scene and so forth. But at the same time, we do not leave our officers unarmed. We replace the gun that they have with an exact duplicate of the one we took.
At some point throughout this, the jury may not know the day, but at some point a warrant was written. This is Saturday morning. The warrant's written Monday evening, signed by Judge Wolf when he's brought back to the courthouse here to sign it. Do you know about that?
Yes, sir.
Were you here at the courthouse when he signed it?
No, it wasn't.
At some point, parts of Aaron's weapon that are no longer in that box were given back to him. Do you know that?
Yes.
Can you explain how that happened?
So I believe his gun originally had a flashlight on it, and I think that property belonged to him. That may have happened that night, actually, because the gun I issued or had to issue him was a exact duplicate of the gun, but we don't have any of the extra stuff that he had on his gun. If it was that flashlight, if I'm correct on that. And so we take that flashlight off the gun that he turned in to put it on the gun that he was replaced with.
After that photo against the nondescriptive wall is taken, you take his gun. At some point, somebody has to take his Axon taser camera system. Is that correct?
So the night that this occurred, and what usually, let me go by what happens with our critical police incidents. If they have video cameras, so forth, we have a docking station in our office. We have the officers come in, put your camera on the docking station so it can be uploaded to our server or evidence.com, the server that controls all of our video. So that would have been placed on the docking station that night, I believe. And so that we would have access to it to review video, because we immediately restrict access to video.
Did a lieutenant, if you recall, come in and take Officer Dean's camera from him?
I do not know who did that or who loaded it on the docking station.
You know Lieutenant Holford?
Yeah?
Is he part of Major Case?
No. He's a patrol lieutenant. I believe he was actually Officer Dean's lieutenant in the division that he worked, or the district that he worked.
Is part of that evidence.com system, there is what I think you and I have come to know through this investigation is a full audit trail. Would you agree with that?
Yes, sir.
And you and I, Mr. Gill, Mr. Smith, Ms. Diener, have all known each other for several decades.
Yes, sir.
Back from our time, Bob and I at the DA's office to today, we all work together, and sometimes emails just get exchanged and we copy each other, correct?
Yes, sir.
Because we're all trying to get to the bottom of stuff when we're asking questions, correct?
Yes, sir.
You and I and the state had an exchange of emails where I was asking about the audit trail for former Officer Dean's camera. Do you recall that?
Yes, sir.
And you were asked to check into where the physical camera was from the time of the offense, where it was if we wanted to do any additional testing. Do you recall those emails?
Hey, Ian.
Were you able to look
Hey.
at the camera?
Your
Oh, is my
keyboard's pretty-
keyboard?
Yeah.
Oh, it's coming in hot. Sorry.
Yeah. That's
It went.
It's supposed to be a quiet keyboard, but
The
and it's
camera that
yeah.
Officer Dean
Sorry
had
about
was
that.
an older generation camera, and what was told to me by our camera specialist at the academy was after it was turned back into the academy, they sent it back to evidence.com because we upgraded our camera systems.
So if Lieutenant
Or
Holbert-
Axon, sorry, Axon.
if Lieutenant Holbert took the camera and it wasn't actually taken by Major Case, that it may not have got booked into evidence or preserved or held like Major Case normally does, and it could have, that's how it ended up possibly back at Arizona or Nevada, wherever they keep them for processing.
Correct.
And you did some due diligence on our behalf, and we thank you that we can't find it even back there. Is that correct?
Yes.
Thank you, Detective. Pass the witness.
Pretty correct.
No further questions, Your Honor.
Madam Detective, roll off be excused subject to any potential recall.
No objection from the state.
Yes, Your Honor.
Thank you.
Thank you, sir.
all right. That's it for him. When are we taking the morning break, Judge?
Break time.
Here we go.
Judge seems to be very just, hey, this is what we're doing next.
Yeah, I really like this judge. He's very efficient, very in control of his courtroom. Nobody's testing him. Everything happens bam, 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 right after another. Everybody's ready to go. And that's generally a reflection of a judge who's in good control of his courtroom.
Yeah, no,
Unlike some judges we've seen recently.
where there's like 20-minute soliloquies and yeah.
So, folks, if you want us to, questions that you want answered or information from us, it's either you're a law self-defense member, you put it in the member chat, and I'll take a look at those in just a moment. Those are free. But if you're not a member, you're not putting it in the member chat, it's got to be a super chat on YouTube, at least $5, folks. That's the only way we can differentiate the substance from. We have a lot of trolls in the comments today, I notice, or people who've suffered traumatic brain injury. I can't. It's hard to tell sometimes, but. So it's got to be in that super chat form if you want us to address it. In fact, let me take a look now, see what we have. And thanks for coming in. Glad to have you here.
Thanks for having me. It's this one's kind of an interesting one. I think it's looking, from the little bit I've been able to see, that this is possibly sort of the classic situation of both people having a self-defense argument.
Yeah,
and
I
just
think
one
that's
of them
true.
survives.
Right. It's one of those. It looks to me like a awful but lawful use of deadly force here. The officers had responded to essentially a burglary in progress call. They were there. They approached because it was 2:30 in the morning. The neighbor had noticed across the street had noticed all the doors were open. They were never open before, and all the time those people had been living there. He testified yesterday. The neighbor did. So he called the non-emergency number, said, "Hey, I'm worried because the doors have been open since 10, and now it's 2:30 in the morning. So we're concerned." He actually walked across the street and didn't go into the house, didn't call out, but he was sufficiently concerned, he said, because he was afraid he'd get shot if he startled someone inside the house. So he thought it was dangerous. He walked back across the street to his place, called the cops, went in as a open structure call, which is a very specific call that's treated as a burglary in progress call. That's how the officers got it. It's sufficiently dangerous that it's mandatory that 2 different officers show up, and they're trained not to announce themselves because it could be a burglary in progress. They don't want to turn it into a hostage situation until they investigate what's going on. They took 1 minute and 16 seconds from the moment they approached the front door to begin searching around the outside of the house when the shot was fired. One of the cops, the defendant here, looked through a window into the home, and on the other side of the glass, somebody was raising a gun at him. He says, "Show me your hands," fire, and a split second later fires a single shot, fatal shot, strikes the woman in the heart. The woman was not a burglar. It was her place. She was babysitting her 8-year-old nephew, who was the only surviving witness to the shooting other than the 2 cops on the scene. From the officer's perspective, they're lawfully on the property. They're allowed to investigate when they have exigent circumstances, like an apparent burglary in progress. And hold on a second, I have some. There we go. And by the way, if the woman had shot him first, it probably would have been a solid case of self-defense, defense of dwelling under those circumstances. So it's not necessary. People get confused because they keep saying, well, for this to be justified, it must mean that the woman's not allowed to do this or not allowed to do that. No, what she might have thought, her subjective state of mind, what she is privileged to do or not do, is completely independent from whether or not this officer is criminally liable for this shooting. So he's been charged with murder, first-degree felony in Texas, good for 99 years in prison, to which the defense will be self-defense, and a lesser included charge of murder under Texas law is reckless manslaughter, so I presume the jury will be instructed on that as well. But recklessness requires the knowing creation of an unjustified risk of death to another person in this context. And while he may have been incurring or creating risk by investigating around the house, it was not unjustified to do that. That's what he's supposed to do when he's called to a burglary in progress call. So I think the self-defense narrative is pretty straightforward so far. He was acting lawfully, so he was an innocent actor here. He was facing an imminent threat. The gun was being raised. It is a gun, so it's deadly force. He was perceiving all this reasonably. He was acting within department policy, not announcing and so forth. So I don't see any unreasonableness here. So I think it's a very strong, and of course the state has to disprove self-defense beyond a reasonable doubt here. So it's not like a preponderance question. It's if there's even a reasonable doubt that it could have been lawful self-defense, it's supposed to be an acquittal. And on the recklessness, I just don't see any reckless conduct.
And I think that there's arguments for a lawsuit against the police force for things like, hey, your policy not to announce yourself is dangerous or something like that.
And of course they are being sued.
But yeah, I mean, people often sort of confuse this. They think of self-defense as like one side or the other. And so often you get situations where both sides have a self-defense argument. And yeah, this is, I mean, assuming that those are the facts that come out, and so far it seems like it. I don't think that there's,
So we're still in the state's case in chief, and they've presented evidence from the 8-year-old who was a witness. And on the witness stand, the 8-year-old testified that his aunt did not point her gun at the window, and he could not see what was on the other side of the glass. But he's made prior statements, including a videoed interview of him 2 hours after the shooting, in which he explicitly said that, yes, my aunt pointed the gun at the window, and I could see a badge on the other side of the window. So the statement on the witness, and that video was introduced into evidence by the state immediately after his on the stand testimony, saying she didn't point the gun. So there goes him. Whoops, what happened?
Yeah, that sounds to me like, I mean, if you've got a witness with those two contradictory statements, what are they going to do about that? How do you fix that? You can't.
Right, and the statement immediately after the event, and this happened 3 years ago,
Yeah.
October 12th, 2019. So the statement immediately after the event is going to be more credible. Plus, the kid, I mean, he's a child, so the cross examination was soft, as you might imagine. But the kid started making statements that were just not really credible. Like he hasn't spoken to anybody else about the testimony. Well, his family's suing the city. They have Lee Merritt, who's a Benjamin Crump type activist attorney, suing the city. And there's no possibility that Lee Merritt did not talk to the only surviving eyewitness of the shooting, other than the officers. Of course, he did. Then they had the backup officer, who was a female. This is another interesting thing. Both these cops are brand new, effectively. They'd both graduated from the police academy just the year prior, 2018. So he'd been a cop for about a year. She'd actually had her commissioning as an officer delayed because she had a broken foot. She was on the force for 3 weeks when they went to this call. Oof. So they're both really brand new. And I see this happening increasingly in American police departments where because of how the legal risks now associated with going hands-on with suspects, any cops who have the seniority are either retiring or they're moving themselves off the street into academy jobs or headquarter jobs or public affairs jobs. So they have virtually no chance of having to go hands-on with a suspect and finding themselves a defendant in a trial like that. But of course, we still need cops on the street. So all those slots get filled up with new graduates from the academy. And we don't tend to get better decision-making from someone who's been a cop for a year than we do from someone who's been a cop for 10 or 15 years. Not that I think the cops made bad decisions here. I think they acted completely within protocol. It's just a confluence of unfortunate events.
I'm not a huge fan of sort of the non-announcing things, but I get there's arguments for and against. But I mean, at the end of the day, if somebody's pointing a gun at you, what other options are there? I mean, that's when the rubber hits the road, and that's sort of the classic self-defense situation. There's sort of very few situations where somebody's pointing a gun at you, an unknown person, where you're not going to be cleared.
It's not like the officer knows that this is the resident of the home babysitting her 8-year-old nephew. As far as he knows, it appears to be, I mean, his partner testified yesterday that it appeared to her the house was the subject of a burglary and had been ransacked from what they could see. So for all I know, the burglars are still in the home. That's why they treat it as a burglary in progress call. So the person pointing a gun at him could well be the burglar.
Yeah. I mean, it's tough. A lot of these cases, I don't like the outcome, but that isn't how the law works. It isn't like, oh, well, we have to you have to follow the process. The process is, hey, here's the test for self-defense. It's, so it's tough. I get concerned about sort of police shootings, but at the same time, that doesn't mean that every police shooting is necessarily a wrongful shooting. And I think there's people who like to leap to that. There's ones where you can look at it, but I mean, I would call the police if my neighbor's, house was open at 2:30 a.m. This could have happened sort of anywhere and to anyone kind of situation.
Yes, and it's not a particularly safe neighborhood. The police respond to burglaries and so forth. Oh, okay, we got the camera back in the courtroom. We have that camera back. Let me see. I'll just keep it up on the side here. Do we have sound? A little bit of sound. Nothing much is happening right now. Yeah, so the policy could suck, right? We could say it's a bad policy. The departments change their policies all the time around things like high-speed pursuit or, when a taser should be employed and all kinds of things. And maybe this policy needs to be changed too. I'd certainly be open to the argument. But that's got nothing to do with this officer's criminal liability. He doesn't set the policy, and he's obliged to follow the policy. In fact, he'd be incurring legal liability if he wasn't adhering to the policy. So it's simply not his call to make, especially a cop with his limited experience. I mean, maybe a cop who'd been on the force 20 years, you could say, based on his training and experience over those couple of decades as a police officer, he might come to a different decision. But anyone who's new in a job is usually pretty adherent to the company policies because that's what has been driven into their skulls since the moment they were in the academy.
Yeah, and I mean, there's so much subjective stuff to self-defense things, and so I was doing what I thought was best because this is my training, goes a long way. So
Right. Yeah, and it's not necessary that the woman was doing anything wrong for this to be a justified shooting. You can have both people acting lawfully and still have conditions in which, frankly, either of them might have been justified in using deadly force in self-defense. He just got his shot off first. If she'd shot him through the window, saying, "Hey, I couldn't tell he was a cop, and I saw him raising his gun towards me," that looks like a good shoot to me. Not a good outcome. And I think when we have these bad outcome cases, it really emotionally energizes people because we don't like bad outcomes, naturally enough. So we think, well, something should have been done different. There ought to be a law. There ought to be a different policy. Someone has to be held accountable. And from a policy perspective, I guess that's true, right? I mean, presumably the department's going to be held accountable if the policy is deemed to be improper. But in terms of criminal liability for an individual, there are specific conditions that have to be met. One of them is you have to prove them guilty of a crime. You have to disprove their justifications, their legal defenses for that. And I think it's going to be a hard sell here. I think he's got a very robust self-defense narrative against the murder charge. And I think the evidence against him for reckless conduct is really non-existent. And again, they were only there. This all happened in 1 minute and 16 seconds. They were still developing the scene. They're looking around the home. And when they encounter a gun being raised at them.
yeah,
So the
and
prosecutor tried to make a bit about, well, the policy also says you should do this and you should do that. You should do other things. Did you do those things? They're like, no. But doing those things takes time. It's a process. And the first thing, like, there were cars in the driveway. Did you run the license plates on the cars? Well, no, we didn't do that. First of all, it hardly makes sense. But second of all, you can't do everything simultaneously and instantaneously. When you're on the scene, you're doing things one at a time. Maybe they would have gotten to running the plates on the car if they'd had 15 minutes, but the circumstances didn't give them 15 minutes.
I mean, I think that you could go a step further on this one. Let's say the neighbor hadn't phoned the police and instead had said, "You know what? I've got a handgun. I'm going to go check it out. I'll just bring the handgun so that I'm safe." And they wandered out there and were saying, "I'm worried about a burglar." And then I look through the window and there's somebody pointing a gun at me. They'd be in a much, I think, a worse situation. But I suspect that they'd
right. Because they wouldn't have a legitimate reason for trespassing on someone's property. I mean, you could make the argument, right? But you'd need a lot more reason to believe that some crime was occurring to provide the exigent circumstance where a civilian would go in. They wouldn't have gotten a 911 call saying, "Hey, it appears there's a burglary in progress," right? So it would be a much more awkward set of circumstances for a civilian than for. But of course, if it had been a civilian, when civilians intervene and it's a bad outcome, well, they get prosecuted, right? They're monsters because there was a bad outcome. When they don't intervene, everyone says, "Why didn't anybody do anything? Why did they just let this happen?"
Yeah, we get that here in Canada where there's a lot of sort of pushing on that. And, people say, "Oh, well, why didn't the civilian, step in?" It's like, well, because they're unarmed and you're expecting them to intervene in this fight. And I've seen this. I mean, the flip side of this is I've seen the scenario where you get two guys at a bar fight and one guy's just getting, flattened, and somebody comes in to say, "Oh, he's had enough," and gets stabbed to death.
Yeah, right.
It's like, oh, well.
Yeah, people get killed over nothing much of the time, folks. You'd like to think it takes some really important reason for one human being to kill another human being, but often it's nothing. No good reason for it.
Yeah, when you read detective novels, there's always this complicated motive, and usually
inheritance.
some
and often it's dispute.
And often it's just, I didn't like how this guy was looking at me at the bar, so I shot him when he went to his car in the parking lot. Real crime is often just senseless and petty. I mean, so little at stake.
So the state's still in its case in chief. These are all the state's witnesses. They called the backup officer, a female who'd been on the job for 3 weeks when this all went down. And everything she testified was consistent with a non-reckless, rational, policy sound reason for doing what they were doing. When we get an open structure call, it's treated like a burglary. When it's treated like a burglary, we're taught not to announce. We're taught to investigate the scene first. Everything she spoke about was consistent with, well, it certainly wasn't consistent with murder or with recklessness. And the state had her on the stand on direct for 2 hours, 20 minutes, and then another 20 minutes on redirect, 2 hours and 40 minutes, and it developed nothing for them. And I have to say the defense counsel on cross of these witnesses is doing a much better, well, I was going to say a much better job, but that's probably unfair. The prosecutors here are not inept in any way. They're doing fine. I just don't think they have a lot to work with. So, the expression, of course, when you have the law, you pound the law. When you have the facts, you pound the facts. And when you have neither, you pound the table. There's a lot of table pounding going on, a lot of asking questions that don't really matter by the state to kind of pad up the time that they have these witnesses on the stand to create the impression that something is happening. I don't know. Whereas the defense cross-examination is much more substantive, much more robust, much more evidence-focused, much more aligned with what the legal defenses will be in this case, because they have more to work with, I guess, to be fair.
Well, and that's often the case, is that the lawyer on the side that's got the underlying facts looks fantastic, and the lawyer who's sort of trying to spin nothing into gold is sort of looks like they're floundering, because they have to be.
Yeah, and it's been that way since the start of the case. So the state's opening statement was 95% emotion, and then kind of summarily at the end said, and ladies and gentlemen, the jury will show you that this was murder and it was not self-defense. The end. That was it. And the state, the defense opening rather, again, they were each about 20, 25 minutes. And the defense opening was, again, just much more substantive, much more stepping through the evidence. This is what we'll show you. This is what the evidence will show you, and so forth. And but that's not a criticism of the state per se in terms of how they're conducting the case. I think it's largely a reflection of what each side has to work with. And of course, unfortunately, it's a white police officer, white male police officer. It's a 28-year-old black female victim here. So we have the protests outside the courtroom. We have all the racial dynamics. The cop got fired within 2 days, and then immediately charged with murder at the same time. And of course, that has to happen. I mean, the people who make the decision on whether to retain or fire the officer or charge the officer, they're all politicians. And this is going to be a politically energized case because it's a racially energized case, and it shouldn't matter, but that's the world we live in at the moment. So that's no reflection at all on the legal merits on the criminal charges in this case, the fact that he got fired. In fact, I thought it was kind of despicable during the opening statement. The state, I think it was during their opening, but the state made reference at some point to the fact that the officer was arrested on this felony charge of murder, as if to suggest, well, that should be a factor in determining whether or not he's guilty. Whether or not he's still presumed guilty at this point, at least.
Yeah, and there's going to be people always want sort of these firm predictions from lawyers, like, is this guy definitely going to be, acquitted, or definitely? Well, I mean, usually they also want that in the middle of the trial, which at this point, I mean, maybe he takes the stand and says, yeah, you know what? At the end of the day, I shot her because I just never shot anybody before and I felt like it. At which point, my assessment of the case switches hugely. But,
And as usual, as is common in the case, the actual evidence of any kind of racial malice or motivation here is zero. There's none. Or we would have heard about it. It certainly would have been talked about at opening.
And seeing somebody through a window late at night with, sort of a laser coming out your way, I don't know that he would have been able to, conduct or to do a racial identification at all. Like, this is not like a guy saying, oh, I'm colorblind, I don't see. I actually literally couldn't see is probably what we're going to hear, but I don't know for certain on that. But
so the state is focusing on things like, well, he didn't shout gun before he fired. Well, of course, you're not required to shout gun before you can defend yourself.
Yeah, I mean, that's something where you're communicating to your partner, but I think that, if you've got somebody who you think is lifting a gun right at you, is that necessarily going to be something you think about?
Yeah. And of course, there was a gun. The gun was recovered at the scene from the victim. The nephew described how she retrieved the gun from her purse. So it's not even like she was pointing a cell phone and there was kind of mistake of identification of the weapon here. It was definitely a deadly force weapon. So again, consistent with a reasonable perception of an imminent deadly force threat.
Yeah, and it's not even that they can make the argument of, oh, the cop planted the gun or anything if the kid says, hey, she went and got the gun from her purse. So
Right. Yep. Now it was. I mean, there again. It's a tragic outcome. She didn't deserve to die. She had a concealed carry permit for that pistol. She was not a bad actor. It's not like she was involved in the drug trade or something. There's nothing wrong with this woman. It's just a confluence of bad factors that all came together for a tragic event. And perhaps her family is entitled to compensation from the city and from the department. I don't know. That's a civil argument that'll be made elsewhere. But my focus is purely on the criminal liability of this particular police officer for what he did. We have specific criminal charges. We have specific legal defenses that are being raised. And what I've seen so far from the state, so they had the partner witness was not helpful to the state at all, in my opinion. Then we had the state called the woman who took the phone call from the neighbor. Not even a dispatcher, but like an initial phone receiver on the non-emergency line. She's the one who coded it as a open structure, burglary in progress type of call. She was fine, but there was nothing really that helped. I mean, the state asked her, so why did you characterize it as an open structure call? I said, well, the caller said it was a structure that was open, at 2:30 in the morning. I mean, it wasn't rocket science. Okay.
yeah, and I mean, it's not like, hot summer day where you're leaving it open during the day. Few people leave their windows and stuff, and doors open at like 2:30 at night. It's weird, right? It's concerning.
Yeah, and of course, it doesn't need to be a crime. It just needs to be suspicious. The police need reasonable suspicion to investigate, to do things like come on your property. They don't need certainty that a crime's being committed. And having the windows open for 4 hours in the winter when it was cold, when the neighbor's saying he's never seen those doors open before, it's 2:30 in the morning. That's enough to raise reasonable suspicion worthy of further investigation, which is what the officers were doing. They didn't kick the door in and go into the house. They were walking around the house to develop what was happening. All right, looks like we're starting to come in. And crowds coming in. I've really enjoyed this judge, I have to say, given some of the wacky judges we've had in some of these trials that just completely lose control of their courtroom. That just does not happen in this courtroom. Not even a hint of it.
Yeah, some of the trials have been just showboating, it seems like, a certain amount, too, with judges sort of showing off for the cameras.
Is he swearing a witness? Yep. Just seated a witness. All right, I'll pull this back up. Oh, what's he doing? Oh, I don't know what he's doing. Was he just saying hi to somebody? Oh, no, there's a witness. Looks like another cop. Okay.
The cop build?
I saw an elbow. I was like, yeah, it looks like a cop elbow.
I annoyed a police officer at the courthouse once because he was there in his sort of undercover outfit.
Yeah.
And I just sort of went up and was like, hi, officer. He's like, what? And I'm like, you're on the stand here a lot. You should not be here. Like, this is not a great place to be undercover.
And folks, I love these things in the comments. It's like, well, I leave my doors open. That's fine. You can leave your doors open. It's not a crime to leave your doors open. You're free to do that. But if it looks suspicious, it may result in an investigation.
Yeah. I mean, this might be a place to say we should change policy to always announce or, whatever else. But that's a policy question as opposed to a this guy deserves to be in jail question.
And then we know there's reasons for the no announce policy, right? You don't want a burglary to turn into a hostage situation, right? So they'll change the policy. Like in Georgia, after Ahmaud Arbery, they got rid of citizen's arrest effectively. Well, that has negative consequences too. There's a reason citizen's arrest exists.
Yeah.
Okay, jury must be coming in. Oh, the coughing in this trial has been terrible, though. I think there's a couple of people who just have tuberculosis in the courtroom. and they must be family members or jurors, because otherwise it's so bad the judge would have kicked them out, I have to believe, except he feels that he can't do that.
And
they,
whenever
it's like
there's the cough,
they have their
Sorry,
own
go ahead.
microphone practically. It's like the coughers have their own independent microphones just to make sure we hear the coughing as clearly as possible.
I was gonna say, whenever somebody's has a cough, they always sit next to the mic. It's like a law in some way.
Everyone may be seated. One of the fun parts of me sitting up here is to watching girls come in and out each time, and how sometimes everybody gets real territorial. And then some people just switch all the time, so I'm easily entertained. We, ready to proceed. This witness has been previously sworn to testify truthfully. Mr. Smith, Ms. Diener.
State Calling Officer Valdez.
All right, you may proceed.
Good morning, how are you?
Good.
Good. Turn to the jury, introduce yourself, please.
My name is Officer Valdez, and I work with the Florida Police Department.
Oh, he's happy.
5 years.
And what do you currently do within the police department?
I work in the West 7th Patrol District.
And so what are your hours, sir?
I go in at 5 and get off at 3.
Did you work last night?
No, ma'am, I still.
And so before you were in patrol, what
I got this weird
Crime
audio
scene.
wobble.
how long were you in crime scene, sir?
I think that's probably on the original source. I tried
is.
muting my end.
Yeah.
Did you go through the standardized training for being a crime scene officer when you were getting into that unit?
Yes, ma'am.
All right, I want to ask you specifically about your work in this particular case. October the 12th, 2019, did you respond out to 1203 East Allen Avenue?
Yes, ma'am.
And for what purpose, sir?
As an officer-involved shooting resulting in the death of female.
Sure. And whenever you responded, were you called out there to process the scene as a crime scene officer?
Yes, ma'am.
And did you do that?
Yes, ma'am.
Did you take photographs?
Yep.
And what else did you do, sir?
I took photos, wrote notes on everything that I saw, collected evidence. I mean, out there at the scene, that's probably the extent of it.
And may I first witness, Your Honor?
Yes, ma'am.
I'm wondering if that's not the officer's sort of gear interfering with the mic.
It's no better, right? It just sounds a little different.
I'm not hearing it now that we've moved away from the officer.
Yes,
Okay. And so what is 112?
the entire case.
Where did you collect that, sir?
This was outside the backyard, outside the window.
Did you mark that casing with a placard?
Yes, ma'am.
And they've already heard what a placard is.
Multiple
That's
cameras in the
basically what
courtroom
that is.
for different feeds. That's
On
interesting.
the outside of 111, are there identifying marks and information that pertain to this particular case? And let me be more specific. Is there an offense report number on the outside of 111?
Yes, ma'am.
All right. And in the offense report number that's on the outside of 111, does that match the offense report number on your report and your notes?
Yes, ma'am.
And does it pertain to this particular homicide?
Yes, ma'am.
All right. And is there identifying marks from you on State's Exhibit 111, the envelope?
Yes, my initials and my badge number, the seal.
Before we open the box,
Oh, sorry.
that's all right. Is there an identifying number that pertains to this particular offense report and incident?
Yes,
Does that match your notes that relate to this case?
yes, ma'am.
Okay. And is there also
It's on every
identifying
feed, folks.
initials and your badge number on the outside of State's Exhibit 96?
Yes,
And who actually put it in this box?
I do.
All right. So does this box all appear to be in the same or substantially similar condition with the exception that it's now been opened?
Yes,
Now looking inside, State's Exhibit 96, the content, State's Exhibit 97. Did you collect that item, sir?
I did.
From where?
He's on the, just left of the front door.
And was it sitting on, I believe, like a box of some
type of
sort?
box.
Does that appear to be in the same or substantially similar condition as when it was collected?
Yeah.
And State's Exhibit 98, which is a bag containing multiple items. So 98 containing State's Exhibit 99, as well as 100 through 105. First, let's talk about State's Exhibit 100. What does that appear to be?
Live round.
And does it also indicate where that live round was as it pertains to the particular gun?
Yes,
Okay, and was that the chambered round? Meaning that's one that's in the chamber, ready to go?
that's correct.
All right, State's Exhibit 99, what is that?
The magazine.
Okay, and then State's Exhibit 101, 102, 103, and 104, does that all appear to be live rounds that were inside of the magazine, State's Exhibit 99?
Yes,
And each one of those live cartridges or bullets are in the actual position they were in. So in the magazine, 1,
That's
2,
on their
3,
end,
and 4
folks.
in those positions. Is that right?
yes, ma'am.
All
Yeah,
right.
sadly,
Did you
nothing that
do
can be
all-
done about that kind of thing.
Live cartridges or bullets are in the actual position they were in. So in the magazine, 1, 2, 3, and 4 in those positions. Is that right?
Yes, ma'am.
All right. Did you do all of those, the collection of those items?
Now-
Now, State's Exhibit
Sorry, folks. Every feed is doing that.
105, marked item number 2, is that a live round that was also found at the crime scene?
Nice. Yeah, I'm watching the feeds, folks, but they're all the same. That is unfortunate. All right, well, we got a 4K test pattern, so that's helpful. But the good news is that none of this test. Oh. Okay. Still no picture. None of this testimony is likely to be very important. Still a test pattern, folks. I guess I can pull it up. I have audio for it.
Ah, the joys of court feeds.
But Law and Crime is using a different camera than the Fox 4 feed. But they're both showing the same time. Okay. Yeah, and the WFAA feed is also down. So this will be the gun recovered from the victim here that they're talking about. But, I mean, none of this is in dispute. There was a gun. It was loaded.
No objection
I mean, really, how hard can any of this be, people?
no objection to bag and contents, 99, 100, 101, 102, 103, and 105 for all purposes.
All right, so since 96, 106 and 111 presented for those purposes in the record.
Hey, let's hit the like button on
100, 101, 102, 103, 104, 105, 112 for all purposes. Yes, Your Honor. Very good.
So they're just laying foundation here.
Thank
I see we made law nerd clips
And
from
permission just
yesterday.
to show the jury by walking in front of them, states exhibits 99, 100, 101 through 105, and also 97.
Yes, ma'am.
Okay. So states exhibit 99, Academy. States exhibit 101, 102, 103, and 104.
That's the bullet that might have killed the officer had it been fired. Yeah, I don't know what to tell you, folks.
States exhibit
That's got to be a hard thing to sit there and look at while you're on trial.
States exhibit 105.
I mean, I got the volume turned down, so we reduced the hum. She's not saying anything important. She's just calling out exhibit numbers.
States exhibit 112, Your Honor, may I also have permission to publish that?
Yes, ma'am.
States exhibit 112.
This is the stuff that gets cut when they're making movies about court cases.
And then states exhibit 96, which holds. So this was secured. Correct. States exhibit 97, if I can just publish it by showing it to the jury.
That's fine.
Okay. States exhibit 97.
Are you going to show us the pistol? Oh,
Cross-examination.
cross.
Documentation of what happened, what the officer sees on scene.
And at the time that you worked this case, you were a candidate or in a training phase for the crime scene search.
That's correct.
And you were working with a senior crime scene officer, I think Officer James, ever since 2008.
Yes, sir.
We all, since we weren't there, we all had one crime scene search.
One crime scene vehicle?
One crime scene search vehicle, ride, two-man unit.
They have to start doing CLE on using audio equipment in the courtroom.
Part of the SOPs for crime scene, standard operating procedure. You have to take a briefing from somebody, is that correct?
As far as what?
Well, when you show up, it's not like the TV series CSI where you just barge into the scene and start doing it.
Okay, yeah, that's correct.
You're gonna check in, and the perimeter tape usually, yes?
Yes, sir.
And in this case, there was an outer and an inner perimeter, do you recall that?
Yes, sir.
And prior to your arrival, somebody had started a crime scene law, is that correct?
Yes, sir.
Can you explain to the members of this jury what a crime scene law is?
Yeah, crime scene log is gonna be it's just a log of who makes the scene, who's on scene, and that's pretty much it. What time they get there, what time they leave.
Do you recall from this that you're the lead crime scene officer in this case, correct?
Yes, sir.
You're responsible for everything that comes out of that residence that you're the lead, yes?
As far as evidence goes?
Yes, sir.
Yes, sir.
The jury's heard that there's a patrol officer, a beat officer that has the sheet, forward language, he's the sheet officer.
Yes, sir.
You were the sheet officer for the 4+ crime scene officers that were out there, correct?
Yeah, as far as the crime scene responsibilities go, yes, I was the sheet officer for that.
When you got there, did you tell the members of the jury who you took the briefing from?
Let me look back at the notes.
Do you have a copy of your report in front of you?
I do. I met with Detective Renshaw first.
Do you recall what time you met with Detective Renshaw?
0346. 3:46 a.m.
Did you immediately go inside?
No.
What did you do first?
We were waiting for a warrant to be signed, so I couldn't go inside. I did a perimeter walkthrough, just an overall walk through and just looking at the outside of the house, the scene of the from the outside.
If you weren't allowed on the inside, you stayed off the property line so they got the warrant in?
We were on the property, just weren't inside the residence.
The warrant covered both inside and outside, correct?
I believe so. I'm not 100% sure.
Did the crime scene officer, the sheet officer for crime scene, you're given a copy of the warrant to execute, are you not?
I wasn't given the warrant, but as far as what you're asking, yes, I think the answer is yes. to what you're
By the way,
asking.
both these defense lawyers, there's two defense lawyers, they're both former prosecutors.
Search warrants under the Code of Criminal Procedure are not a rubber stamp blanket search each time, correct?
Yes.
They have to be individualized and give a neutral magistrate particularized facts as to what took place and what, under the Constitution, you're allowed to search, correct?
Yes.
Were you given the parameters then of this warrant that you didn't see as to what you could search and select?
Yes. I guess the only thing I remember is I wasn't going to go in the house until the warrant was signed.
Do you recall what time, following your standard operating procedure and crime scene, and those all important times, what time you actually were cleared to go into the residence?
Let me look at my report real quick.
The officers differentiating between inside and outside the house for a reason with respect to the warrant. They expect to recover evidence that might be relevant in a criminal prosecution from inside the house. They want to make sure it won't be excluded because it was collected without a warrant. Standing outside the house, they're not expecting to gather that kind of evidence. It would be in plain sight. Nice hum. Yeah, it's not me, folks. It's definitely the court feed.
I don't see the time of when I entered the residence.
I mean, he probably didn't even read the warrant. He was probably handed the warrant. They said, here's the warrant. Now you can go in. And he just went in.
You have what we would refer to as a steno pad that you're making your notes on. That's critical crime scene.
Might have skimmed it, maybe.
The government's given me a copy of crime scene sketches and notes. Would those help you maybe to see if you've noted the time and notes that they're yours? You have those up there?
I have notes with me.
All right, can I come up there and see what you got?
Yes, sir.
I think I have everything. I just want to make sure.
It's not trespassing by the cops, folks, if they have reasonable suspicion there's a crime in process, which is what they had. That's not trespassing.
Just this one.
Yeah, hit that like button on YouTube, folks, and hit the plussy. Hit the plussy on Rumble.
Since you and your training partner, Officer Bain, were here together, I've stapled now what the state gave me as Defendant's Exhibit 31. It's a few more pages than what you had. Can you take a second to look through there and see if that helps you as we go through this?
Not sure that the camera should be zooming in quite so clearly on council's computers.
Yeah.
Like, hey, let's just do a close-up zoom on privileged material.
Having had a chance to look at Defendant's Exhibit 31, that appears to be not only the notes that you had, there are Xerox copies of the steno pad, but it's also your partner, Officer Baines' notes, that you recognize his handwriting and service number incorporated when you talk about it through the state, correct?
Yes, sir.
Needless to say, this was a busy scene when y'all were out there, correct?
Yes, sir.
There was a lot of rank out there, a lot of supervisors.
Yes, sir.
And as the lead crime scene person, you have to kind of keep everybody safe and keep your job.
That's correct.
By the time you got there, the advanced life support had stopped, and this was a crime scene by the time you were allowed to enter the residence, correct?
Yes, sir.
As part of your crime scene training that you were in the middle of as we were doing this case, you have to document first the scene as you find it, correct?
Yes, sir.
Is it a safe estimate that you took about 275 photos, am I correct the number?
There was a lot. I don't remember exactly how many, but yes, there's a lot.
Well, it's part of your SOPs, and I'm just asking because I'm trying to figure this out.
Mm-hmm.
Aren't you supposed to put the number in your report for the submission?
Yes, sir.
And can you look at your type report and see if you can direct me to what page the total number of photos is?
So exciting.
This is what so many court cases are like, you know. We've got 60 exhibits. Let's go through and identify all of them.
So the state has to disprove self-defense beyond a reasonable doubt or prove recklessness beyond a reasonable doubt. I've yet to see any evidence that gets them close to that.
It's going to be tough.
Also, though, that becomes important later, because part of your standard operating procedure, you must verify.
There's always the possibility that the jury doesn't care, though.
Yeah, that's right. That's right. That's why I don't predict verdicts.
And to any CDs or DVDs, I guess, at this stage, that any detectives downstream need of your work.
Yes, sir.
Because you want to get credit for all the work you did do. Yes?
Credit, I mean,
Well,
I want all my work to be there, yes, sir.
Yes, sir, that's what I'm talking about. Because the jury's heard a little bit this morning from other crime scene officers. There's either, most departments either use Canon or Nikon, and Fort Worth uses Canon SLR cameras, correct?
Yes, sir.
And an SLR camera is one that you have to look through the lens to take the photo, correct?
Yes, sir.
And prior to you going to the scene, you had to go to work the camera, yes?
Yes, sir.
The jury's seen some of your photos, and they've seen I've seen at least the sequential, where some of your photos are just dark. You didn't delete them, because that would be against your SOPs, correct?
Yes, sir.
Why would that be against your SOPs to delete photos that are just black?
I think it's just to eliminate any factor of anybody trying to hide it.
Sir, you want to make sure the sequential number is there, because on each time you put a memory card in that Canon camera, you have to reset and format the card and it starts at 0, correct?
Yes, sir.
And if you have issues, you're supposed to check the date and time on your camera prior to starting the scene. You call that.
Yes, sir.
Would you do that night?
Yes, sir.
So that's important because it gives us metadata, data data about data that's in the digital image, correct?
Yes, sir.
So we would know exactly when you went inside and started taking pictures, correct?
Yes, sir.
And it would kind of give us a timeline if we knew the total number of photos you took as to when those were done throughout the night. Regardless really if the camera's set to the perfect time, if it's 0 hour, and it goes 0 or goes 4:30, we know you're there 4.5 hours.
Yes, sir.
Safe to say?
Mm-hmm.
As part of those SOPs, you're taught how to take exterior photos and interior photos, is that correct?
Yes.
Can you educate the members of the jury what you're supposed to do for exterior photos?
As far as what I'm taking pictures of?
Yes, sir.
Just the, you want to show obviously the residence, the house number, where it's at, the location, any near by intersections that just identify exactly that you're at that house. When I just get photos of what it is that where you're at, just gives any viewer or any audience, just tells them where you're at, what you're looking at.
Prior to being selected to join the crime scene team, you were on regular patrol somewhere, correct?
Yes, sir.
You're back now on the 7th Street area,
Yes,
correct?
sir.
What observations, if any, did you make when you're taking these exterior photos outside, I guess, while waiting on the warrant, if I understand your timeline that night?
Yes, sir.
Can you tell the members of the jury what the condition of the city of Fort Worth streetlights were on the street there outside of the residence?
Well, there's a traffic light, I believe, like just west of the residence. As far as the street lights goes, anything else, I have to refer back to the photos. I remember, I mean, it was dark, it was late at night, so.
You recall there's a street light, if we have a traffic intersection by the Mississippi, you come down the street, there's a light on the address side that we're talking about. As the road starts to curve a little bit, I'm just curious if you made any observations being trained by people, whether or not that light was functioning.
I do not remember.
It's another one of these cases where this all happened 3 years ago, folks. So people's memories. It's like the Dean Cummings case in New Mexico that we covered. Everything was 3 years old.
Is it important to document, I think that there's a phrase in your business,
Everybody forgets that about trials.
Yes.
can you explain to the members of the jury what the four corners of a room is?
You just want to, before, you're just wanting to basically photograph the whole room, get a 360 view of where you're at, what you're looking at.
And your SOPs say you shall do that, shall equals must in your rule, correct?
Yes, sir.
You didn't get written up for not doing all four corners in some rooms.
No, sir.
SOPs are like general orders, you didn't get sanctioned for not doing it, but it's safe to say that some of the rooms, you look at the photos, there's not four corners in all the areas, is there?
I don't think so.
Okay, so though they have general orders and SOPs, that's a best practice type guide for how you're supposed to function as an officer, correct?
Yes, sir.
You have to be able to be out there and they hired you, they gave you a badge and a gun, and they trust your judgment.
Yes, sir.
Any reason to doubt your judgment for what you did this night in the process of the scene?
No, I don't think so.
This guy likes to use the paper easel.
So,
I mean, it can be useful.
I like it.
how are you?
I mean, it's a little less efficient than having everything electronic, but on the other hand, you get to flip through the pages. The jury gets to see stuff again, right? Just incidentally.
Yeah, you can keep it and go back to it if you need to.
Yeah.
Well, are you
I do, yes, sir.
primarily?
And things feel more substantive when you write them
Radio
down.
or- I mean, either one. But yeah, we communicate through the radio, so yes.
Cell phones as well, city issued cell phones back then?
I never used the cell phone. Officer Bain may have done it, I didn't.
Now, you're familiar with those SOPs, so a crime scene sergeant has to be notified if we have a critical police incident. Right?
Yes, yes.
You get to the scene, and you take a briefing from the lead detective, correct?
Yes, sir.
And as you're processing the scene, you have Officer Bain with you, correct?
Yes, sir.
Now the coughing's back.
Where is your office, or where did you guys stay pretty busy, correct? When you're
Yes,
at
sir.
a crime scene? And we have in Defense 31 a list of Bain's calls that night, and I assume you worked them too. You're hopping one call after another as soon as you clear the service. Safe to say?
I don't remember how many calls. I can look through my notes and tell you what I had that night. I mean, that happened in the morning.
So you brought your original pad without revealing state secrets. Can you just hold the pad up in general, just so the jury sees the size of what we're working off of? Okay.
I remember being at the office when the call was dispatched.
I'm showing you the fourth to last page in Defendants 31. Is that kind of an idea what y'all's night was like?
No, I think these are previous reports. I don't know what his notes, I don't know what his thought process was when he wrote these notes, but there's no way we could have taken this many calls in one
Okay,
night.
fair enough. I was just clarification. So you were at the office, is that at 1,000 Calvert?
Yes, sir.
back then?
Yes, sir.
For each division in the city of Fort Worth, the radio has at least one primary channel and several talk channels. Is that safe to say?
Yes, sir.
Can you explain to the members of the jury what a talk channel is?
So for certain units inside the police department, for the crime scene unit, we have our own radio channel so they can talk directly to us. If there's any kind of communication, that way it doesn't tie up the main patrol channel for all the other calls that are going on. So, if that makes sense.
So division, north, south, east, west, northwest, central, all have a primary and multiple talk channels. SWAT has its own channel, correct?
Yes, sir.
Air One has its own channel. Crime scene has its own channel, correct?
That's correct.
So dispatch notifies you through the crime scene channel and gives you an address of where it's going, right?
Yes, sir.
You get the nature of a call, what you're going to.
Yes, I had the nature of the call. So we were following we can listen to other channels too. And so we were aware of what was going on.
In addition to those individual divisions, there's an all-call that would go out over all the channels, correct?
Yes, sir.
And did an all-call for the critical police incident come out that night?
I don't remember.
How long does it take to get from where you were at Calvary over to where your office location?
About 10 minutes?
Without going into what you and Officer Bain discussed, did you start getting mentally ready during that 10-minute drive as to what you were going to be facing?
Yes, sir.
When you got there and talked to the lead detective, and the period of time you had to wait for the warrant, you're there at the 3 o'clock hour, and the warrant's not signed at 4:52 in the morning. You had some time to prepare yourself for how you're going to have to process the scene, correct?
Yes, sir.
Since the detective had already been inside, without going into what he said, you received the briefing and know what the layout of the structure was, correct?
Yes, sir.
So you and Bain had time and space to get in, do you walk around and make observations first, or do you immediately start taking photos?
No, observations first.
Why is that important?
You're trying to identify really what's important inside the house. So you're looking for, obviously, there's the deceased, you're looking for evidence around it, just trying to figure out what happened.
Given any particular scene, not just this one, you also have to look at scene safety for you and your team, is that correct?
Yes, sir.
If there's any objects that may hurt you, or pets or anything else, you need to be aware of that.
Yes, sir.
And take appropriate safety precautions. Is that correct?
Yes.
I'm sure everybody in this room has seen video of the FBI doing their evidence response. You don't dress up in a Kevlar suit to go in and process the scene, do you?
No, sir.
Do you take steps to decontaminate your evidence, those little yellow markers, and clean them from one scene to the other, since we're in the realm of roll of DNA now?
As far as you talking about the placards?
Yes, sir, the yellow placards that you put down next to evidence, or where you're gonna do a DNA swab. From the previous calls, do you clean those and make sure they're preserved and ready to go to the next patient?
No.
When you do the initial walkthrough, then you start systematically shooting photos, is that correct?
Yes, sir.
And the general order say you should shoot all four corners if possible.
Yes, sir.
Because you're not gonna get fired if you don't, but that's part of the order, if you didn't do it, you didn't do it, right? Safe to say?
Yes, sir.
By law, once somebody passes away through a certain criteria that affects it, you can't move the body, correct?
That's correct.
And you have to wait for the death investigator to get there, yes?
Yes, sir.
In between the time that you started your processing of the scene after the mortal time, your partner came in and they started processing with the life system, correct?
Yes, sir.
If I understand your report, you stopped work some additional photos and took additional photos once the death investigator, once she arrived, is that correct?
Yes.
Did you assist her with taking care of Ms. Jefferson and doing her part of the examination?
No, they usually come in with a team.
If the lead crime scene officer, ultimately, if you one of the last ones on scene,
Yes.
you're the guy usually left in or gal left in the crime scene, take it, releasing the scene back to the family or securing it, release there.
Us or patrol officers kind of work together on that.
As the lead crime scene officer, did you take the crime scene log with you?
I believe I did.
Was it included as part of your report?
Let me look back real quick. That. It's typical of the protocol for me to collect the crime scene log, but I don't think I notated that.
Okay. See, that's, we've never worked together, but I expected crime scene to lead with it, and it was a confusing scene out there, right?
Yes, sir.
So if the SOP say you gotta leave with it, that's just part of it, it ended up with somebody somewhere in the case, correct?
Yes, sir.
Just maybe not the way the game counter, like the general order said it's supposed to be. Safe to say?
Sure.
When you go into the house, you've done your initial walkthrough, you start taking your photos, they do their scans. After the scans are done, you're allowed to use your process, start collecting evidence, correct?
Yes, sir.
And did you pick what item number?
I guess, yes, I did, I just went by the order of how I saw them.
It's really luck of the draw where you are when you start with number one, correct?
Yes, sir.
Nothing gets any special attention whether it's 1 or 1,000.
That's correct.
The next one up.
That's correct.
What is an L scale in the crime scene world?
It's just, it's a reference to show the size of an object.
on the yellow markers, they have nowadays, the ones you were using in 2019, a little bump out, a little plastic bump out that has a grid on it. Is that correct?
That's correct.
And that serves kind of a purpose of an L scale, correct?
Yes, sir.
There are actual physical L scales made by Certian, dozens others, that are there for you to take images so we know what they are to scale. That's safe to say?
Yes, sir.
And your SOPs, your general orders talk about taking images to scale when it's important to look at detailed objects, such as a projectile hole in the window. Do you agree with that?
Yes, sir.
And your kit that Officer Langley we worked out on that night, that truck, was it equipped with L scales?
Yes.
And by 2019, I think y'all also had rolls of tape that had scale markings on it, and use them to go, if we wanted to take a picture of the judge's board, if there were a defect up here, and you wanted to take a picture of the board, you could peel off a piece of the scale, because it doesn't matter if it's 1 or 22 on the tape, it's just that we know it's the scale, and you can stick it next to it, take a photo, and go through that, correct?
We typically have that. Hang on. Mr. King, come up. I need counsel.
Judge wants to go to lunch. It's 11:30. Where are we going with all this? Let's see. Do I have something else playing? That was my phone. All right, so let me tackle a couple of super chats while we're waiting for that to get in order. I think it looks like we only have a couple. Let's see. Squizguard 2322, $5 super chat. Thank you very much. Says, I wonder if the coffer is a family member of the deceased. If it's not a jury member, is there not recourse to ask them to leave? I don't know who it is. I thought at one point that the prosecutor, the female prosecutor, Diener, had offered a juror a cough drop, but I'm also hearing that there is a black woman in the gallery in a wheelchair, and I'm told she's coughing. There might be more than one person coughing, but if it's a juror or a family member, they're privileged to be there in the courtroom. The judge is going to be reluctant to remove a family member. There's statutory provisions that allow family members to be present in the courtroom, and super reluctant to discharge one of the 14 jurors because he's only got 2 alternates, and he doesn't want to flush the case down over coughing should they run out of jurors. But if it's not one of those 2 categories of people, absolutely, the judge should have had that person removed from the courtroom. It's not too bad today, but man, yesterday it was awful. It was awful. And then Kyle Cowden, $5 super chat. Thank you very much. Writes, repeating myself, I remember when the policy went from call for backup if indicated to a mandatory 2-unit response. The policy is written in blood. Yeah, I believe this is a Texas police officer or former police officer writing this comment. He means the policy was written in the blood of officers because officers were responding to burglary scenes by themselves. And often there's more than one burglar. You're overmatched. You're killed by the bad guys. So it used to be when you go there, hey, if it looks like you need backup, then you call for it. They made that mandatory. It's non-discretionary. Must be 2 officers responding to apparent burglaries, which is what this was. An open structure call is a apparent burglary in progress call. And then we also have, let's see, the law self-defense chat for our members. Yes, so the gentleman we had earlier in the day who was running that scanner device, what was his name? James Van Gorkum, crime scene investigator, running the Leica, Leica. I believe it's a German company, German camera company. Ran that laser scanner where they can get all the pictures together in like a matrix. That was when he was first being questioned by the state and the defense. That was a Daubert hearing. The defense was challenging him as a witness. They objected after the Daubert discussion. That was all outside the hearing of the jury, but the judge overrode their objection And so he was allowed to testify. Then the second time the state and the defense are questioning him, it was with the jury present. Daubert is named after a court decision. It's the criteria that a expert is supposed to meet in order to qualify as an expert, give opinion evidence in court. Normally, opinion evidence is not permissible unless it's from a qualified expert.
We've got something similar here, but of course not referring to the
called
Daubert
Daubert.
case. Yeah, exactly. And yeah, Leica makes good optical stuff, so high-end lenses, cameras, that sort of stuff. Good quality.
Sam asks, was the officer, the defendant here, using his handheld light or a weapon-mounted light to look into the window? I actually don't know, to tell you the truth. He had a weapon-mounted light on the gun. I'd be inclined to think he was using that. I mean, if you have it, why not use it? A weapon-mounted light, especially that Streamlight TLR1 that he had on that gun, it is really, really bright, folks. You don't actually need to point the light and therefore the muzzle directly at something you're trying to illuminate. There's a lot of wash light that goes out, even if you just point it in a low direction, especially if there's any objects that can reflect the light back. It's very, very illuminating. I have a couple of them myself. I put those on all my home defense guns, folks. So if it's a gun I plan to use for home defense, it's got a light on it.
I think that's just good policy, because I see people saying, "Oh, well, you could have a separate light," but that's just awkward. And
it's awkward, and you know, most of the time, I don't carry a light on my carry gun because I don't like the way the gun functions. I don't like the way it recoils. I don't like you have to get a bigger holster to accommodate the light. I do carry a pocket light in my pocket all the time. That's part of my EDC. But the truth is, if you're out and about, it's never totally dark when you're the subject of an attack. I mean, if it were totally dark, how would they find you? It might be dimly illuminated, but there's almost invariably some ambient light. Otherwise, how would you even be targeted for attack? But the one place where you are likely to be totally in the dark is in your own home at night if you hear something crashing at 2 o'clock in the morning. And then it's completely black, presumably, because most people sleep in pretty dark rooms. So you're going to need a light. You're going to need a light to make sure you're identifying what you're pointing your gun at. Absolutely. And then it may as well be mounted to the gun. I mean, you don't need a special holster, for a weapon mounted light like that. It's just presumably a lockbox gun or something similar. So you don't have most of the disadvantages of having the light on the gun, and you have all the advantages. And especially in an enclosed space, you illuminate that light and it lights up everything.
And there's been lots of tragedies with people who haven't had lights. If you shoot at some dark shape.
Turns out to be a family member. Yep.
Yep.
Let's see. Yeah, the state keeps trying to distinguish between, does it really look ransacked, this dwelling, or could it just be messy? And everyone's like, well, I don't know. I mean, it's so subjective. But the point is, to the state's own witness, the officer they called, who was the backup officer, she explicitly and repeatedly described her perception of the state of the dwelling as one that was the subject of a bank robbery, a burglary, and had been ransacked. It looked that way to her. Let's see. There were tox results for the victim here, by the way. It looks like the judge excluded those. There was discussion about them before the jury ever came in, before any witness was questioned. And that suggests to me that the tox results, while they were almost certainly positive, or it wouldn't even have come up, that the judge doesn't perceive them as being relevant to any particular legal issue in this case.
Might have been she had 2 beer or something.
It's probably marijuana would be the most common thing, I would think. But
oh yeah,
no one's claiming that she raised the gun because she was intoxicated.
Yeah.
Although I'm sure the defense would have liked to have been able to have that conversation. Let's see. One member says, I'm having to watch this on YouTube because my video player quit working on the member dashboard since you all worked on it yesterday. Well, I'm watching it right now, folks, on the Law Self-Defense member dashboard, and it's working. Let's see. Dave B says, if she'd shot through the window at the cops, she'd still be dead because it's likely his ballistic vest would have protected him and the situation would have degraded from there. Well, who knows? That's just speculation. If she'd shot him in the head, the vest wouldn't have helped. But then she might have been shot by the partner. I mean, by the backup officer. Who knows?
And even you take a hit to a vest, it's tough to keep going after that.
Yeah, but his backup officer was immediately behind him. So if she saw her quote unquote partner get shot, she had her gun out already. She probably would have returned fire.
Yeah.
Let's see. Andrew Branca's coffee mug asks, that's a question I have for Andrew. In this case, from the perspective of Jefferson, who's the victim here, would someone snooping around at 2:30 a.m. outside the home constitute a threat that would allow Jefferson to raise and point a gun at the subject? Not that it's relevant to Dean's self-defense claim. I can't imagine she'd be charged for merely pointing a gun under those circumstances. Not in Texas. A woman in a home alone with a child, and someone's prowling around outside. It just merely pointing the gun. There's no injury. It just wouldn't happen. I would think. Does it get different if it turns out it's not a prowler? A prowler, by the way, is a specific thing, folks. It's not just someone walking around a home. It's someone doing it surreptitiously for unlawful purposes. This police officer was not prowling. He was investigating. But might if the cop had discovered he had a gun pointed at him, hadn't shot back, and no shots were fired, might he have been upset that a gun was pointed at him? It's hard to get much traction with that. You are surreptitiously moving around someone's house at 2:30 a.m. Brian asks, if she had shot him, I would think the argument would be, is a prowler outside an imminent threat to her inside? I wouldn't want to have that be my narrative for my client. It would be much more advantageous if there was any evidence from which you could show there was an apparent intent to enter the dwelling, even if it's just turning a doorknob. But if someone's just standing outside, there are innocent intruders. There are innocent trespassers. There are people at the wrong location. Sometimes people get drunk. Sometimes they think they're going to a house for a party and they go to the wrong house. So can you just fire out your window at somebody like that? Could that be justified? Where's the imminent deadly force threat under those circumstances? But that said, again, there are soft issues here. She's a woman alone, 2:30 a.m. with an 8-year-old besides her. So that would be it would be a difficult case to have to prosecute, I think. What kind of gun did she have? I don't know, Sam. They haven't shown the gun, and I don't believe it's been mentioned. Some kind of semi-automatic. Let's see.
I don't know that the type of the gun is going to be all that relevant. Even if it was an airsoft gun, it doesn't really change his position.
Right. No, it doesn't matter. Notably, apparently it had a laser on it. Let me see while we're waiting. I'm not sure why we're still waiting, but while we're waiting, unless I guess they decided to go to lunch. Yeah, it's only, it's 1:45 lunchtime in Texas right now. In Fort Worth, maybe they decided to take their lunch break and just not announce it. That's rude. Let me see. I have the body-worn camera footage here.
Law and Crime apparently said that the judge ordered the cameras to be turned off for this part.
Oh. Okay. So let me pull up the body-worn camera here. Share this screen. There's no gore here, folks. The camera freezes when the gunshot is fired. The actual camera keeps playing, but the portion of the body-worn camera footage that they've shared publicly stops at the moment the shot is fired, which, of course, that's all I have. And it's only about a minute and 16 seconds from... I'll start it right when the officers are at the door. They're outside the door. Let's see. And then they start moving with their flashlights around to the side of the house. and you can hear the female officer whispering to the male officer. There's a little bit of communication going on, and it's right about 2:30 a.m. as all this is happening. So there's the weed whacker. The female officer trips over a bicycle. That's the side door. The door proper is open. The storm door is closed.
These officers are super sneaky.
He's going to put his light on in a second. There we go. Oh, handheld light. Yep. His body-worn camera is on the left shoulder, which is a little unusual these days, but of course this is 3 days ago. That was the female officer on the other side of that car. Opening up the gate, there's the air conditioner. Turn to the left. Now he's between the gate and the air conditioner. He's gonna
put your hands up. Show me your hands.
Okay, so that's it. So that's all I have in terms of body camera. But let's see if I can get the frames closer. Can you see the laser come up? There was a laser on the victim's gun. So he's got his gun out here, right hand, flashlight in left hand. It's pretty bright. Do you see anything green? Green laser on the suspect's gun.
It's getting washed out.
Somebody told me they could see it, but I
go back a couple frames. I'm just trying to determine if there's that one spot of light that shows up on the window, and I'm trying to determine if that's a laser or a visual artifact. That.
Yeah.
That's odd. Because that's a bright, what I think we're seeing there is a bright spot that's washing out and making it adjust the sort of visual. I think that might be the laser right there.
It's hard to tell. It could just be a bright object inside the room. The front of the house was very well illuminated. All the lights were on, but this room is dark. Obviously, this is a bedroom. Apparently, she was playing video games when she heard a noise outside and retrieved her pistol. Oh, there's a little dot there in the lower left. See that?
Yeah.
And it looks like it's moving up. Hard to tell. Maybe the defense... Oh. I mean, now I'm starting to see some greenish, right?
I think there's certainly enough there that the defense can say, hey, maybe.
Yeah, and unfortunately, the photos of her pistol are very poor. Here's the... But you can see the laser there in front of the trigger guard mounted on the pistol. It's got a little red tip, but it's apparently was a green laser. Okay. Yeah, always important to keep in mind, folks, that the body-worn camera is not showing exactly what the officer saw, right? It's on his shoulder. It's not his eyes. The reflections are going to be all different. Even the photographs taken with the fancy Leica scanner, as the defense mentioned, they don't know, they can't recall the height of that scanner, so they don't know if it was the same height as the officer's eyes. The lighting conditions are different. The, how much of a fish lens effect it might have is different. We saw the state present a number of photographs of the officer's weapon, duty weapon, and they were all distorted vertically. So the grip was really long and the slide was really short, much distorted from what a Glock 17 pistol actually looks like. Yeah, I mean, it would be consistent with the gun with the laser being raised, right? It's not inconsistent with that happening. And of course, the defense doesn't have to prove anything. The defense just has to maintain a reasonable doubt that it could have been self-defense. And I think there's certainly enough here to do that. And why was he using the flashlight? Because it got dark and that room was dark. And to see into the room, he's going to need the flashlight.
Well, and also they're physically tripping over things as they're going.
Right.
Like you can hear them stumbling through things. So of course they're turning on a flashlight because you don't want to face plant with a gun.
Right. In fact, the female officer testified she tripped over the bicycle that was laying out there. Another reason they thought the place was ransacked, because in this neighborhood, one would expect, the officer said, that if you leave things like a bike and a lawnmower outside, that they'll get stolen. Whereas when people are ransacking a home, sometimes they'll throw stuff outside of the home to facilitate your ability to carry it off, rather than have to go in and out of the house constantly. So,
Yeah, in fact, seeing stuff staged outside the house like that can be a suggestion that there's a break and enter actively happening right that second.
Mr. Gosney, welcome, welcome.
Hello, how are you? Can you hear me?
Yeah, you sound great.
Hey, it just my hair's messed up. What else is new? I'm a professor. Hey, yeah, how's it going? Hi, how are you? Who's this?
Oh, you don't know Ian?
I do not.
This is Ian Runkle of the Bailey. He's a Canadian lawyer. Ian, why don't you introduce yourself to Steve Gosney? Steve is a public defender down in Florida, also a professor for our newly launched American law courses.
Oh, nice. Yes, I do criminal defense and firearms law up here in Canada. So, which has gotten chaotic because there's all sorts of new bans they're pushing through. But yeah, no, self-defense, like just gun issues in terms of, is this a legal gun? Is this not?
Mm-hmm.
Those kinds of questions are sort of my favorite stuff.
Well,
So,
the SKS I know is real popular up in Canada because of its maximally configured to conform with the gun laws up there. Is that still true, or is there something?
it wasn't because of that, because like previously, up until very recently, you could buy an AR-15, no problem. It's that it was inexpensive. Up until recently, prices spiked in sort of the last 5 years, but I have an SKS that I picked up for like $250.
Mm-hmm.
And it's really hard to get a serviceable hunting rifle for $250. And then, you'd get another $250 for a case of ammo and you're good to go. And the other thing that really kind of helped it be popular is that Canada gets cold. And the SKS does not shut down. It doesn't suffer at all, including really cold weather. So if you go up into the Arctic, you'll see people with an SKS because it still works up there just fine. They're everywhere. There's like hundreds of thousands of them in Canada, and a lot of them are on reserves being used by Indigenous hunters. So banning the SKS is going to end up putting a lot of Indigenous Canadians in jail.
Is that something they're considering?
Yeah, it's on the list, specifically named as a gun they want to ban.
Nice. Well, I'll tell you, that's I don't know. I mean, it seems like the gun grabbers are on the move all across the world. And, it's interesting, when Ukraine got invaded, all of a sudden everybody was grabbing for the nearest firearms. They were handing them out like candy on the streets because they needed the citizenry to be armed all of a sudden, right? Because of external invasion. So it seems to me that that's sort of the Swiss-Israeli model is a good self-defense model for countries. But I don't know. It doesn't seem like that gets thought about until crisis is upon us, right?
Well, I get people saying, they're friends of mine saying, "Oh, well, I'd stand up to defend, my country," and it's like, how? With what?
Right.
With what training? Like, you don't even know how to change a magazine. Like,
Right.
you'd be spending 20 minutes trying to figure out where the safety is.
Well, that's one of the nice things about the SKS is it's built to be understood by peasants.
I really like how the one tool that you need to disassemble it is a cartridge.
Right.
Because if you don't have a cartridge, then there's not really much point cleaning it. But if you do, you can take it apart, you can field strip it, you can do whatever you need to do.
Well, now, I just got back from Miami. We had a meet and greet with Nick Requeta, and that was a lot of fun. Got to have dinner with Nick and his wife, and I just wanted to. So I'm sort of behind the eight ball here, Andrew. So you're gonna have to catch me up. So what's the Cliff's Notes summary on our trial here? I saw one day, but obviously I'm dodging in and out. What's happened so far?
Yeah, I'll do that. Before I do, though, I do want to, of course, mention the sponsor of today's content because it directly involves you, Steve, and that is our American law courses, for which Steve is a professor. These are law school level courses, typical first-year law school courses. Steve is today is his last criminal law class of the fall semester, 14 classes under the belt. The students will be getting the final exam, the optional final exam, but you have to pass it to get a certification. And in the spring, we start with evidence and property. They start the second week of January. We're still in the pre-registration stage, folks. You can save 50%, over $1,000 for each of those courses. And they're taught by absolute experts in their fields, evidence and property. So if it's at all of interest, I would encourage you, I guess I should remove that banner so you can actually see the correct URL. And I should move this around too.
Move that around. Yeah, there we go. That's there.
So you can go to American Law Courses. And after the spring, after evidence and property, we're looking at a criminal justice course in the summer, constitutional law, and criminal law 2 or criminal procedure in the fall, and much more to come moving forward. So a law school education at a fraction of the cost and time of law school without the toxic politics of law school. We just teach traditional American law in the traditional American way, and proud to have Steve as our criminal law expert for those.
And I must say, I've been promoted to provost.
Provost.
And you are the provost. I think that's a sufficiently vague and term to encompass all kinds of duties that may come my way from the dean, of course, assigned by the dean, which is the top square.
Well, I'm very glad to bestow you with the provost title. Steve,
Thank you very much.
Steve's doing a lot more for these American law courses than just teaching. He's also facilitating and bringing on board other professors, helping us develop this whole program. And that's what a provost is supposed to do. So it's perfectly appropriate. All right. So for this case, what we have here is a 28-year-old black woman is babysitting her 8-year-old nephew in their home. It's 2:30 in the morning. All the lights in the house are on, at least in the front of the house facing the street, and all the doors are open. From 10 p.m. to 2:30 p.m., all the doors are open. The neighbor across the street happens to be a black male. Elderly black male, older black male. I guess elderly is probably too strong a word. But he gets a call from his sister, who also lives on the same street, says, hey, the people across the street, they've had their doors open for hours. It's cold. It's 40 degrees. It looks suspicious. He walks across the street. There's no apparent explanation for this. He doesn't want to go into the home or even knock on the door because he's afraid he'll startle them and get shot himself. So he goes back to his house. He calls the police, reports the situation, house with the doors open. That's an open structure call to the police, which is treated as a burglary in progress call. 2 officers arrive on the scene, the defendant and a female backup, and their standard procedure, SOP, for the police department is if it's an open structure call, burglary in progress, you do not announce yourself until you've had a chance to look the scene over. They get up to the front doors of the house. They're being quiet, as they're supposed to be. They're investigating. And within about a minute and 15 seconds, they've moved around to a side window. And someone on the other side of the window inside the house raises a pistol at the male officer. He says, show your hands, and immediately fires a fatal shot. Single fatal shot, strikes her in the heart, and she's dead. 2 days later, he's charged with murder. And that's what he's on trial for now. 3 years after the event, there's been a lot of delays in this case. This happened October 2019. So he's on a murder charge. It's a first-degree felony in Texas. It's good for 99 years. His legal defense, of course, is self-defense on the facts of these case. And a lesser included to intentional murder is reckless manslaughter, which is a second-degree felony, good for 20 years. So the state either has to disprove his claim of self-defense beyond a reasonable doubt, or prove recklessness beyond a reasonable doubt. So far,
Oops, sorry.
Oh, was that you, Steve? Okay.
Now you're muted.
So far, I haven't seen any evidence from the state. We're still in the state's case in chief that would support either of those legal conclusions on the merits. Of course, in any case, there's a risk you get convicted no matter how innocent you are. Juries are dangerous and unpredictable creatures, and that's without having the racial dynamic we have here. White male officer shoots black female suspect who actually did nothing to deserve being shot. It's one of those situations where it looks like it's an awful but lawful shooting. In fact, she may well have been privileged to shoot him if she had a genuine good faith belief that he was, someone about to forcibly enter her dwelling. We'll never hear those arguments, of course, because she's not alive to present them. But it's a terrible event. It's a tragedy. She didn't deserve to die, per se. She wasn't engaged in criminal conduct. But based on the facts known to the officer, the circumstances in play, almost certainly he was privileged to use deadly force in self-defense under these circumstances. If you look at the chat, you'll see we have a bunch of lunatics in the chat. They're all upset about things like the officers violating the Fourth Amendment rights of the homeowner because they stepped on their property. They're convinced that unless the woman had committed a crime, it can't possibly be lawful to shoot her. Lots of emotionally based arguments independent of the legal merits. And I do have the body camera footage. In fact, we just looked at a portion of it, but I can pull it up again and I'll play it for you, Steve. It's very quick. It's only about
Right. Well, I remember I did cover part of the opening statements and the first witness, the little child witness.
Right.
So I was here for that, and we did play the video. So if you want to play it for review purposes, we can. But I've sort of I've been dodging in and out because of conflicting duties. But if you want to show it again, because I know that this, I'm not sure where we are in the sequence of things. It's your show.
Yeah, I'll go ahead and play it. We did play it just a few minutes ago, but I'll play it again. And it starts with the officers at the door of the dwelling. They don't announce because their policy is that you don't announce. And within about 1 minute and 16 seconds, that's when the shot is fired. So it all happens relatively quick. So let me pull that up again. And let's see, make it a little bigger. Oh, I guess that doesn't really help. Does this help? Not really. All right, I'll just play it like this. So the house is in disarray. There's stuff all over inside. The female officer says it looked to her like a burglary, like the house had been ransacked. All this stuff outside is stuff the female officer said you'd expect to get stolen if it was left outside in this neighborhood. So it didn't appear normal.
Yeah, there's kind of garbage all over the kitchen,
Yep. Now, the front of the house is really well illuminated. All the lights are on inside, but as they get around to the rear of the house, the internal rooms are dark. Apparently it's a bedroom. She was playing video games in there. The cop has a handheld flashlight in his left hand, now that he's in a dark area, and he's got his pistol in his right hand. At least when he gets up to the window where the shot is fired, his pistol's already in his hand. That was the female officer there. They're clearing the cars. He's going to walk through a little gate here, and once he's through the gate, the window's on his left. And when he turns to his left, now he's kind of pinned between the gate and an air conditioning unit. And his partner is directly behind him, inches behind him. So there's not really any place for him to go. And here it goes quick now.
Put your hands up! Show me your hands!
There you go. That's it. 1 minute, 15 seconds, 16 seconds from when they're.
This is such a horrible, horrible situation, and I think the first thing we have to say is that the victim of the shooting, the woman in the house, did nothing wrong,
right?
And that's what makes it so horrific, because anybody can see themselves trying to defend their home as a Second Amendment firearm holder. But that does not necessarily mean that the police officer was acting criminally. And that's a hard thing to kind of wrap your head around.
Right.
Because it's like, well, it was wrong. She shouldn't have died. This was ridiculous. And all of that's true. But then now we're talking about holding somebody criminally liable. It's kind of like, I compared it to an auto accident. If you get into an auto accident, not all auto accidents are criminal. And so if you're driving drunk, then that would be, you kill somebody, all right. But or if maybe if you're driving recklessly, speeding and going crazy, but what if accidents do happen, and if this is an accidental shooting, a justified accidental shooting, because it's really, is it self-defense or justifiable use of deadly force? If somebody points a gun at a cop, it is justifiable use of deadly force. Now but you have to add in that factor if she is inside a home, but he's coming upon the situation thinking there might be some sort of home invader situation.
Right.
And so it's a real tough spot for that police officer to be in.
I mean, there's a reason the policy is not to announce, and it's because you don't want to turn a burglary in progress into a hostage situation.
And we had a debate about this last time we were on, is that people say, well, I don't like that policy. And I don't really like the policy either. It's between you and me. I would rather not. But there's trade-offs. There's benefits to that policy and there's downsides to that policy. And like if you change it, you said you have to announce. Well, there's benefits to that policy and there's downsides to that policy. So so it's not like there's no perfect solution here. And that's what people want, the answer and the perfection. But law is messy. Yeah, very difficult.
Yeah, because we had a bad outcome, right? None of us likes a bad outcome.
Right.
Everyone would be happier if this woman were alive. Nobody wants her dead. That's not a good outcome. And when there's a bad outcome, we want a solution. We want a reason why this should not happen. And maybe there's a solution for the next case, but whether there is or not, this individual defendant has to be judged based on the rules in effect and the totality of the circumstances in place at the time he made that decision to use force.
I just remembered, has there been any evidence about the police policy on this yet?
Yes. Yep. So we had yesterday we had the female backup female officer, and she testified at length, 2 hours 40 minutes on direct and redirect, and maybe an hour on cross and recross. And everything she testified about, and she's a state witness, of course, called by the state. It's still the state's case in chief. Was consistent with the defense position that, listen, this was reported as a open structure that's treated as a burglary in progress. We're not supposed to announce. Everything she was saying was this. It looked to me like the house had been burglarized, was subject to ransack. It was all consistent with a reasonable perception by the officer that, by the defendant, that he was intervening in a burglary event, or at least could be. And they were investigating, as they're supposed to investigate, to clarify what was going on.
And even if they'd known it was the homeowner, I mean, you can still get shot by the homeowner, and the police may be in a situation of self-defense there. That's not the situation we're in, but I see people in the chat going, oh, it's, you should have known it's the homeowner.
How would you know that?
I don't know how he would know that. Right. But assuming that he did, would that, boy, this is a in the weeds question for Andrew. I'll ask the hard questions for you. If the cop did know this was the homeowner, then would there be a duty to retreat on a cop? Would a cop ever have a duty to retreat?
I mean, I just don't know how the cop would know it was a homeowner.
Well, but now forget that.
Retreat wouldn't apply here anyway, for a number of reasons. One is, even if there were a legal duty to retreat under Texas law, the legal duty only applies if it's practically possible. You can't have a legal duty to do the impossible. He had an air conditioner to his right, he had a fence to his left, and his partner was standing immediately behind him. So there was no place for him to go. In any case, under Texas law, normally it's a stand your ground state. In fact, it's a hard stand your ground state. The jury's instructed that they're not allowed to even consider the possibility of retreat in the context of deciding whether or not a use of force was reasonable. The only avenue I could imagine would be, would he alternatively have acquired a duty to retreat because he was recklessly creating an unjustified risk of death? But I don't see that, because while his conduct may have been creating a risk of death, right? You sneak around someone's home in the dark at 2:30, outside their home in the dark at 2:30, and may result in the use of guns. But would it have been an unjustified risk of death, which is what recklessness requires? Under these circumstances, an officer responding to an apparent burglary, sneaking around the house, is not only justified, it's required. It's in his standard operating procedures.
Yeah, well, and this is why the procedures are so important, because in my view, and I think this is the correct view, that procedures are there to protect the innocent officer, because you'll have officers who are given a very difficult job, and their job is to basically run headfirst into dangerous situations, and with using and sometimes use deadly force. And if they follow procedures, that should give them some cloak of immunity from this type of criminal prosecution. Now, I know we talked a little bit when the little kid testified, who was a compelling witness, but he changed his story to say, oh, she never picked the gun up and pointed it at him.
Right.
And that is the thing. It's like if she's got her gun by her side and he shoots her down with the guns by the side, then that's recklessness, right? So, but I still don't see first degree murder here. So I don't see how they're going to get to first degree murder. I mean, maybe the judge will JOA it down to a negligence standard. I don't know.
Well, I mean, it's right. So it's first degree murder that you can escape, that you can escape liability for if you meet the conditions of self-defense. I mean, it's an intentional killing. He didn't shoot her by accident. The gun didn't go off by mistake. He intended to fire that round into her chest, which would normally be a crime, right? We're not allowed to just shoot people in the chest unless it can be justified as self-defense. And he's certainly...
Or you're in Canada.
Or you're Canada, right? I don't know how
Canada, actually, there's a fair amount of case law of people who get acquitted, including in situations where they are dealing drugs. Somebody rolls up on them and, points something that turns out not to be a gun, but they fire. And, there's a lot of acquittals. It's just you can't carry the gun in the first place. So most of our self-defense case law is actually things like gangsters with guns, because they're the ones who actually have the means to defend themselves.
Right. Yeah, and then they had the testimony. So the first witness, quote unquote witness, yesterday was actually the forensic video interview of the kid 2 hours after the event, where he says,
okay, right.
My aunt pointed the gun at the window. And apparently he could see there was a badge outside the window.
Well, and people may wonder why the state would introduce such evidence. And the reason is because generally the state is going to orchestrate all the evidence. They're going to put it together. If they don't put it in, then the defense gets to put it in and say, aha, you see, why didn't the state didn't want you to see this? So it's better to get the bad news evidence out up front and control it within your state's case and buffer it with the other evidence so that you can tell your story with the evidence as it stands. So generally a prosecutor will put in all the evidence, even the stuff that hurts them. Like a lot of times they'll bring in like DNA and fingerprint experts when it's inconclusive. And people say, well, why did you bring that in? Because we're here to present all the evidence for you, and you don't want the defense to get up and call the state's fingerprint expert and say, we found fingerprints and they were nothing, right?
Right.
So,
or the flip side of that, to just say they didn't even, you've heard nothing about fingerprinting evidence. Did they not bother to investigate this?
Well, except that that's true, but what you would do as a defense attorney, if the evidence is inconclusive, you would bring it in your case in chief. You cannot argue that evidence exists, at least in Florida, and it may be different in other states, but you can't say, why didn't the state call X, Y, and Z if the defense is in the same position to call X, Y, and Z? So you can't use the failure to call as evidence against the state if you have the same opportunity. I don't know. Is that common around the country? I know that's a very, okay. So, but generally, if the state leaves something out like that, the defense calls them, and then it looks bad for the state. Like they didn't want you to see that they tested for DNA, and look, DNA said nothing here, right? It's you want to defang the defense as much as possible if you're a prosecutor. And so that's why they're bringing in all the evidence, like even the one with the changing testimony. I'll bet. How did the defense do on the cross of that one, though?
Well, that was a video, so there was no real cross.
Oh, just presented it. Yeah.
Right.
They didn't bring in the interviewer then. They just played the video.
No, they didn't. Yeah, I guess they must have just, the parties must have stipulated to just having the interview. And of course, it was 3 years ago, so maybe the person who did the interview is not even available anymore. Who knows? But another witness they called was the neighbor from across the street who made the call, the non-emergency call about the open structure. And he testified. He obviously called because he thought it was suspicious, right? So there's another person who had, there's good reason for this to be suspicious. All the doors and lights on, doors open, lights on at 2:30 in the morning, have been for hours. He walked across the street to take a look, but he didn't knock on the door. He didn't call out. Why? Because it was dangerous. He was scared himself that he might startle somebody and get shot, which just is consistent with the officers acting in a way where the scene could be dangerous and not simply treating it like a welfare check, which it was not. So really all the evidence I've heard from the state so far, I mean, the only little exceptions are things like the state gets real nitpicky. Like, did the officer, before he fired a shot, did he shout gun? Aren't you supposed to shout gun to alert your partner that there's a gun in play? But between the verbal command and the shot was, I don't know, a second. I mean, you can only say so many words.
Yeah, that was so fast between sees her and, reacts. And he's shouting a different verbal command. It's because if he's yelling gun, then he's not yelling drop. Like, that was
another really good point that you made, Andrew. And you've trained police, I know, before. And that is verbal commands, the way the cops, like, they get in these high pressure situations and they start shouting things out.
Right.
And it doesn't seem like there's any kind of training or discipline on what the commands are. Could you talk about that a little bit?
Yeah, I mean, it just mouth noises just start coming out of their faces. It's not actually like coherent commands or communications, and it can lead to bad results. Like here, he's shouting, "Show me your hands." Well, maybe she was trying to obey that command and raise her hands, and in doing that, she's raising the gun that's in her hands. Would freeze have been better? Would drop the gun have been better? I mean, maybe, but you have a second to make a decision. My sense is they're just not adequately trained on how confusing and ambiguous these verbal commands can be if they're not thought out and appropriate for the circumstances. Here in the U.S., we had the Daniel Shaver shooting, which is a guy who was pointing an apparent gun out a window of a hotel, I believe he was in. Someone saw him. They called the cops. A bunch of cops showed up with rifles. And this guy ends up crawling down the hallway of the hotel, receiving a barrage of orders, different instructions from different cops, and he's probably just trying to obey the instructions. But obeying one cop involved, he was crawling along, and he was wearing like gym shorts or something, and they started sliding off his body, crawling along under the orders of the police, right? Crawl over here. And his pants start sliding off, so he reaches down to his waistband to pull his pants up. And of course, once he reaches for his waistband, the cops, it's a man with a gun call. They presume he's going for a weapon in his
but
waistband.
that is the most ridiculous. Those cops didn't even get charged. If that wasn't, to me, that was such a murder charge. That video upsets me so much. And the fact, I don't think those cops got charged. And have you seen that, Runkle? Have you seen that video?
I have. I was just like, what do you do at that point? Because there's literally not, I mean, what's he going to do? You got people shouting different commands,
and he's crying. He's like, he's doing everything he can possibly do to comply. And these guys are all jacked up on steroids or whatever, yelling, thinking they're great because they got guns on somebody. And they are so trigger happy. That was the most absurd, obscene shooting I've ever seen. I don't know if anybody's seen that else in the chats, but that was in Las Vegas, wasn't it?
I believe it was Las Vegas. So it would be nice if the cops had training on, hey, let's not have multiple people shouting commands, right? Who's ever senior on the scene or whoever's best positioned or whatever they think the appropriate policy should be, one person is shouting commands so they can at least have a chance of being coherent.
But all of that training falls apart too as soon as you get people with adrenaline. Like once they start thinking this guy might have a gun. I saw a video elsewhere of a guy who the police are rolling up, and it's a similar, everybody's shouting things at him, and the guy just starfishes out on the ground and is yelling back, "I'm not doing anything. I'm not doing anything."
Right.
And the cops get really upset because they're like, "You need to come here." And he's like, "Nope, not doing anything. You can come to me. I'm just," and he just keeps like arms and legs spread eagle. And eventually the cops come up and, sort of rough him up a little as they're arresting him. But I'm going, that might have been a better approach. It's just, you saying crawl over there. You're not going to shoot me for not crawling, but you might shoot me for moving the wrong way. So he was just like, I'm not moving at all. But
it's really ridiculous that this is the level we have to be at. But I watching that Las Vegas shooting, I don't know. It's hard because these things are so dynamic. And of course, the police are trained with the crazy situations. And we talked about this too, about the guy who's acting crazy. He's dancing. He's like, shoot me. And then he goes in his truck and gets the rifle. And the cop didn't want to kill that cop didn't want to kill somebody. I don't know. These are very tight calls. But see, this one here
and that cop got killed.
Right. And so every police officer,
he just kept shouting, "Stop, stop, 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 stop." And the suspect just retrieved the rifle out of his pickup truck and loaded it and apparently he'd been in the Army, knew small infantry tactics, and just just killed that cop.
Yeah, that was a horrible situation. Well, going back to this case, I don't know. This was Texas though, right? Is this Texas?
This is Fort Worth.
So it's big city Texas.
Right.
Yeah, I don't know. Big cities.
But it was pretty obvious. I mean, right away, within 48 hours, this cop was fired, charged with murder. Given the racial dynamic of this case, white male police officer shoots a young black woman babysitting in her home. The prospects that this would, the politics compels a prosecution, regardless of independent of whatever the legal merits might be. On the legal merits, I don't see it. But all those people making the decision on whether to fire this cop, whether to charge him, they're all politicians ultimately. They're the police chief, they're the prosecutor's office, they're the mayor. I mean, there are protests out right now outside the courthouse for this case, claiming some kind of, that this is institutionalized racism and so forth, even though there's not a scintilla of evidence about any racial animus or racial motivation here at all, as there typically isn't.
Now, I've got to run, but if you're still going and if you're still inclined to have me, I can try to pop in when I get back. But
all right.
Thank you for having me.
Hey, nice to meet you, Runkle.
Thanks, Ian.
Nice to meet you. Cheers.
Runkle, I love that name, Runkle on the Paley. Yes. Thank you.
Take care.
Cheers.
Well, I'm told there were protests Monday in front of the courthouse. I don't know. I'm obviously not physically present. I'm here in the Denver area.
In this case,
yeah.
Protests. What's to be I mean, I don't think this cop was happy to shoot somebody. I don't know. I mean, I guess that I'm just seeing these things as like not everything is criminal. And that's something that we have a hard time. It's like, okay, somebody did something wrong or there was a mistake. And it's just no punishment. Nothing is enough until we have scalps on spears. It's not sufficient, right? I mean, if the guy's going to get fired, I mean, I'm sure he's terrible. There's going to be a big civil suit. There's going to be lots of money paid. There's a dead person. Okay. At what point is it enough? I'm just seeing, I just don't see this cop as being from what I've seen in other cases that have not been charged. And then this guy's getting charged. I don't know. We'll look at the other one. What was the woman who was a taser woman?
Yeah. Kim
Potter.
Right.
Yeah.
So this is right after the event. So if there's not protests today, there certainly were at the time, which makes this a politically energized case.
The voices are loud.
There's no requirement under the Sixth Amendment that an impartial juror is a juror that has no awareness about a case.
All right, so they're talking about they were trying to get a change in venue. The defense was because of all the publicity and all the protests and so forth. So certainly there have been political activities.
But this sloganeering and this protesting, that's just emotional sloganeering. Okay, so
right.
No justice, no peace. Okay, what is justice here? Is justice to hang this cop's head by a pole? I mean, is that right? I mean, that's
right. See, because unfortunately, many people think of justice in terms of some outcome that they desire, and if they don't get the outcome they desire, justice was denied. But justice is not the outcome, folks. Justice is the process. Like in this particular case, I mean, first of all, this defendant, this cop, he's no friend of mine. He's not my family. It doesn't mean anything to me personally if he gets convicted. And frankly, while I don't see a conviction on the legal merits, there's noise in the system. Innocent people get convicted. What I really appreciate about this trial so far is that the process looks to be extraordinarily clean. And I care mostly about the process. And then if it's a clean process, it goes to the jury. If it's a fair and impartial jury and they decide in their judgment that it's a guilty verdict, well, that's the way our system is built. I don't have any problems with that per se. But where I get troubled is when I see trials taking place in which jurors are misinstructed in the law, or the judge just doesn't do his job, or they're lied to about the evidence, or the jurors themselves are not unbiased and impartial. They're political activists who lie themselves onto the jury to deliver the outcome justice that they demand. Those things are extremely troublesome. But if we have a clean process, and that appears to be the case here, well, then the verdict is ultimately in the hands of the jury.
Right. And what you just said is exactly the point. And that is justice is a process. It is not an outcome. And this is what people forget. I mean, if you convict somebody using an unfair trial, then that is an unjust verdict. Even if it's, say, the right verdict, if you give it unjust, like, well, so our system we crank through is a dictatorship, and we're just going to dictate somebody guilty. Well, but the guy was guilty, right? And no process was respected. In a free society with a constitution, with an adversarial system, the adversarial process has to be respected. That means the judge is an impartial arbiter. The prosecutor should be an advocate for truth and the law, and following the law, and the defense attorney should be an advocate for their client and the zealous advocate for their client. So those roles need to be respected by all the parties. Now, I remember this judge, and I remember him being pretty authoritative and pretty good. Was there ever any follow-up on the coaching of the witness from the galleries issue that we saw?
No, not that I've seen. If it happened off camera. He swore her as a witness, maybe just to compel her not to, to be prohibited from talking to anybody. But I mean, normally what you're not allowed to talk about is your own testimony. She didn't testify. So presumably it does something for him. I guess it gave him a reason to kick her out of the courtroom, because as a witness, she shouldn't be in the courtroom. Not that he needs a reason, really. He can kick anybody out of his courtroom he wants. Arguably, with the exception of family members, I think they might have a statutory privilege in Texas to be in the courtroom. And of course, the jurors have to be there, and the defendant, well, the defendant has to be there unless he makes a really compelling reason for why he shouldn't be there, I guess. Like we saw in that other crazy trial, the Waukesha parade.
Right. That's nutty guy. Well, this is not that. I mean, and I think that we had I haven't really seen enough to see the defense attorneys I saw the one prosecutor had that sort of angry middle-aged female prosecutor look about her that I've seen way too often. But has the defense attorney been adequate? Has the defense attorney been on point so far?
Everybody's been good. So the prosecutors have been good. They've been pretty clean. The defense, I think, has been, I was going to say great, but it's really unfair to give them a better rating than the state, because I think the state has very little to work with. So they have to kind of flail around a little bit and try to make something out of nothing. So lots of irrelevant questions, lots of why are we talking about this kind of stuff, because this is their case in chief. They're presenting witnesses. They can't have them up there for 3 seconds and then dismiss them. Their case in chief would be over in an afternoon. Right. So it feels like they're often engaging in questions that don't really matter, but they're just doing it to kind of pad what they can talk about at closing.
Right. Well, and this, we talked about this too, and this is something that people do not understand about criminal prosecutions and trials, is that everything is geared towards having a trial and in presenting a case and letting it go to the jury. And so if the state can just get over the hump just enough, just to say, okay, if you believe this little sentence, but this thing person said, that's enough to get you to the jury. And once they do that, then it's all emotion. Then it's all showing, crying mothers and crying victims and sad police people. And then it's just all this emotional argument, which is what we saw in the beginning of the case, I know, was this big emotional appeal. And it's a tragedy. There's a lot of emotional impact in the case. That should not be part of the analysis, but that is the way the state gets a lot of convictions if they've got a weak case, because they don't hit the facts or the law. They hit the emotional thing, and they get it just enough. Well, if you believe that she put the gun up, like the kid's changed testimony that he pointed the gun at him, that's enough, right? Did not point the gun at him, right?
Yep.
Yeah.
Yeah, we heard from poor little Zion Carr, 8 years old at the time, that his aunt never pointed that gun at anybody. I mean, it's,
but this was 3 years after that he said that she did not, or she did, right?
Right. That's correct.
So he changes his testimony based on discussions with prosecutors that were unrecorded. And now, but that's enough to get him to the jury now. So that little bit of change.
Right. And that's what the state's opening was like. So the opening was 20 or 25 minutes, and it was 95% how cute the kid is. He helped make the hamburgers for dinner, and the hamburgers burned. That's why the doors were open in the house. And she was a lovely woman, and she was going to be a doctor and all this kind of stuff. And then at the end, she just kind of summarily says, so we're going to show you, the jury, that this was murder, it was not self-defense. Thank you very much. I mean, there was nothing on law or evidence-based in that opening to speak of. Whereas the defense their opening was about the same length, 20 or 25 minutes, but much more substantive. Here's the fact, here's the law, here's the fact, here's the law. That's why it was reasonable. This is the totality of the circumstances. This is why they did what they did. It was a burglary in progress call. They're not supposed to announce. They can meet deadly force with deadly force. But of course, it was more substantive because they have more substance to work with.
Well, and as you said earlier, tonight I'm going to be doing the last module in our criminal law class. And in that class, I'm going to be teaching death penalty. And it's kind of the penultimate class that we've been leading up to the whole 14 modules. And people don't realize that another thing about the death penalty is that they look at the big glory serial killer murder cases. But what happens is it trickles down into everyday trials. So like this case, for example, could be a first-degree murder case. They could ask for the death penalty, theoretically. And then all of a sudden you've got this slim modicum of evidence that, if believed by the jury, is enough to convict. And then you have this emotional appeal. The jury convicts, and you get a death penalty on a case with this type of slimness. And it's like, well, that wouldn't happen. No, it happens a lot. And that's one of the problems with the death penalty. And we're going to be talking tonight about problems with the death penalty, reasons to have it and reasons not to have it. And so pro and con, and then the weaknesses of each side, because it's easy to say, I'm for it, I'm against it. But to really look at both sides, that's kind of what lawyers do. And of course, we've been trying to do that this whole criminal law class. And I know that's what they teach you in law school, which is what we're infusing in our law self-defense classes, in the American law courses classes.
And yes, speaking of which, they are, of course, the sponsor of today's content. I think I have a nice little banner right here. Indeed I do. American Law Courses. These are law school level courses in the traditional first year law courses. Criminal law. Steve's just finishing up criminal law for the fall semester. Last class today. Then the students get the final exam. In the spring, we're doing evidence and property. And then moving forward from there, we're looking at criminal justice. We'll definitely do constitutional law, criminal law 2, or criminal procedure, whatever Steve decides to call it, in the fall semester. And we'll continue to proceed from there. So you can take law school level classes at a tiny fraction of the time and cost of law school, and without the toxic politics of today's modern law schools. And we are in the pre-registration period for the spring semester with our property and evidence courses. So you can save 50%, over $1,000 per course, folks, if you sign up right now during this pre-registration period at AmericanLawCourses.com.
And the neat thing about this, and I'm the provost, so I can talk to the academic side. I love it. I've never been a provost before, but one of the neat things about this is that you get is that if you go to law school, you have to quit your job. You have to devote 3 years of law school studies at some residential thing. So you're not getting paid. You're paying out through the nose for tuition, room, and board. You then have to sit for another 6 months of study before you take the bar exam, which you may or may not pass, right? And then you've got all this time and commitment. Whereas the neat thing, what we're doing is we are replicating the first year law school experience, which is really the meat and potatoes of law school anyways, where you don't have to quit your job. It's a fraction of what you'd pay. You do it online and at night. And you get interaction with, we're really focusing on recruiting great professors. Of course, yours truly, but also we've got some really good other folks on it. So we're going to get great teachers. So you're guaranteed great teachers, guaranteed to have fun. It's almost like the pure love of learning. So if you're interested, and some people, like, maybe they're thinking, I've got this job and I'm an accountant, or I'm a bookkeeper or something, or I'm a paralegal, and I've thought about being in law school, but I don't know if it's for me. I don't know if I could handle it. This is a great way to kind of test run it too. Or if you're going to go and you really want to leg up on law school, boy, if you come in with this stuff, you will be the top student in your class.
Yeah, for sure. I mean, of course, Steve knows this, but for folks who haven't been to law school, for most of us who go to law school, the first time we're exposed to criminal law, criminal procedure, constitutional law, evidence, property, is when we're taking the damn class and getting graded on it. That's our first exposure. If we'd had the opportunity to take these classes before law school, law review would have been easy. I mean,
Right.
we would have utterly destroyed those courses.
So, you could, like a parent who has a child that's thinking about law school, this is a good way to see what you think, see if you're good at it, see if you would enjoy this. Because the thing about being a lawyer that I really like is the academic side of it. I mean, it is interesting subject matter. So when I go to work, I'm dealing with things that are interesting every day, just like people watching these trials. I mean, this is really cool. This is high drama. And it's very interesting legally, it's interesting factually, and that's the substance of what you do as a lawyer, unless you're in private practice when you're trying to make money half the time. But as a public defender, I mean, this is what we do all day. We deal with cases, deal with clients, try to figure out the right way to approach it, strategies, law. It's interesting, and so that is part of the joy of law, and this gives you that joy without having the grade pressure on you, or the bar pressure, or the financial pressure, or any of those things. It's just the pure love of learning. So
Yeah,
really
and these
enjoying
classes
it.
they're taught one night a week over a 14-week period. They're live streamed, so they're live classes. You get to have plenty of Q&A opportunity with the instructor for anything that might not be clear. Plus, you also have access to the recording of each class for, I think, a year from the start of the class, or a year from the end of the class, I forget. But you have, so if you have a conflict, a scheduling conflict, you can't make a live class, the recordings, they're available for you within a couple hours after the class. So it's easy to access the materials. There's not a lot. By the way, another thing they do in law school is make you buy hundreds and hundreds of dollars of textbooks. We don't have to do that in our courses. So we make the content very, very accessible financially, schedule wise. And we're offering 2 classes in the spring, but that would be 2 nights a week. If you take both, you could take either one of them if you want. You don't have to take both. And if you really want to save money, I would suggest you sign up for the entire curriculum, because then the per class cost just crashes. It becomes incredibly inexpensive to be a student of these courses.
Or you could, like, what you could do is you could sign up for one class and see what you think. And if you like it, then get into the bundle, because
Right.
but the bundle is a tremendous value. But like you say, if you just want to dip your toe in, how much, because it is kind of a commitment. I mean, it's a time commitment, it's a financial commitment, but still, I mean, think about the commitment of going to law school. Right? It's ridiculous. So this is a way to, I mean, what other way would you do? Like, is law for me? How do you really know? And this is a great way, an inexpensive way, an affordable way, a fun way to get into it and see if it is for you. So I'm real excited about being involved, and thank you for letting me provost your American law courses. Look at the logo. The new logo is cool, by the way.
Right.
Let's see.
Yeah,
Well,
I would love it if the entire chat took the American law courses, because
Sure.
some of the questions would be a bit more rational and less emotional than they
well,
tend to be.
yeah, well, but people, that's part of the fun of the chat. Being a chatter myself, one of the things that somebody had mentioned about burden of proof. Now, my understanding is, and this is Texas, so it's a different jurisdiction, but I'm sure it's the same. Once validly raised, the state has to disprove justifiable use of force beyond a reasonable doubt.
Right.
So in this case, do you believe that with the policy that's been put in, that the defense needs to put on anything? Has the justifiable use of force instruction been put at issue, or will the defense have to put in some evidence to meet their burden so that they get that instruction now?
Well, so the defense has to meet what they call a burden of production, which is a minimum, basically just a very minimal level of evidence in support of self-defense before the judge is required to give a self-defense instruction. But that doesn't mean they literally have to produce the evidence themselves. The evidence can come from any source. And it looks like there's plenty of evidence here in the record about the gun being raised, right? We had the kid's own testimony in the forensics video, the circumstances and the hours of testimony by the partner. We have the body-worn camera video that was admitted. So no, I don't think they have to. With the gun was recovered from the victim beside the victim's body. I think there's plenty of evidence here to support to meet the burden of production, support the self-defense instruction. The bigger question is there any evidence from which the state has a hope of disproving any of those elements of self-defense beyond a reasonable doubt? For our purposes, there's up to 5 elements of a claim of self-defense, folks. In Texas, on these facts, there's really only 4. Avoidance, the duty to retreat, is off the table. So the 4 remaining are innocence, imminence, proportionality, and reasonableness. And the state, they don't have to disprove all of self-defense beyond a reasonable doubt, but they do have to disprove one of those 4 required elements. Was the officer acting as an unlawful aggressor? Well, he wasn't acting unlawfully. Was he facing an imminent threat, a threat about to happen right now or actually in progress? Yes, the gun was being raised, if you believe the 8-year-old's testimony. Was the intensity of the threat deadly force in nature? Well, yes, it was a gun. That's deadly force, which privileges him to use deadly force in response to defend himself. And was he perceiving all this reasonably? Was he acting reasonably? Were his perceptions, his decisions, his actions those of a reasonable person? And based on department policy, based on what anybody would think if there was a gun being raised at them, I don't see the state being able to disprove reasonableness. So that's the self-defense justification, the legal defense against the murder charge. The lesser included of reckless manslaughter, strictly speaking, whether or not self-defense can be a legal defense to a charge of recklessness, because normally it's a defense to something you intentionally do, not recklessly do. But even if it's not, the state would then have to prove recklessness beyond a reasonable doubt. That would be an element, obviously, of reckless manslaughter. And recklessness is the unjustified creation of a risk of death.
But see now, but this is where we get into the modicum of evidence that, if believed by the jury, will get it to the jury, and that is the changed testimony of the child that says she did not raise the gun at the police officer. If you believe that changed testimony of that child, then you can say that the officer was not acting reasonably in firing, and therefore you get past that one piece of the 5 elements that is sufficient to defeat the justifiable use of force argument on part of the cops. That's why that changed testimony is so damaging, and why any police or any prosecutor interrogations of children should be recorded, because how did that testimony end up changing? The defense has no power or no ability to investigate why that testimony changed. Problem.
Yeah, and of course, the kids had 3 years knowing that his family was filing a $10 million lawsuit against the department and against the state. And if his testimony changes, as it did, to say that she never raise the gun against the officer, well, that's favorable to the civil suit. I don't even know if that needs to be explained to him. We're talking about $10 million. There's an incentive to change your testimony.
Well, and ultimately, the parents can put a lot of pressure on a kid, and ultimately your memory can be changed. This is something we covered actually last class in junk science, good science, junk science, the module, which was module 13, which was, I think, one of the best modules we did. I must say, we had so much fun on that, and I borrowed. What should I say? I gave a presentation that was given to me by Dr. Brian Cutler, who is an expert, eyewitness testimony expert, and an expert on memory falsification and how our memories can be changed. And then what happens is, by influence, by external forces, and then we actually can create memories. And then what happens, once the memory is created, we can say, oh no, I'm looking back and I remember it for sure, when that memory did not exist before, but we create it to bridge a gap or for some psychological reason. And then then certainty becomes, because you can actually visualize the memory, which is a strange phenomenon. And that's what can happen.
And if you put that person on a polygraph, they'll pass.
Well, they believe it, and you will remember it yourself. Right. Yeah.
It's memory is fluid, folks, and especially things that happen under stressful circumstances. Those memories are particularly fluid and frankly unreliable. It happens all the time. People are involved. I mean, for many years, I was a traveling instructor for my law self-defense courses, and I would haul with me this $20,000 shooting simulator. Let me make sure I've got the screen open for the courtroom. Okay. Basically it just projected an image, a video, typically 60 seconds, 90 seconds, maybe 2 minutes in length, of a character, an actor, but a character representing a potential aggressor. The students had a little infrared toy gun, really, and they had to solve the problem. The video would start and they'd have to use verbal commands and maybe go to the infrared pistol to solve the problem. It was up to them. And then when they were done, they had to turn their back to the screen and explain to the rest of the class. And this is after 6 hours of self-defense law instruction. Explain to the rest of the class what they saw, what they did, and why they did it. What was their legal justification for their use of force decisions? They couldn't remember what they saw, or they would imagine they saw things that weren't there, often because I would suggest it. So I'd say, all right, well, describe to us what the guy was wearing. And they'll just describe it. I'll say, well, what color was his hat? And they'll go, blue. Well, there was no hat. But because I suggested a hat, their brain kind of filled that information in. Of course, the rest of the class, not under stress, just observing, we knew there was no hat. You'd ask them what they did, and they couldn't remember. We all watched them do things they don't remember, or they can't remember the timing of when they did things. Like we'll say, all right, well, when did you present your fake pistol? They'll say, oh, when I saw the guy's knife. But no, the whole class saw them whip the pistol out the minute the video started, because the minute the video starts, they know they're being observed. There's some level of stress, even though there's no real threat, of course. And their brain just makes them get that gun out because they know they may need it to respond to the video, but they don't recall it that way. They recall their response as being the justified response, right? They didn't pull out a gun until there was an actual threat that they observed. That's not what happened. And if you can't remember what you saw and you can't remember what you did, it understandably becomes difficult to explain the legal justification behind what you did. And this was just the most modest amount of stress you can imagine. There's no real threat. The character can't come out of the screen and hurt you. So it's just that the way our brain captures and stores and recalls information under stress is completely different than our normal experience. So imagine how much worse it is if you're actually in a fight, if you've actually had to fire a shot at another human being, or you're a witness to an actual violent event. That's why people think, you imagine from TV, they always make it sound like eyewitness testimony is the best testimony, right? And circumstantial evidence is bad evidence. No, folks. Eyewitness testimony can be horrifically bad, and circumstantial evidence can be completely compelling. It just depends on the nature of the witnesses and the evidence that's available. Nothing wrong with circumstantial evidence.
Yeah, well, Dr. Cutler, you ought to have him on sometime, because I did an interview on my Rumble channel with him. It was a two-parter. And the second part, actually, it seems like my second parts of my interviews are always better than my first part of the interviews. I don't know. I'm still working on it. But he also talks about how photo lineups can be influenced, because what'll happen, and that's why there's a lot of checks on identification photo lineups. And we talked this again in the last module about all the checks needs to be done to a photo lineup, because just the mere fact of showing a picture to somebody just before the lineup can influence them, because then they think, oh, I've seen that face before, but they don't really even remember where. But they saw it because the cop just showed them a picture, and now they're showing them the picture to photo lineup, and they're like, well, that face is familiar. And so then all of a sudden, and then the confirmation, well, I picked it, I know that's it. And then they put that face on the previous memory. It's a very dangerous thing. Memory is a very dangerous thing. And people, like you said, put so much credibility on it that it becomes overwhelming. Well, the person says they remembered, and they don't have any reason to lie. They don't have any reason to lie, but their mind is not perfect. Our minds are very imperfect, especially with memories.
Yeah, the prosecutor here did something very similar, actually, which I found incredibly objectionable. There was no objection. I'm not sure why. I think it was during her opening statement. And she's talking to the jury about, this event happened, this officer fired this shot, and you know what happened then? 2 days later, he was arrested for felony murder. Mm-hmm. Like, that's supposed to be an indication of guilt, right? The jury's, well, he was arrested, therefore something must be wrong. I wasn't arrested for murder, but he was. It's so inappropriate because, of course, an arrest is not evidence, and an indictment by a grand jury is not evidence that you did anything wrong. Right.
That's putting the approving stamp of the state onto a jury trial. Like, we only prosecute those who are guilty. That is improper.
Right. So the mere fact that you're present then as a defendant in the courtroom should automatically lead to a guilty verdict.
Right. Well, that is a slip up. I'm surprised that wasn't objected to, but it's tough. Again, fallible attorneys.
And it's really, first of all, it's suggestive to the jury, but it's also burden shifting, right? You're suggesting, oh, hey, maybe if the guy's not guilty, he can prove it.
And it's also burden lowering, because the mere fact of arrest, there's a lot of ways. Usually when something's wrong, it's wrong in several different ways.
All right.
We have any super chats or self-defense chats? Or
yeah, we do. I'm sure we do. Let's see. From the Law Self-Defense memberships, David writes, we did some coding changes to our membership dashboard for streaming, and now the chat is below the video instead of next to the video. And David doesn't like that. I don't like that either, David. I'll talk to my staff about whether we can move it back to the side. It's more convenient, because right now you can really only either look at the video or the or the chat, which is not ideal. Gene asks, can the 11-year-old be impeached if he was being coached from the gallery? I think the person was removed, was giving signs, shaking her head which was to say, I don't know. Maybe. I mean, the judge wasn't happy. Obviously, he kicked her out of the courtroom. We don't know why she was gesticulating. I couldn't see her gesticulating from the camera angle, but clearly the judge saw it. Can the 11-year-old be impeached? Well, it depends on what impeached really in this context of a witness testifying just means you're undercutting the credibility of their testimony. Could you do that? I mean, that this happened? Did that impeach the?
Sure. It's a witness against you. So any witness against you, you can impeach. Now, and there's different levels. See, let's talk about if you're a defense attorney. There's different levels. What I say, in fact, I taught this in the criminal law class. So it sounds like I'm repeating myself, but it's true. You make choices as a criminal defense lawyer. Now, the first thing is they were mistaken. They didn't see it. They don't remember it correctly. Before you go to, they were a liar.
Yep.
Because liar is like, most people think, oh, that person doesn't have a reason to lie. They don't want to think somebody's a liar. Although we all know that people do lie, but juries don't want to believe that, especially of a little kid. So you usually want to step it back and say they misremembered or they were being influenced. And in this case, I think that is the go-to place for this defense attorney, is that the child was being unduly influenced by a lot of people around them. And I think that interaction within the courtroom. Now, my experience has been the jurors are very attentive to this type of thing. And so if there was somebody signaling, the kid's paying attention to somebody, juries see that. It's just like they're watching the defendant. The defendant, we tell the client all the time, you are being watched 100% of the time by that jury. And if you may roll your eyes or make statements or look like an idiot, act like an idiot, the jury is going to pick up on that. And so the better thing is to always be respectful, keep yourself as clean as possible, because you will be watched by that jury. And so I'd be surprised if the jurors did not pick up on some kind of signaling, and that may find its way back into the jury room.
And by the way, folks, some wonderful examples of soft impeachment. Hard impeachment might be accusing someone of lying. But soft impeachment is where you suggest that, maybe they just didn't see it right, or they just not recalling it right. Or of course they're trying to be honest in their testimony, but isn't it true that, maybe you weren't really in a position to see what you thought you saw can be found in the movie, My Cousin Vinny, one of the best legal movies ever made.
Yes, I agree.
There's one witness in that trial. It's an old lady who's got very thick glasses, and she wasn't wearing her glasses, or even when she's wearing her glasses, she still can't see very well. That impeached her eyewitness testimony. There was another guy who was, he observed something he's testifying about while he was cooking grits. A key element was how much time was involved. And the question was, well, do you make instant grits, or how can your grits cook faster here than they do anywhere else in the state of Georgia? Not calling him a liar per se, but saying, listen, there's something wrong with your testimony. It doesn't match the circumstantial evidence that you're otherwise describing. And all those witnesses in the movie, of course, ultimately concede that, the defense is right. Maybe I'm not quite correct about what I was testifying about. That soft impeachment completely undercuts the testimony of those witnesses, and it's well done. If you haven't seen it, I presume everybody in the world has seen My Cousin Vinny at least once. But if you haven't seen it, it's a pretty good law movie.
I'd say it's probably the best law movie that I've seen. I mean, it's right. The thing I love about it is it's exactly the way things unfold. I mean, all of those things could actually happen. It's not one of these Hollywood people that don't know law. It's, did I tell you? I had a little interesting tidbit. One of my former office mates, a fellow named Bob Wildridge, who was actually, when he retired, was the oldest practicing lawyer in Florida. And he was in appeals with me. He went to school. He was a Harvard and a Yale grad, and went to school with the judge in that case, who was Herman Munster.
Right. Yeah.
Yeah. He went to school with him because they went to, I guess, law school together. Maybe it was undergrad. I don't know. He went to either Harvard or Yale, and so did Herman Munster. So he would tell me stories. I forget what the guy's name was. But yeah, Bob Wildridge, what a character he was. He'd done everything in his life. Fascinating guy. And he retired pretty recently. Neat.
Yeah, all the law in My Cousin Vinny is pretty spot on, folks, which you can't say about a lot of courtroom dramas or police dramas for sure. They just make shit up. But My Cousin Vinny was pretty dead on.
Yeah,
and
and
Marissa Tomei was pretty easy on the eyes.
Oh, it's just so funny. The accents, the cultural clash. We showed that. So we had some friends come in from Russia, and I told them, you need to watch this because you want to understand the South, like the cultural differences across the United States, because it's also interesting for that. It's like, people, we're from the South. I'm from the South. At least Florida, as much as I'm from real South Florida, not Miami, South Florida, but like,
right.
And it's like, well, when people say Yankee go home, we're like, yeah, that's right. Yankee go home. They think they're insulting Americans. And like we Floridians are like, yeah, that's right.
Right. Get these damn Yankees out of here.
Get
Carpetbaggers.
these Yankees. They don't think that, they don't understand that that's like when they're shouting that, the foreigners are shouting that at the Americans. A lot of them are agreeing with the foreigners.
Let's see. What else? I think that's about it. What is the name of the Las Vegas situation we're talking about? We were talking about Daniel Shaver. It may not be Las Vegas. It might have been in Phoenix. Now that I think about it some more.
It might have been Arizona.
Yeah.
That was a horrific situation. Whew. That gives me chills thinking about it.
Let me take a look here at the super chats.
See, that to me was that was worse because there was so much time to contemplate by that officer. And that guy, they knew that guy wasn't armed. I mean, it's like he had already put down his gun. He didn't have anything. It was just so terrible that whereas this officer was really reacting, and this was so fast.
Right.
And guy with a gun or some figure in a dark plume that might be a home invasion situation, and they got a gun and they pointed at you, you react. I don't know. This is not I'm not impressed with this case. I don't know. People are going to call me like I'm pro cop or pro law enforcement. And, I'm a public defender and I do appellate work. I mean, if I'm going to call it like I see it, and I'm generally going to err on the side of the citizenry here. And I absolutely sympathize with the female, the person in her home with a gun. But boy, what's that cop supposed to do? Let himself get shot in this situation? I don't know.
Hey, is that the right URL for your book, Steve?
Ideas and Answers in Law, crimelaw.net. Right. So here's let's check it out, man.
I just got it. I just got in the mail yesterday. Your new.
Oh, you got the new one, the hardcover.
It's noticeably thicker, Steve. It's definitely in the hand. It's definitely a more substantial book, and it's autographed.
There's two reasons for that. Oh yeah, look at you. Yeah, there's two reasons for that. One is I've upgraded the paper. And I've upgraded the cover. It's got the shiny cover. Yep. And then I also added a chapter on prosecutorial misconduct, which I thought was kind of Florida specific. But because of the response of everybody in this, I thought I'd throw it in there and let you read, because it does have how a prosecutor should conduct a clean trial in the first part of it. And then it talks about all the ways that they can screw up a closing argument. And then it has my proposed ways to fix the prosecutorial misconduct and closing argument. That's an additional chapter in the second edition. And look at this. Look at this guy right here.
Yeah.
Attorney Andrew Brocca forward.
Yours truly. Honored to write the forward to the book.
And then on the back, we've got Nick Ricada and attorney Mike Lambert, who's been practicing law since '74. Steve Hayward, PhD. He's a brilliant professor at UC Berkeley, who I'm going to hopefully interview on my channel tomorrow. And I'll post it sometime in the near future. And then Brian Cutler, which is on my Rumble channel right now, who's the expert we were talking about, who's, I think, probably the preeminent expert, written multiple books on memory and eyewitness misidentification, false confessions. Really, so many academics. Well, and we talk about this with our law school class when we're talking about what we want to present and put together for a law school type class. Is we want the substance. We don't want like a bunch of Marxist propaganda. We want to talk about what is the law, what are the practicalities, what are the realities, integrating the law and what it is and how it's used and how courtrooms unfold, and then taking real world practical examples. That's why my friend Ryan Bellinger, who's going to be doing evidence, he's going to be great because he's done literally hundreds of trials. So when he talks evidence, he's going to teach you the evidence, but he's also going to give you real world examples without all the propaganda. So, and that's, I'm really, you know, when you first approached me about this, I put a lot of thought into it because it's like, I said, I want to do the ideal class of what I want to teach and the way I want to do it. And I said, what does that mean? Well, that means doing things that are without any propaganda, that are based in reality and not just kind of up in the head in the clouds, you know, academics talking to each other, but real world examples, integrating that with facts and law, and making something that's exciting and vibrant to watch. And from the response, I mean, we've had such a great response from our first class, and I think that it's launched this thing. So we're going to have a full first year law school, which is kind of the dream, you know, to have a boxed full law school class, and without the time commitment, without quitting your job, right?
And it's almost impossible for people to understand how toxic the political environment has become in law school. So when I had this idea for American law courses, I have all my textbooks from law school. Of course, I paid the fortune for them. I'm not going to get rid of them. But I thought, you know what, I better get the updated edition. So I have, you know, an updated library of books should questions come up. So I ordered all the new textbooks, hundreds and hundreds of dollars of textbooks. And all of them are completely pervaded with critical race theory and social justice warrior stuff that was not in those books when I was going through law school in the early 90s, but certainly is there today. And it gives a bad smell to the entire process. So that's why we don't do any of that at AmericanLawCourses.com. We just teach traditional American law in the traditional American way without the toxic politics.
Well, and a lot of this, and I got to say, it even invades some of the law when you're practicing law and you're supposed to go to continuing ed and get a box of continuing ed. Right. And I've gone to some of these conferences, and then there's always this module, which is like, you know, all the racial diversity problems and all of the, you know, discriminating history and legacy. And I'm like, okay, all of that, maybe that's a historical fact. Maybe it's, you know, maybe it's propagandized a bit. But how does that actually, how would I ever bring that in some kind of motion form, or how would that ever be useful in a court? If you brought that, you would be betraying your client. And so it's really talking about that stuff. It's not appropriate to me in a legal context, because the law is to view people equally before the law. Now, we talk about that, but then that's where the practicalities come in, because just like this case, I think the racial element here is a big driving factor, if I was to speculate, because of the fact if the races have been reversed, you might not have seen this prosecution happen, which is a sad commentary on the law, but that is extrajudicial, extra legal. And but we also talk about that as a factor, but it's not a, you know, it's not a motion. You can't dismiss the case because of that. You know, ultimately we have to have a trial. And it takes reasonable jurors and reasonable people. And being an educated citizen, part of this too is just being an educated citizen and consumer of the law, so that when you go forward, you know how to analyze things legally and analyze things impartially and rationally, rather than just knee jerk. I don't like him because he's my race, or I don't like him because he's the other race, or that's not the way that we should be thinking about things.
All right, let me take a look at some of these super chats. Rach, $5 super chat. Thank you very much. She writes, per Law and Crime, the judge ordered the cameras to be turned off. Okay, well, they must be at lunch now. Lunch has got to be almost over. It's 1 o'clock in Dallas, Fort Worth. Let me take a look at the screen. Looks like it's still paused. Duncan, $20 super chat. Thank you. Thank you very much. Law policies should not necessarily change whenever an individual gets killed. It's the messy nature of the state bumping up against individuals. Sometimes this sort of thing happens with no party at fault. Yeah, we live in a messy world with messy humans and subjective decision-making and complicated scenarios. And policies generally exist for a reason, just like a fence in a field generally was put there for a reason. It didn't just materialize. So before you tear it down, you might want to give some thought to why it was put there in the first place. There may be damn good reason for it. There's good reasons for these policies to not announce what you suspect is a burglary in progress. Might those be outweighed by other considerations? Sure. but it's not like there's zero rationale for not announcing at a burglary scene. Otherwise, we wouldn't have the rule. Chris, $10 super chat, says, to me, there's no mystery that both sides can claim self-defense. Here, the standard is beyond a reasonable doubt. That means the state may not be able to overcome that on either side. Yeah, sure. Both of these people might have been lawfully justified in using deadly defensive force.
And that is true. But the problem is if it goes to the jury is the one that has to be reasonable. The jury can do whatever it wants once it's in its hands. So we expect jurors to obey the instructions and to act reasonably and apply standards, but they don't have to. That was the issue in the Brooks trial, is that he wanted to argue jury nullification, which is asking the jury to not follow the law. But ultimately, he was correct in that the jury doesn't have to follow the law. Once it gets in their hands, they can convict. If there's sufficient evidence to go to the jury, and all that evidence has to be is just some smidgen of evidence that if believed, and that could be the changed testimony of the kid that she raised the gun and pointed at the cop, or the other way, that she did not. Oh, sorry, I can't keep getting it around. So that she did not do it. He changed his testimony to make that fact change. And so she's just wandering around in her house with a gun in her hand, but down, never threatening the cop, then he acted unreasonably, then he's guilty. So that's what the state's going to ride all the way.
Kingslayer Damocles, $5 super chat. Thank you very much. Writes, I'd like to know the political views of the kid's interviewer. So this was the video of someone who looked to me like a social worker interviewing the kid. That was played the morning after his testimony. If she was a rah-rah, thin blue line type person, I wouldn't trust her questioning of him. Well, I mean, she hasn't been called as a witness. She may not be available. For all we know, she's dead. I mean, there's a number of dead people here. The lead defense counsel for this defendant died last week. That's why Monday was only a half day, so they could have the funeral in the afternoon. So we don't know. I mean, I watched the video of her questioning. It seemed straight down the line to me. Kelly R., $10 super chat. Thank you very much. Civil suit on the district attorney for bringing a frivolous suit, and possibly to the Crump lawyer for preparing that child to change his testimony. Am I wrong? Well, we'll never know who changed the kid's testimony, if anybody did. We can only make inferences from things like incentives and circumstantial evidence. And there's no civil suit against the DA here. That's not happening. Somebody was killed. The DA can make the argument that the self-defense justification was weak, or that the DA believes they can prove recklessness beyond a reasonable doubt, in which case they have a viable prosecution. The standard's not very high, folks, to drag someone into a criminal trial. Unless even if I see prosecutions where prosecutors hide exculpatory evidence, do all kinds of things that are really contemptible, and they're never held accountable. The times I can recall a prosecutor being held accountable for misconduct on any serious level is one or two in my entire career.
Well, let me, again, going to the added chapter in the book on prosecutorial misconduct, I actually cataloged every prosecutor that had been had a ethics complaint against them for prosecutorial misconduct in closing arguments. And it works out basically one prosecutor every 5 years for the past 30 years. So there's been basically less than 6 prosecutors. I think it was 5 prosecutors had ever had any kind of sanction at all ethically over 30 years in Florida. And of those, some of them got elected to judge after that. So, I mean, you can look at that. That's one of the interesting little factoids, is that, so basically it's never. I mean, it might as well be if you've got that level. And, and when they get sanctioned, it's like, okay, now don't do it again. Right. Go take this class.
It's not like they're not disbarred.
No. So it's really, it's very shameful. And I think one of my suggestions is that there needs to be a much more rigorous ethical enforcement against rogue prosecutors, because it's way too common. There's way too little cost to the prosecution for cheating, and they are absolutely immune from civil suit. As the questioner asked, can these people be held liable civilly? The answer is no. Prosecutors are basically immune to civil suits for bad prosecutorial decisions.
Right. Even if they just lie. I mean, like in Baltimore, they had the Freddie Gray prosecutions. Freddie Gray was a street corner drug dealer who the local city representative had asked the DA's office to ask who he was married to. He was married to the state's attorney. Asked his wife to ask the police to do a sweep of this open air drug market in their neighborhood. And the cops did. They came in, a whole bunch of them, and Freddie Gray saw the cops and ran with his drugs, and they grabbed him. And he had an illegal knife on him, which I think is ridiculous, but that was the charge against him, an assisted opening knife, which they routinely arrested and prosecuted people for. So they pick him up, they throw him in the back of a van, and when the van gets to its destination, Freddie Gray has a broken neck.
Oh, right. That case,
right.
yeah.
He was fine when he went into the van. There was never any evidence that any of those officers had used any unlawful force against him, particularly no force at the site of injury against his neck. There was never any evidence. I mean, the media talked about things like he was given a rough ride in the police van. The police van was monitored on cameras. There was no evidence of that at all. Complete fabrication. And of course, the case was investigated by investigators for the police department, like an internal affairs kind of function. And the day they were to issue their report that there was no evidence of misconduct by these officers, that state's attorney who'd originally requested the drug sweep in the first place decided to hold a press conference on the steps of the courthouse saying she'd run her own independent investigation without telling anybody and had evidence to charge 6 cops, half of them black, with crimes as serious as murder. And it turned out later there was no such investigation. She never did it. So she just completely fabricated that claim.
Was that Mosby?
Marilyn Mosby. And not only was nothing done to her, but she won her next election too. Now she's in hot water. I think she's being prosecuted by the feds for some kind of tax crimes or property crimes. So she's in hot water now, but she didn't get in any hot water for that. And those cops were prosecuted for crimes as serious as murder. When we tell you all the time, if you're put in front of a jury, there's a chance even the most innocent person can get convicted. So they were put at that peril for nothing. Nothing. There was never any evidence that any of them had done anything wrong.
Yeah, well, absolutely. Now, and talking about prosecutorial immunity, there is absolute immunity for prosecutors operating in the prosecutorial function. And the reason for that is because they put a lot of criminals in prison, and those people have unlimited time to file frivolous complaints against them. So the solution from the judiciary is just to grant them absolute immunity. But when they enter into a police function, then they operate as they get a partial immunity, and it basically they act in the stead of cops. They are cops in essence, and that means they get the same sort of level of immunity. That's why when I was a prosecutor, I never engaged in independent investigation. We had investigators who would do that for us because I did not want to be in the loop of witnesses or evidence chain, nor did I want to lose my absolute immunity. So there is just so that people understand that a little bit more in depth.
Right. So in the case of Mosby, the fact that she had never actually done an independent investigation. Well, first of all, every cop that went to trial, the first one asked for a jury and got a hung jury. So they were just going to retry him again. But every of the other cops who went to trial, they got a bench trial. And in Maryland, the defendant can demand a bench trial, and the prosecution has nothing to say about it. The judge happened to be black, and he just acquitted everyone that came before him, 2-3 of the cops, and finally the prosecution just gave up and dismissed the charges against the others, just dropped the cases. But then those officers turned around and tried to sue Mosby civilly. And part of the suit was they also sued the investigator in her office who was supposed to have been the guy who ran this parallel secret investigation. And of course, the moment he got subpoenaed, the moment he got served, he was like, I don't know what you guys are talking about. I never did an investigation. And I never claimed I did. But
here it is.
All those civil suits against Mosby got dismissed on the grounds of prosecutorial immunity.
Here, I'm reading my book here again. I got a reference back. Here, I'll just give you 2 sentences from the book on page 241. We can follow along. A modest search of disciplinary cases reveals only 6 times in the last 3 decades where the Florida bar has sanctioned a prosecutor for actions in relation to the prosecution function. That's more than just closing arguments. That is 6 prosecutors in 30 years were somehow sanctioned by the Florida bar for some sort of function in prosecutors. Of these, only 2 were for improper actions at trial. So that's a ridiculously low amount. I mean, and the amount of prosecutorial misconduct that we see every day in trials. Like, we cover these trials, and it's like, that's wrong, and what the stuff that you see, and then nothing, no follow up. Look what happened with the Binger guy, who knowingly altered the video so that he could get past the JOA. Remember, he degraded the value of the quality of the video.
Right.
Unbelievable. And because if he hadn't done that, it would have been clear and he would have been JOA'd. So I don't know.
I wonder if this camera has been is done for the day. It looks like Long Crime stopped their stream completely. Let me take a look. One hour ago, day 3. Day 3, they stopped the stream 12 seconds ago. Well, I don't know, folks.
I've got a 5 o'clock appointment with this my class. And I just got back from Miami. We got to have dinner with Nick and his wife, and that was really beautiful. The Oriental Mandarin. Holy cow, what a hotel that is.
Well, it's I'm very, very happy for Nick. I haven't had a chance yet to listen to his Rumble stream where he explains what the deal looks like with Rumble, but he certainly seems very happy, and I'm very pleased for him. As far as I'm concerned, he's the hardest working guy out there on live streaming this kind of stuff, and I don't know how he does it, but he certainly the success is well earned. I couldn't possibly be happier for him. Ironically enough, as much as Nick and I have worked together and stuff, I've yet to meet him in person.
Oh, right. I don't know if I saw him talking one time. He says his dream trial would be to have some sort of self-defense trial with Branca as his wingman, because he loves you. He thinks the world of you, and so do I. I mean, really, you are the preeminent expert in the country on law of self-defense. And of course, that's how we initially met. I mean,
sure.
I heard you on commentating. You were the only guy that made any sense on the Zimmerman trial. And then, of course, I'd call you occasionally when I had a self-defense case. I'm like, I know somebody who knows something about this. I'm going to call. And then you give me the 5 points and the 5 elements, and we go through it. And so that was wonderful. So it's really it's hard to find, though, because there's so many of these commentators out there who talk on LawTube or whatever you call it, who don't know what they're talking about.
No, it's like, I see a lot of these that, and some of them are, I'm not going to name any names because there's been enough drama in LawTube, but some of them are LawTubers who, when I look at their content, I'm like, and they always start the show by saying they're a lawyer, and I'm like, all right, great, we'll get some legal insight here, but it's just not. It's like TMZ could have produced that, 30-minute video on that particular case. There's no legal analysis. There's no legal insight. There's good and bad lawyers, and there's good and bad cops, there's good and bad everything, and not everybody is, well, even when we've been talking about going back to our American law courses, I mean, trying to find people who I would stand behind and put my name behind, it's hard to find. I mean, that's a challenge, and I know we've put a lot of thought and a lot of brain power into that, and come up with some great teachers, but it's hard to find really great people who will have that balance of knowledge and teaching ability, and somebody who's not politically infused or just out it for their own great political aggrandizement. So I think sometimes that's what this whole LawTube thing gets attracted to people, because it looks like their faces in their. Well, it looks like easy money sometimes, right? If you can get a couple 100,000 subscribers, then you get that sweet YouTube ad revenue money, and you're making a living just talking on the internet, which doesn't strike me as I've made a living doing much nastier stuff than that, for sure. So I understand the motivation. Speaking of another LawTuber, hey Kurt.
There's Kurt. Hey Kurt.
I heard Steve Gosney talking shit about YouTubers who go out there and just say shit without knowing anything, so I thought I'd contribute.
Yeah, well, of course, present company excluded.
Sure.
Sure. Well, actually, Kurt, I mean, one thing, Kurt's analysis is very in-depth. If you want to really learn about a case, I think you did Apprendi, right? Didn't you do Apprendi?
Yeah, we did do
Anders.
Yeah, I did that, and I did Allen, and this morning I just did the 303 consulting case, freedom of speech, with a gay weddings site. That was a really interesting one. Yesterday I did U.S. versus Texas, and of course today there was an oral argument dealing with the state legislatures and the degree of control they have to the exclusion of other state apparatuses, including state courts. And so I'll be covering that in the next couple of days. So trying to cover all these things that are interesting.
Hey, Kurt, what's your channel so people know, in case there's anyone here?
Channel is called Uncivil Law, and we discuss a lot of Court of Appeals cases, U.S. Supreme Court, particularly when it's in session, do oral argument review. We try to hear what's good, what's bad, and try to explain things as things are developing. And we also do a little bit of the pop stuff, trials that are happening and things that are new. So try to do something that appeals to everybody. And well, 121,000 of you have said it appeals to you. So
nice.
We're making
Sweet.
some progress.
Yeah, that's great. That's fantastic, man. That's almost triple. I don't even know how many subscribers I have. It's not many, but I'm not really a law tuber. I do this only intermittently, or when there's an interesting trial, I'll do it for the length of the trial. But you guys are the hardworking ones producing content just about damn near every day, a lot of it, and for a select group of you, high quality content. Not everybody.
Not everybody, right? Well, it's not. I mean, this is quality of your lawyer makes a difference. Now, there's no magic wand, but one thing, you can have a bad lawyer can really miss things and screw things up. And if you don't have somebody who knows what they're doing, you can miss. One of the benefits, again, of American law courses is giving people the knowledge so that if they ever run into a problem, they can take, because the lawyers get busy, maybe they're a public defender, maybe they aren't even aware of the things that we're teaching, like the good science and bad science. We talked about firearms matching. There's a lot of lawyers that aren't even aware of the issue. I see it missed. I've argued that multiple times in an Anders brief where the lawyer should have brought it up and should have challenged the science, but didn't even know that it was challengeable. And so they missed it. And then I've got to say, well, it's waived because it wasn't challenged below. So
what percentage of your office's appeal briefs are Anders briefs?
About 50%.
Yeah, you had said something like that the other day, and it surprised me. So I just wanted to confirm that I had understood you properly. I suppose it shouldn't surprise me that half of them are just complete crap and there's nothing to appeal on. But
well, I mean, I'll give you an example. I mean, people say I've done appeals. I have done appeals front to back in 30 minutes, and it's like, well, you're not paying attention. No, what happens is they make a plea deal with the state. They agree. They plea. They get sentenced exactly what they agreed to. They don't file a notice to withdraw their plea, and then they appeal. Well, there's nothing to appeal in that. If the colloquy was done right, somebody pleads guilty, it's over. There's no issues that you can bring, and and on a direct appeal. Now, there may be on a 3850 where you can add something to the appeal, which is, again, we talk about in criminal law class that we're doing with law of self-defense, but once in a direct appeal situation, the evidence is closed, it's fixed. Right. And so if you plead to something, it's over. And people think, well, magic, I'm going to get a new trial because I've appealed. No, there's no new trial. We're just reviewing the law. And if the plea colloquy is done correctly and you're given a legal sentence and that you agreed to it, there's not much for me to argue on direct appeal.
Yeah, at that point, you're like, what part of this did we not explain to you adequately? Right. Because I'm sure we brought this to your attention in the plea colloquy. Like, you understand you're pleading guilty. It's because you are guilty. You understand that you're waiving your rights. You're like, okay. It's like, what part of this did you not understand?
Yeah, but they don't.
It would be amazing. I'd say that is probably 1 out of 4 cases.
Yeah. One of the reasons I wanted to do these American law courses is because, in my view, most people simply are completely ignorant, uninformed consumers of legal services. I mean, they have no way to differentiate between a competent lawyer and an incompetent lawyer because they just don't know anything. Really, what they do know is wrong. But if we can give them a base level of understanding of the law, at least perhaps they can have an informed conversation with their legal counsel and have some hope of being able to detect if someone maybe is not as strong an attorney as they ought to be. I can tell you, as far back as when I was in law school, there were people in my law school class who ought not have been there. I mean, they just didn't have the chops. And for whatever reason, they were admitted regardless. Now we hear law schools talking about dropping the LSAT as a requirement. I hear arguments being made that you shouldn't have a bar exam to practice law. So there's a lot.
Well, they are doing the new bar exam, which is coming out in what, 2 or 3 years?
I don't know.
Yeah, there is the next gen bar exam. They've already announced when it's being released. I think it's 2026.
I'm so happy I never have to take another bar. Why did you willingly take another bar exam?
Bars are fun.
Oh my gosh! See, you're the glutton for punishment. Yes, you're applied to Texas.
Still not licensed in Texas because they still haven't cleared me on character and fitness. They have 270 days by rule, which expires in late January.
So you'll get it in
And
late
I'm
January.
still waiting for them to clear me.
That means that's the fun. Nothing gets done if it wasn't for the last minute. But you're originally from where?
I'm licensed in Virginia.
Oh yeah.
I went to law school in Ohio, but I'm not licensed there.
I love Virginia.
Yeah.
I went to school in Virginia. That's a great state. I really enjoyed my time there.
Yeah, it was good.
I went to law school in New York and took the bar exam in New York and passed it. And then I met a girl in Massachusetts. So I followed her to Massachusetts, took the bar exam there and passed it. Got admitted in Massachusetts, never bothered getting admitted in New York because I was never going back to New York. And in fact, have never gone back to New York. And thank God, because I have a colleague who was admitted in New York and then decided to stop practicing law there. So they wanted to stop paying their bar fee. And New York's policy is, no, as long as you're admitted anywhere, you have to continue paying us in New York.
It doesn't make any sense.
Yeah,
Well,
it sounds like there might be an issue there. But when you're fighting lawyers, it's hard.
Right. And of course, now I'm in Colorado and still a member of the bar of Massachusetts because it doesn't really matter where I'm a member of the bar.
Well, Florida, the
Right.
problem is Florida doesn't reciprocate with anybody.
Yeah, I know. So if I want to join Steve over here, I guess I have to sit for the bar exam again. Let's go for broke. Is it too late for me to sign up for February?
Yeah, you're welcome. Well, the thing is like there are actually websites like there's where you go to apply that have maximum reciprocities. So like if I want to like shotgun it, so sit for a bar and say, Wyoming or something. Wyoming.
Well, thanks to the UBE, I basically sat for the bar in like 40 states simultaneously. That's the
Really?
beauty of the UBE.
Okay, I should do that. I'm so sick
Yeah.
of Florida sometimes.
It'd be quicker to name the states in which I'm not, which I didn't sit for the bar. It's Florida, Georgia, South Dakota, California, I think Nevada, Virginia, but I already had Virginia. And then that's about it. So basically all the other ones, and I passed everywhere. So I just have to file the paperwork and I get no less than 2 years and up to 5 years, depending on the state. I can file and they will admit me. And
Well,
if I give them
I
money.
guess I am admitted to the U.S. Supreme Court because I do.
I
our
got that
US
going for me too.
I submit our U.S. Supreme Court briefs. In fact, I'm working on that's my latest. I've got a new one that's traveling its way up.
Ooh.
Yeah, so hopefully I'm going to cert
Can I
that
get
one.
co-authorship credit?
No, that's easy. Yeah, everybody, I'm going to have to fight people away. I said if I get up there, I told the boss, the big boss, the elected official, if I get accepted on this cert petition, I get to go up to D.C. right and argue this. He's like, yes, all right. But it's one of the chapters in the book on the unlawful cost of incarceration. That article came out of the brief that we've been challenging this $50 cost of incarceration in Florida for many years. And I'm arguing it's an excessive fine under the excessive fines clause. And that's one of the chapters in the book is basically what we do in appeals is challenging it, saying why it's an excessive fine under the excessive fines clause. And I've got a great test case, which is a fellow who got sentenced to 22 years in prison and over $400,000 cost of incarceration, which I calculated out, which would be every penny that he would ever be expected to earn for the rest of his life when he gets out of prison. So that seems to me to be excessive. But maybe
I'm not sure if I agree or not, but I haven't really thought through the issues in detail, so I'll defer.
You should buy my book.
Maybe I'll write a brief in opposition.
Probably. I can see that. That would be Kurt's style too. You should do it. That'd be awesome.
I got
a friend of
chats
Court
here.
Brief.
Super chat from Kingslayer Damocles, $5. Thank you very much. He writes, he, meaning the officer in this case. Are you familiar with this case, Kurt?
No, not particularly.
All right. So we have an officer who was, how should I start? So we have a neighbor across the street from this house, and from 10 p.m. to 2:30 p.m. in the winter, he notices all the doors are open in this house. I've never seen the doors open before like that. Got concerned, walked across the street, and decided to come home and call the police. Told the police dispatcher, hey, my neighbor's across the street. Their doors have been open for hours. Not sure what's going on. Could you send a cop? Well, the police dispatcher accepts that as a open structure call, which is basically a presumptive burglary in progress call. They say 2 cops, has to be 2 to a open structure call because they're high risk. The officers get to the house. They peer through the front door. The front of the house is all lit up. But their SOP for a burglary in process call is not to announce themselves until they've investigated the scene. So they start walking around the house. This is 2:30 at night, walking around the house with their flashlights. One of them looks through a window into the house, and on the other side of the window is someone raising a pistol at the officer. So the officer shoots that person. Fatal shot through the heart. Turns out the person inside the house was the resident, 28-year-old black woman who was babysitting her 8-year-old nephew, who also observed these events. The cop happens to be a white male, and within 2 days he was charged with murder for this shooting. So he's on trial for murder now. Of course, his legal defense is self-defense, and there is a lesser included charge that of reckless manslaughter. So the state either has to disprove self-defense beyond a reasonable doubt or prove criminal recklessness beyond a reasonable doubt. And so far, it's not looking good for the state. Their opening statement was very weak. They didn't have a lot of evidence to talk about that was favorable to them. They're on witness 4 or 5 now in their case in chief, and it's not been very productive for the state. Of course, the risk for the defendant is all the evidence could be in your favor. You could still end up convicted by a jury, especially in a racially charged case like this one. There have been protests and all the usual shenanigans that come with cases like this. So with that in context, so when the officer looks through the window, he sees someone on the other side of the glass. He says, "Show me your hands." And almost instantly he fires the fatal shot. He says she was raising the gun. It had a laser on it. He could see the laser being projected. And the comment here.
So there was a gun, in fact.
There was a gun, in fact. Yeah.
Okay.
And the nephew, the 8-year-old who observed this, within 2 hours he was talking to somebody on video, somebody associated with the investigation. I think it was a social worker, and he told the social worker on video, "Yes, my aunt raised the gun at the window." So it's not a misperception by the officer. But here the super chat is the officer commanded the woman to raise her hands. How do you raise your hands with a gun in your hand without pointing it forward? Well, you could. I mean, you could raise it sideways. You could drop the gun and raise your hands. But it's what we talked about earlier, Steve. It's these ambiguous, very spontaneous verbal commands that officers give that may not be entirely coherent under the circumstances. Yeah, it's a problem. Raise your hands. You keep the gun in your hand. Now you're raising the gun, right? And the officer's going to see that, and you're likely to get shot.
And the difficult thing here, Kurt, is the perspective of the homeowner here, or the occupant of the home, is that she hears a suspicious sound at 2 a.m. in the morning outside her home. So she retrieves her firearm and goes to investigate, and she's inside the home with firearm, thinking there might be some kind of intruder, right? And so all she sees is a flashlight outside her thing, and somebody's out there. She doesn't know this is a police officer or anything, and all of a sudden, well, how do you react to this? And the cop shoots through the window into the home and kills the legal occupant of the home. It's a very tough situation on both sides. And clearly, obviously, there's going to be big civil settlements here. But the question is whether the cop is criminally responsible for murder in this situation. It happens in a second. It's just a split-second decision. It's as soon as you see the gun, it's like, I forget exactly. It's like, show me your hands, or something like that, and then boom, the firearm.
What's the best argument for the state?
That the homeowner raised the gun at the cop. Basically, the woman was in the house. He's investigating what he may think is a home invasion of some sort. He sees a figure in the house with a gun, and she raises and points the gun at him, and so he shoots in self-defense.
Right, that's the defense narrative. The state has not given a very compelling narrative. Their opening statement was about 25 minutes long. It was 95% emotion. The poor 8-year-old who had to observe this. How loving everybody was. The victim was going to go to medical school, be a doctor, all kinds of touchy-feeling stuff. And then she just summarily at the end of her opening says, and we're going to show you, ladies and gentlemen of the jury, that this was murder and it was not self-defense. Thank you very much.
Well, I keep giving this defense side because I'm a defense attorney. My brain thinks that way. The state side is that the 8-year-old who is now
listen to the question posed, counselor.
Right. The 11-year-old who's now he's 11 and a cute kid, but has now, after the initial interview, now says that the mom never raised her gun, that
The
she was
aunt,
armed, but
yeah.
she never raised her gun. So he changes his testimony to allow that she's wandering the house with a gun and gets shot unexpectedly or whatever, and she never pointed the gun at him. So that's the best state case here.
Oh,
Yeah,
yeah.
like he's got that was the look says it all, right? The right. I think we're kind of on the side of the defense in this one, but I think it's enough to go to the jury. Oh, here we go.
At that time,
I'm trying to figure out, the thing I'm trying to figure out in my head is like, how do you fix this sort of as a matter of policy? How do you prevent this from happening again? I'm trying to rewrite this in my head and I'm having a difficult time.
Well, there's a lot of debate that we've talked about going around whether the officers should approach silently a home in this situation. But the policy evidently in this community is that is what, when there's a possible home invasion type situation, that they sneak up on the home, they quietly approach, they just assess the situation that way. But you know, there's pluses and minuses to either side of that one. And in
It
this
seems
case,
like a reasonable policy. I mean, I can see pluses and minuses sort of. It seems like a reasonable policy though.
and if the cops follow the policy, I mean, seems it should protect him. But you know, obviously we are in a criminal trial. Judge has been pretty good. Brett's been pretty solid on this one.
Yeah, good judge.
But he's quiet. Somebody in the tweet, Kali saw a tweet saying judges discussing with the parties that a camera zoomed in on one side's laptop and showed sensitive information. So he may be upset about cameras in the courtroom.
I did see the camera do that. I didn't see anything sensitive, but at least it wasn't visible in terms of the resolution of the image that was being shown. But it was definitely showing on the prosecutor's laptop and some at a sharp
I can see
angle,
the judge's
some papers
laptop
on
right
the
there.
desk.
Judge's laptop, you can see right there. You can see him playing solitaire.
Nice.
I used to have a judge who used to download, what was it? What was the music streaming thing that Metallica got all upset about?
Napster?
Napster. Yeah, I had a judge. He would sit there during trial all day and download stuff off Napster on the bench. And you'd object and you'd be like, what? I'm streaming Metallica, you know?
It's
On
the
some
judge has
level, I
been
can't
very,
blame him because sometimes I'm like, just wake me up when something interesting happens.
Yeah, right. I mean, I was telling someone the other day, it's like I'd be bored out of my mind being a judge. I mean, so much of the time you're not actually doing anything.
Oh, this is in my backyard, the state of Texas?
Yeah, Fort Worth.
Okay,
Tarrant
cool.
County.
I like the symbol on the wall. I got to get myself one of those. I got to put one of those on my wall. That'd be cool.
Now, what county are you in, Kurt?
I'm not sure, actually. I'm on the north side of Austin, so I'm not actually sure which county I'm in. Williamson, I think.
Yeah, this judge. It's the nice thing about this proceeding so far is the proceedings has just been very clean. No shenanigans, no crazy lawyers trying to get away with stuff. Everything proceeds in a very, very timely, fast pace. One witness after the other. Everybody's prepped, and my expectation is that's because they know this judge, and this judge demands that in this courtroom. So no one's trying to push this judge around, which is quite different than some of the judges we've seen in high-profile cases.
Right.
The last couple of years, for sure.
And I think the prosecution is playing a lot on the emotional side of this, that the victim was innocent, and the chats have been there's been a lot of people that have been pushing back because a lot of people here are gun owners and have guns in their homes and would respond exactly like this woman did to a suspicious noise at 2 a.m. They'd go, I would do that, retrieve my firearm. And of course, and then she gets shot and killed inside her own home or inside. I think she might have been a babysitter, but she's basically legally in a residence. So there's been a lot of sympathy to the victim here, and rightfully so.
I'd like to not be shot when the police show up at my house, so I have a lot of sympathy to that too.
You're such a bleeding heart. But anyway, that's the.
I want to not be shot, Steve.
You know, demands. This is just nonstop. But anyway, but here we are. The cop's the one on trial and not the victim. So that's where we are.
It's I just think that the state so far hasn't shown really anything substantive. Just the emotional stuff, and I would think they would have by now. I mean, their first witness was the little kid. And he did testify that the gun was never raised, but that was immediately followed by the video interview of him 2 hours after the event, explicitly stating that the gun was raised. Then they had the police officer partner. Everything she said was consistent with the narrative of innocence. We have, she talked about the policy, the no announce policy. You know, it's not a fabrication. That's the way things are actually done. The state called the dispatcher. The dispatcher talked about, well, this is why we call it an open structure call. It was a structure that was reported as open 2:30 at night and suspicious. I mean, that's why 2 cops have to be sent, because it's dangerous. The neighbor who made the call, first he went across the street. He himself would not knock on the door because he was afraid he'd get shot. He didn't want to startle the people in the house. Again, it's a dangerous. Everyone involved thinks it's an inherently dangerous situation. That's why the cops are sneaking around with their guns out. They have good reason to believe. To the partner cop who testified for the state, she said, yeah, that house, it was in a considerable state of disorder, lots of loose stuff on the inside and the outside of the house. She said, yeah, it looked like a burglary to me. It looked like that house had been ransacked. So not very good for the state in terms of legal merit, I would say.
You might want to show Kurt the little video, because the video is only about a minute long, and it gives basically it's the body cam of the officer. It shows you how quick it is. It's a good review because it really does give you the flavor of the immediacy of this case.
Yeah,
I'm sure it's fast. They always are.
1 minute, 16 seconds. So I'll advance it to the start of the real video. This is the front door that's open when the cops arrive. So this, of course, is their body-worn camera. Takes about a minute and 16 seconds from here until the shot is fired, and you'll hear how fast it goes.
You know, they look inside. It looks like things have been tossed.
Right. That was my impression too.
Yep.
Now, of course, the state says in its opening, well, there was an 8-year-old in the house. Of course it was messy, but the officer wouldn't know that.
Exactly so.
So now the front of the house was well illuminated inside. The back of the house where they're going now, it's dark. They're going to go through this gate, and then the window will be on the left once they go through the gate. That's the female partner immediately behind this guy. So he's got a handheld flashlight in his left hand. He's got his pistol in his right hand. It happens quick.
Standard.
Put your hands up. Show me your hands.
That's it.
Yeah, no, I mean, I understand the officer's position.
Of course, it's a bad outcome, right? So people get it's emotionally. This should not have happened. The woman wasn't a bad actor. She was not. You know, the cops may have thought she could have been a burglar in the home, but she wasn't, in fact, a burglar in the home. She probably legitimately just heard a noise outside, got her gun because she thought she might be at risk.
It is Texas, right? So you know.
It's understandable why she would want a gun if she heard a noise outside at 2:30 in the morning.
Yep.
But that's, of course, that's not the legal question here. The legal question is, was the officer justified in firing the shot, not what the mental state of the victim was in this particular case.
Yeah.
And it's tough too, because we also have to look at it from the position that this is a police officer and their job is to enter into these situations and, if necessary, use deadly force. So if this was a citizen coming into there, it would be a whole different analysis. But the fact that the police officer, his job is to follow, is to confront, to move into dangerous situations like this when called. And his defense is that I was following policy. And the policy evidently is, in fact, that he's following policy by entering there stealthily to investigate, to find out what's going on. That was the policy of this police department, and he's following it. So, but despite that, 2 days later, he gets charged with murder, and now he's facing trial for murder. So very, very bad facts. You know, these are hard fact situations for anybody.
Yep.
And I'm sure the racial component is involved here somehow too. So,
Well, that's just the political nature, right? I mean, people often look at the law, the legal process, as if it were some kind of supercomputer, right? You put law and evidence in one side, you crank the handle, you get justice out the other
Those
side.
people irritate me.
But yeah,
I fight with those people on my channel sometimes.
But
It's like there is no law. There's only what the courts will give you. I'm like, look, it's complicated. Humanity is complicated.
And inside that machine is not a supercomputer. It's a bunch of fallible human beings, right? And many of them politically driven. So the decision makers here on whether to bring charges, whether to fire this cop, both of which happened, they're fundamentally politicians. A police chief is a politician. A prosecutor is a politician. They're subject to the body politic. And if their body politic is outraged, rationally or not, they're likely to respond to that and do things like, these decisions cost them nothing. It costs them nothing. There's no downside to them to fire this cop or to bring him to trial. In fact, when it comes to the civil settlement, politicians are happy to spend other people's money to make their political problems go away. So even if there were a lack of merit, it's not surprising when you see large settlements in these kinds of police use of force cases. Here, I think there's a sound argument to be made. I'm not sure I buy it, but I'd be open to the argument that the policy was somehow defective, that maybe they should be compelled to announce, even in a burglary, so that this particular kind of situation doesn't happen, this bad outcome. Of course, that opens up the door to other alternative bad outcomes. It's like a product liability case, right? We could make everything perfectly safe, could make every lawnmower perfectly safe, but what would it cost?
There is no way we can do that.
Right? It could pluck each blade of grass.
Require bubble wrap surrounding every individual as they exit their homes into the world. Be a big bubble wrap, baby, you know.
And of course, there's a reason we don't do that. Let me see. Another super chat. Duncan, Idaho, $5. Thank you very much. He writes, have neither of you seen the Paul Newman movie, The Verdict? That's got to be the best law movie ever. You got to watch it. I'm sure I must have seen it. It's decades old, but I have to confess I don't have a recollection.
I think I remember that movie. It's been a long time since I've seen that also. I think Duncan, Idaho is a Dune reference, though. That's pretty cool.
Jazz Truckin, $10 super chat, says, do you think the prosecution could be sandbagging the defense given the weakness of their case from the start? No. No, I think the prosecution would have led with strong witnesses up front.
Well, the kid was a strong witness. Oh, and there was another interesting thing too, Kurt, that happened, which was evidently there was somebody in the audience who was signaling to the little kid as he testified, and got brought up and basically booted out of the courtroom by this judge, which was pretty cool. But I don't know how. My experience is jurors are hyper aware of that, and just the fact that was happening, I think that's anything the defense attorney says. If the juror picks up on that, that's going to be a big mark against the state and will have an impact. Sometimes maybe more than what it should, because sometimes jurors like to figure the mystery out, and they like to they speculate and they fill gaps in with their imaginations. And so having a signaling witness to the state's key witness, it's like, we know something's screwy going on here. And then they react extremely the other way. Or it could be, we really think that the family around the kid was influencing the kid to change testimony. So, or the prosecutor.
Hey, somebody did a Branca Burns from my coverage yesterday. I don't even know what it is.
What'd you do now?
But I don't know. Let's see. Let's find out. I don't know what I did either. We don't need a duplicate of that banner there. This was the non-emergency call receiver that the neighbor spoke to, describing the house as being the doors open in the middle of the night in the winter, and calling the police to ask that somebody be sent out to take a look. She was very nice. There was nothing wrong with her, but I must have said something rude, or presumably they wouldn't have done this. So let's see what it is.
October the 12th in 2019. Did you get a call around 2:23 in the morning regarding an open structure?
Yes.
Why did you do and
Oh, it's the coughing. A lot of coughing.
And not a welfare check?
Because there was a structure house
That was open.
That had an open door, so it's pretty specific to that. So.
This poor girl's like, why are you asking me stupid questions?
Does it fit?
Why did you classify it as an open structure call? Well, because it was a call about a structure that was open.
No, I mean, that's trial. Sometimes it's painful.
Well, and
That's fine.
sometimes attorneys, they got to say something. They're up there and they're on call. We had there was one that we get passed around. Like sometimes when we're doing appeals, we'll pluck something out of the appellate record just to pass it around. And I remember one of them was the funniest was they were asking the medical examiner. So in your opinion, was this person dead? And the medical says yes. Well, and then he's like, now, why did you think that? He says, because his heart was in a jar in front of me. It's like a stupid question.
Yeah, but with all possible respect, just because what it says on the label may not necessarily be like what it is. It's like, why'd you call it an open structure call? Well, you see, the thing was that the doors were closed, and there was no walls, and so that's what we call an open structure. I mean, the law does some weird shit sometimes. You can't say, "Oh, that's what's on the label," so that must be what it is.
Well, I had a funny interaction that I did the trial and then I did the appeal, and it's one I took all the way to the U.S. Supreme Court. I'm trying to get my cert petition granted. One of these days, I'll talk to you, Justice Thomas. But it was a case. It was two felonies, 2 third-degree felonies, wiretapping cases. And I was fighting it was such a ridiculous case that they charged. And so we were fighting. And I was arguing that it was protected under the Constitution's right of petition. Complicated case, but just believe me, I was right. They were wrong. And I was arguing to the judge that the right of petition covers this. I said, and the Constitution governs, right? This is a constitutional right to petition the government. And the state is using their petition as a basis of a criminal charge. And the judge says to me, what's the Constitution have to do with this, counselor? It's illegal, isn't it? And I said, what's the Constitution have to do with this? Right? I'm like, what? He's like, yes, but the legislature made this illegal, right? So what's the Constitution? So I block quoted that in my appellate brief.
Well, I mean, there's I don't know the exact details, but there is a principle of constitutional avoidance. If you can solve it on a statute, then that's not a ridiculous question, right?
Well, somebody had recorded themselves on the phone with a cop, and because he thought he was being abused by the cop, so he took the cell phone call and sent it on a complaint form to the police to complain about the police officer abusing him, and the police officer turned around and charged him with typing him without his consent.
Right.
And so I was arguing that the complaint against the police officer was a petition for redress of grievances against a government entity. So that was the basis of the thing. And
I don't think so, but nice try.
No, I think so. Well, we'll have to be in the what is it? The friend of court brief on the other side. Kurt's like, Gosney's doing it again. I'm going to be.
That's right. Yeah, I'm petitioning for split time so I can get up there and argue against you too.
Oh, that would be fun, wouldn't it? Anyway, so let's see. What other sort of fun things do you have going on your channel?
Just think of it as a plus, though. If you do get your case taken to the Supreme Court, just think of it as a plus that I'm more than willing to play the black hat and try to give you a hard time in your moot.
No, actually, I think the world can be wrong as long as I'm right. That's
well, but you need someone who play the black hat to give you to do your moot so that you can figure out what the answers are.
In all honesty, I would much rather go against somebody who's competent. It's insulting sometimes when the state just mails in their briefs. I feel like I want good competition. I want to win against the best, and that's the thing. I mean, you want to.
No, that's what I like. I like law at the highest levels. I like it when you get two really sophisticated arguments. And I really like it also when the attorneys have the courage of their own convictions.
Right.
Which was a little bit wanting, at least in part, when I was covering the case dealing with the free speech issues for the websites, So what's going on in this case I covered today, which answers your earlier question about what am I covering? I was covering this case 303 Creative, which is a company in Colorado, which does graphic design, and they do websites. They don't currently do any websites for weddings, but they'd like to. And they'd like to only do websites for straight relationships, and the equal protection law says that they can't, or they can't do this. They have to make it available to everyone. And they say, well, it's speech.
Cake issue, like the cake.
Yeah, it's masterpiece cake, but it's pure. Because we move from something where it's symbolic speech or representative speech into much more pure speech. Like, is the cake and the writing on the cake speech. Okay, whatever the answer for that is the website with words speech is more, right? So it's a pure issue. And for example, I was a little bit critical of the lawyer for 303 because they didn't have the courage of their own convictions. Because Jackson over here is asking questions like, well, if they can deny the website to create a website, if they can deny the website to create for a gay couple, can they do it for an interracial couple or a couple that's handicapped or a couple that is whatever? And she tried to avoid that. And I'm like, well, the answer is just yes, because freedom of speech trumps is the right answer. So your parade of horribles is something that I am willing to accept, but she tried to avoid the consequence of that a little bit, which was annoying. So I do like lawyers who have the courage of their convictions. At least the lawyer who was arguing in favor of Colorado is like, yeah, this is not compelled speech. This is not a problem. They should definitely be required to make this website. The New York Times, I like this one. Can the New York Times run only gay wedding announcements for Pride Month? And in the context of this exchange, the right answer was no. And he said no, because it's like, that would be discrimination. I'm like, okay, well, you have the courage of your convictions. You got that going for you.
So it looks like they're going through exhibits here and talking about stuff that may not be admissible at trial, but would be admissible at punishment phase.
Yeah.
Well, Kurt was just telling us about what he's covering and coming up in that free speech. That's a big issue. And that's U.S. Supreme Court oral argument.
303 is going to win. The only question is how, and how extensive is the ruling. I have a sneaking suspicion that it's going to be 6-3, and it's also going to be fairly narrowly rooted to its facts, which I'm going to find to be annoying. I would like the Supreme Court to speak a little bit broader, and I think I'm going to be annoyed.
Look at this guy, man. I tell you. People want your volume up, Andrew.
It's all the way, folks. Oh, no, it's not. Sorry, my bad.
That's fine.
I think they mean the volume for your mic.
Oh, yeah? I don't know if I can make it any higher.
That would be the volume I would play that in front of the jury. Is that agreeable with the defense? Yes, Your Honor. Okay.
Yesterday I was too loud. Today I'm too quiet.
Yeah, welcome to my world, right? I'm trying this new streaming browser called Melon instead of StreamYard.
Oh, yeah?
We'll see if that does any better. I paid for a year of that, so we'll see.
What's it called?
Melon.
Melon.
MELON. It's for Streamlabs. You can invite up to 12 people instead of 10, and it's a little bit cheaper.
I'll have to check that out.
What's happening with this court stream? I might have to duck out for a few minutes here, Andrew.
Okay. I'll think of more ways to help you lose while you're gone.
Yeah.
I'm sure we'll find something we agree on, Steve.
Oh, I'm sure we'll agree on something. Just got to figure it out.
Want to go boxing? Florida versus Texas? We can meet in Mississippi.
Good afternoon. I apologize.
Are you kidding? I'm such a non-physical creature.
Your Honor, before the state calls another witness, the state will offer State's Exhibit 116 for all purposes. It is another excerpt from the forensic interview of
What all the cool kids are doing this day, like Logan Paul and all those cuz, is just doing boxing matches and having we could have law tube boxing.
Any objections to 116? No, Your Honor. 116 is admitted.
We could do chess boxing, except law boxing. We'll do some boxing, and then in between rounds we'll do some legal analysis, and then we'll do boxing and then legal analysis.
And you're talking about the weapon that she had. Tell me more about what that weapon looks like.
I gotta head out here, Andrew. I'm sorry. I gotta run. Okay. I've got to prepare for this 5 o'clock class that keeps coming up. I'll talk to you later. Hey, good to see you, Kurt. I'll see you in at 5 o'clock.
Okay.
There's a hole in the front and a break in right here. Excuse me. And you said you thought ammo, where was the ammo?
Theoretically, I also should go to the gym today.
One of them was on the floor because she got a thermal tank on the floor.
I've been trying to go a lot more frequently.
When they take it out and take it back in, like she got an extra and it's on the floor. Where is it on the floor? By the window. By the window? Is it always on the floor by the window, or did she put it there or something? Always by the door, always by the window. Always by the window. I don't think she could have picked that up. Okay. And you said that she got that weapon out of her purse. Where does she usually keep that weapon? In her purse. In her purse? She used to have a case to put it in. Mm-hmm. But now I don't know what it is, because like she told me she got a war gun, but she's hiding it from me. Okay. Have you seen any different guns at her house? Mm-mm. Okay. Are you allowed to touch that gun that's in her purse? Mm-mm. What are the rules about that? Don't touch the gun.
Mr. Smith?
State calls Dr. Richard Freeze.
Dr. Freeze?
Dr. Freeze. Presumably the medical examiner, I guess.
Was that Victor Freeze?
I thought it was Richard. Let's see.
Never to hold your hand again. We will meet in a place where your warm hand embraces mine.
Evidence is in effect. Don't talk about the case with anybody else except the lawyers, okay?
Okay.
Mr. Smith?
Dr. Freeze, would you introduce yourself to the jury, please?
Yes, my name is Dr. Richard Christian Freeze. I'm a deputy medical examiner.
Look at that mustache.
Medical examiner's office.
How long have you been over at the Tarrant County Medical Examiner's office?
About 10 years.
That's pretentious.
What is, you said you're a deputy medical examiner, what's that mean?
We are
What a mustache, though.
We
I mean, come
investigate,
on,
deaths.
dude.
In particular, our office is concerned with determining the cause and manner in which people died, and in particular, deaths that are not natural or suspicious in nature.
Okay, so what's it mean to be a forensic pathologist?
That again goes to, we usually perform autopsies and death investigations into determining the cause and manner of death in individuals.
How does somebody become a forensic pathologist?
I did my undergraduate training at the University of Texas, Dallas, in biology. Following that, I went on to do my medical training at the University of North Texas Health Science Center here in Fort Worth. I then did my residency in anatomic and clinical pathology at Medical College of Virginia, Virginia Commonwealth University. And then went on to do subspecialty training in forensic pathology. I'm licensed to practice medicine in the state of Texas, and I'm board certified in anatomic pathology, clinical pathology, and forensic pathology.
Okay, so how does all that stuff help you be a forensic pathologist?
So we use that medical training and knowledge of pathology in our examination of deceased individuals in order to elicit and come to a conclusion as to what caused their death.
And you went to medical
I got my thumbnail for tomorrow's show.
Nice.
like a pediatrician, you chose this route.
That's correct.
So where did you work at before the Tarrant County ME's office?
Prior to the Tarrant County Medical Examiner's office, I was in Richmond, Virginia. I worked as a local medical examiner for about 2 years there.
And was that your first job out of school?
Yeah, aside from residency.
Where'd you do your residency?
Virginia Commonwealth University Medical College of Virginia Hospital System.
So have you testified as an expert, as a forensic pathologist a few times or many times?
Many times.
All across the state of Texas?
Yes, in many jurisdictions.
And you've done it in Virginia too?
I have not in Virginia.
Oh, not in Virginia. And you testified in this courtroom, as a matter of fact, haven't you, Chris? I mean, not necessarily in this actual room, but in the 396th District Court where Judge Gallagher is the elected judge.
Yes.
Right? So were you working as a forensic pathologist in October of 2019.
I was.
And as a result of working there at the Tarrant County ME's office in October of 2019, did you have the opportunity to perform an autopsy on an individual named Atatiana Jefferson?
I did.
So, could you just kind of give a brief synopsis of how you do an autopsy?
Okay. So deaths will be reported to our office, how this generally begins. They can be reported by anyone. Most commonly it will be by the police agencies, first responders, hospitals, and we have staff on hand 24 hours who will take those calls. When we take that case, we'll assign that case a unique identifying case number that will then follow that case throughout the process. Our investigators will take the call, take down the information regarding that, and then depending upon the circumstances may also actually go out to the location, the scene where the body is at, and acquire additional information, both from individuals who are present for that, perhaps family members or people that might provide medical history or any information about the circumstances. We'll then bring the body into our office. We'll start by performing an external examination where we'll look at the body as it arrives, documenting the clothing that's present, any medical intervention that may be in place from attempted resuscitation. We'll then clean the body off, make general documentations of standard information, hair color, height, weight, things of that nature. And clean the body off and document any injuries, any evidence of disease. Then we'll proceed to do an internal examination where we will open up the body with a standard Y incision and reflect the scalp so we can examine the internal organs and again look at them for any evidence of injury, trauma, or disease processes. During that, we'll collect specimens as necessary for additional testing.
So, exactly on what day did you perform the autopsy on Atatiana Jefferson?
That was the 13th day of October 2019.
Around what time?
11:30 a.m.
So, whenever you began the examination, what did you find on Atatiana?
Most prominently was she had sustained a gunshot wound to her torso with an entry wound in the left upper chest.
Were there any other injuries on Atatiana?
On the
outside.
On the outside, there was what we refer to sometimes as pseudo-stippling or fragments from glass that had embedded in her skin.
Okay, you said that. Could you walk us through, what is pseudo-stippling?
When a bullet is discharged from a gun, not just the bullet leaves the gun. As the gunpowder is ignited and propels the bullet out of the barrel, we can see other stuff sometimes is projected with that. Gunpowder, soot from the combustion of the gunpowder. And if an individual is close enough to the barrel, that may be deposited on the skin and it can give a pattern. We'll describe whether soot is present if we have that, or a stippling or tattooing pattern from the gunpowder striking the skin can cause a small defect and perhaps even embed in the skin. In cases where we have the bullet may strike another object before it goes on to strike the individual, portions of that object can break off and travel in the direction as well, and those can also deposit themselves on the skin and cause defects.
So what's the difference between stippling and pseudo-stippling?
Stippling is the term we use for when it is caused by that gunpowder, and pseudo-stippling is a general term for something that may appear like that, but is caused by something other than gunpowder.
And in researching this case, prepared for your autopsy, did you learn that the projectile bullet had in fact passed through a plate of glass?
Yes.
So you expected to see this pseudo-stippling?
Not necessarily expected. It is a possibility. Obviously, there's a lot of additional variables, just like with you may see that deposit, the stippling from a gun deposit if they're close enough. You will also only see that if the individual is close enough to the object for those to travel and strike the individual.
Were there any other external injuries?
No.
Well, I mean, were there some, there was a IO needle in the shin, right?
There was medical therapy present, yes.
Medical therapy present, the two punctures in the lungs and the one in the shin, but you don't consider that externally?
No, I would generally will list that under my autopsy reports under medical intervention.
So what was your next step in the autopsy of Atatiana Jefferson?
Following the external examination, then proceeded to the internal exam to document the injuries in the wound path of the bullet, and to recover the bullet. There was no exit wound present externally, and X-ray revealed that a bullet was identifiable on that.
What did you find in your internal examination?
So the bullet passed through the muscle and the soft tissue of the chest wall, and proceeded in, perforated, went through the heart, the diaphragm, injured the liver, the right kidney, and then ended up in the right back with a small fracture of the right 12th rib, and next to that the bullet was recovered.
Now, approach the witness, Your Honor.
Yes, sir.
If you would please, would you look at State's Exhibits 71 through 87 inclusively, just to yourself without showing them to the jury?
Well, that's an instantly mortal wound. Yeah, Bon Jovi has entered the chat.
Do you recognize State's Exhibit 71 through 87 inclusively?
I do.
And are they pictures that were taken during the autopsy of Atatiana Jefferson?
Yes,
And they truly accurately depict what you saw while performing this autopsy?
they do.
And that is it, including the projectile that was recovered as well as an X-ray so you could find the projectile in her body?
Yes.
At this time, Your Honor, State Officer
Yes.
State Exhibit 71 through 87 inclusively for all purposes, tendering to defense counsel for review.
Mr. Good, you previously, outside the presence of the jury, objected to State's Exhibits 75, 76, 80, 82, 83, and 84. Do you renew those objections?
We do, Your Honor, and I apologize for not standing as I'm looking through these.
So other than those photographs, do you have objections to any of the remaining photographs?
No further objections.
And you renew your objections previously? All right, those are overruled. State's Exhibits 71 through 86 are admitted, and you may have a running objection to the photographs that you objected, and I overruled your objection.
Did you say 71 through 86?
86.
87. 71 through 87 inclusively.
Got it. 87 is admitted.
Permission to publish
Yep.
using the smart board.
Yes, sir.
May I approach the witness again?
Yes, sir.
I hear a lot of yes, sir. I'm not sure what, but you seem sure about something.
Show you what the, 71, what are we looking here?
Here we're looking at Ms. Jefferson's hands, in this case the right hand, standard procedure to photograph the hands, particularly in gunshot cases.
State's Exhibit 72.
And you renew your objections previously? All right, those are overruled. State's Exhibits 71 through 86 are admitted.
I'm switching streams, folks. Someone told me the volume here might be
You
better.
objected, and I overruled your objection.
Did you say 71 through 86?
86.
87. 71 through 87 inclusively.
Got it. 87 is admitted.
Permission to publish
Yep.
using the smart board.
Yes, sir.
May I approach the witness again?
Yes, sir.
His last name is spelled Fries. I get why a guy with a mustache like that would go with the pronunciation of Freeze.
71. What are we looking here?
Here we're looking at Ms. Jefferson's hands, in this case the right hand. Standard procedure to photograph the hands, particularly in gunshot cases.
State's Exhibit 72.
This looking at the prior one being the back of the hand.
To feel the warm heat on my face. Oh yes,
And then the
I'd
back of
kill
the
for
left
that.
74.
and the palm of the left hand.
All right, State's Exhibit 75. What's the jury seeing here?
So in this photograph, we're looking at the upper chest and neck of Miss Jefferson. We can see the hand as it's positioned there. And we can see many of these multiple small superficial kind of punctate defects. And this is the pseudo-stippling caused from the glass fragments striking the body.
So each and every one of those little dots is a little piece of glass?
Yes.
State's Exhibit 76.
Here we've, similar picture, we can see a little more of the neck. Here's the chin, and we can see a little more of the chest and the deposition of the glass and the defects caused by it.
And the bottom, from our bottom, that's her neck.
Yes, this is her chin here, the neck, the right shoulder.
I expect the state's going to try to argue that there wasn't this glass stippling in her firing hand, therefore her firing hand was not raised.
Of the defects, again, caused by that glass on the anterior of the front of the right shoulder.
Why aren't they all the same size?
As glass fragments, you will get different sizes for that. And so there's a lot of variability with that depending upon the type of glass.
Okay. And what about State's Exhibit 78?
In this picture, we can see both in the background the defects we were looking at earlier, and additional, we can see more of those present on her face.
Are they, go back to 78, please. Are they even on her lips?
Yes.
So those small pieces of glass were traveling fast enough to break the skin
Yes.
and then bleed? Is that right?
Yes. They're largely superficial. They don't penetrate deeply through the skin, but.
And can we see something in the top upper left corner of State's Exhibit 78?
Yes, and there we can see the entry gunshot wound.
Okay. State's Exhibit 79.
79 is, again, looking at the right upper chest.
I
and
guess
shoulder where
the cameras aren't allowed to see any of the
the pseudo-
photos, I guess.
Previously.
Okay. State's Exhibit 80.
80, we're again looking at the upper chest and the face. We can see the pseudo-stippling caused by the glass and the entry gunshot wound on the left upper chest.
Okay. What about State's Exhibit 81? What are we seeing there?
This is a close-up of the entry gunshot wound. We can see it's a little oval in shape. There's abrasions around the margin, and we don't see any gunpowder or soot that I previously described there.
Would you, from what you know of this case, the bullet going through the window, would you have expected to see the soot?
I wouldn't in that scenario, no, but it's something we always look for.
And why not?
Because there is a target interposed between the firing of the gun and the individual.
And I know there's no soot there around that bullet wound, but is that what you would expect? Is that how a bullet wound looks on human skin?
Yes.
State's Exhibit 82. So, what is this a picture of?
This is a picture of her heart. We have the anterior surface of the heart here, and we can see the defect caused by the bullet.
And you, with your laser pointer, for purpose of the record, you pointed to a very dark, almost cavity in the right portion of the heart, maybe a little bit to the lower half on the right side, from the looking picture on the right side of the photo. Is that correct?
That's correct.
So is that where the bullet went into the heart?
Yes.
Where did it strike the heart exactly?
So it went into the heart at the anterior surface involved the left ventricle. So the left side of the heart here is the left ventricle that pumps all the blood out to the rest of your body. So it's the largest chamber here, and then this being the right side. So it went through the left ventricle, and then there's what we call the interventricular septum. There's a septum that divides the right and left ventricles. It proceeded through that and then through the right side of the heart.
If I could interject briefly, the witness appears to be reading from something up there on the witness stand as he answers the question.
Are you referring to your report?
Yes.
It appears he's referring to his report. You wish to see what he's looking at? Okay. Okay, don't read from it, just use it to refresh your memory, okay?
So what happens when a bullet goes through a heart like this?
Well, a few things. Blood will exit the heart. The heart is the muscle that pumps blood to the rest of your body. With a hole in the chambers, as the heart continues to pump, that blood will exit the heart, and it will enter into both the pericardial sac around there and into the chest around there. And as the chest fills up with blood, that will compress the lungs and make breathing more difficult as well. And with that blood loss, we will have an inability to provide oxygen to the brain and other tissues that will cause eventual death.
How fast would you expect the blood to be coming out of the heart with a wound like that in it?
Pretty quickly, especially with an injury to the left ventricle.
Go on to Exhibit 83. What is this a picture of?
Here we're looking at the liver, and we can see, this is looking at the backside of the liver with the gallbladder here. The diaphragm would sit above this, and we can see the wound path continuing. After it goes through the diaphragm, it continues through the liver here, causing this disruption and destruction of tissue.
And for the record, the witness has used the red laser pointer to point out the apparent injury that goes across the top right quadrant of the liver in stage 83. So, if you just, this type of injury just on the liver, is this bad?
Yes, the liver is also highly vascular. A lot of your blood passes through that in order to metabolize substances. It has a lot of function for that. So you can expect a lot of blood loss from a larger liver injury like this as well.
Okay, and section of 84, what is this?
Here we're looking at the right kidney, and we can similarly see the defect there caused by the wound path injury, the pole of the kidney.
And for the record, you were pointing at, you can see the clear wound at the top quarter portion or top third portion of the kidney in stage 84, is that right?
That's correct.
So, what about just this wound itself? Could this be a fatal wound?
Yes, it can. A lot of blood, when it leaves the heart and is pumped down through the aorta, blood will then go off to the kidneys, and the kidneys also serve as a filtering function for that. Because of that, a lot of your blood volume, when it's pumped, goes through there, so you can have extensive bleeding from kidney injuries.
And so this may sound like a dumb question, but the human body is filled with blood. Why, I mean, is it bad when there's blood where there shouldn't be blood?
Yes.
And what I mean by that is it good to have just free-flowing blood in the chest cavity?
No, it presents two problems. One, again, just the loss of blood. If you don't have it in your vasculature in order to provide oxygen and nutrients to your tissues, that will, cause damage to them, will frequently lead to as hypoxia, the lack of oxygen being delivered to those tissues. Additionally, we may have other problems caused by the blood being in an inappropriate cavity. As I mentioned earlier, is that blood, as it pumps out, collects in the chest, that will put pressure on the lungs, keeping them from expanding and inhibiting breathing, which will further exacerbate the inability to oxygenate your blood.
So would you be surprised if earlier in the trial a paramedic had said they had worked on Atatiana Jefferson for 20 minutes and she never breathed on her own?
That wouldn't surprise me.
And they never had a pulse?
That wouldn't surprise me either.
And they never had an electrical reading from the heart?
Again, I wouldn't be surprised by that. This is a very lethal wound.
Basically, State's Exhibit 85. So what is State's Exhibit 85?
This is the bullet that was recovered from her back.
Okay, is that normally how bullets look whenever the actual projectile, when you see them after they've been shot?
That's not uncommon depending upon the type of ammunition. Many types of bullets are designed to kind of open up to disperse the energy into the individual and keep from penetrating through and striking someone else.
Okay. State's Exhibit 86?
This is the bullet from the side.
And is that kind of a better picture of it opening up so it kind of disperses that energy?
Yes.
And then State's Exhibit 87, what is that?
This is the radiograph or x-ray of, particularly we can see the pelvis hair, the bottom of the rib cage, and the bullet on the right side.
So, after Atatiana was shot, and that bullet traveled the way it did she have any chance at surviving that wound?
These are very devastating wounds. I would not expect somebody to survive them.
So, your heart's above your liver, which is above your kidney. How would you explain the bullet traveling in that path?
So when we describe directions of wound paths, we'll generally describe them in a standard anatomic position, where an individual is standing face forward, arms at the side, palms out. And then we'll describe in that position as going from the back to the front, right to left, etc. I can't tell you what position an individual was in when they were shot. Based off that, that's why we standardize that.
But would it be consistent with someone who's maybe leaning forward?
Yes, there's a downward trajectory for that, so that's a frequent scenario we'll see with downward trajectories, that if somebody is leaning forward would explain that.
Well, would Atatiana died quickly with a wound like this?
Yes, it would be pretty quick.
Well, if we've seen some body camera footage that showed her groaning and moaning, would that surprise you in any way?
No, that wouldn't surprise me.
Well, why is that not surprising?
It wouldn't necessarily be immediate, as with the injury to the heart, it is going to take some time for that blood to leave the body. The lack of oxygen delivered to those tissues and subsequently brain function and the shutting down of the body will take some time.
Have you ever heard of a term called agonal breathing?
Yes.
And what is that?
That's frequently a term used to describe somebody's kind of final breaths while dying. As the brain is shutting down, you may even continue because it is a lower, breathing's a lower function, a more essential function in the brain. That'll continue for longer after other regions of the brain may no longer be viable.
So, taking a gun, pointing it at somebody, pulling the trigger, is that an act really dangerous to human life?
I think so.
I mean, it clearly was in this case, wasn't it?
Yes.
What's another term of art, what does cause of death mean?
So cause of death is what we use to describe the injury or disease process that caused someone to die. Common examples of that might be a heart disease.
What was your finding of cause of death in your autopsy of Atatiana Jefferson?
It was a gunshot wound of the torso.
And what does manner of death mean?
So manner of death is how we classify deaths. as the classifications are natural deaths, which are due entirely to a natural disease process, accidental deaths where common examples of that may be motor vehicle collisions or drug overdoses. Suicides are when the person inflicts the death upon themselves, and then homicide is death at the hands of another person.
And what was your ruling for the manner of death in your autopsy of Atatiana Jefferson?
Homicide.
We'll pass the witness.
Cross-examination.
Thank you, Judge. Good afternoon, Doctor.
Good afternoon.
You doing all right this afternoon?
I am.
Your manner of death, homicide, suicide, accident, there's also an undetermined, isn't there?
Yes, there is.
And in this case, you determined the cause of death to be homicide, is that right?
That's correct.
Now, that's a medical term, is that right?
More of a functional term, I would say.
Well, I guess the point I want to make is that homicide is not synonymous with murder, is it?
That's correct. We don't make determinations of murder. That's left to triers of fact.
Okay, so murder's a legal term, right?
That's my understanding, yes.
It has a specific legal definition in the state of Texas, doesn't it?
Yes.
And it also has a series and set of justifications that apply to a murder case also, is that right?
I'm not a lawyer, but that's my understanding.
You were describing earlier the path that you described to this boy as it traveled through Miss Jefferson's body.
Yes.
And maybe you could either I could demonstrate on myself or you could demonstrate on yourself. Would you show the jury where, if you were use your body to demonstrate Miss Jefferson's body, show the jury where the bullet entered her body?
So it was on the left upper chest, as we saw in the pictures in this, both this area.
And where did you locate the projectile that you located?
The bullet was in the soft tissue of the right side of the back near the 12th rib.
And the entry, you do some measurements when you do an autopsy, is that right?
Yes.
And isn't it true that the measurement that you ascribed to the entry wound was 11 inches below the top of her head?
Yes.
And you can feel free to consult your report if you do not recall off the top of your head.
Yes, it was 11 inches below the top of the head.
11 inches from top of head to entry gunshot wound, is that right?
That's correct.
Okay, and then where you located the bullet was down here in the lower back, is that right?
That's correct.
Did you measure the location of the projectile?
Yes.
And what was the measurement you got?
That was 21 inches below the top of the head.
So would it be a fair statement that the projectile was located 10 inches lower than the entry gunshot wound?
Yes.
So from here, from entry gunshot wound up here to the location where it was found is a 10-inch space, is that right?
That's correct.
So the bullet traveled through her body in a downward path.
Yes.
Is that a fair statement?
Yes.
Did it also travel from her left to her right?
That's correct.
You measured it to be from the front center of her body, you measured it to be 4.5 inches to the left of the front center of her body?
Yes.
And in the rear of her, where the projectile was located, you measured that from the posterior midline, the back, the middle of the back, is that right?
That's correct.
But you ascribed the direction looking at it from the front, is that right?
Yeah. Oh, yeah. Again, the direction we describe as in a standard anatomic position.
Which is facing the subject, right?
Yes.
So the bullet ended up being 4 inches to the left of her backbone as you look at it from the front.
No, we turn the body over to measure it from the back when we recover that. So
but it is the midline and the back and the front are in the same.
Let's look at your report real quick. Because in your description, you're describing it as you saw it from the front. Look at the bottom of page 5.
Mhm.
The bullet is recovered from the subcutaneous tissue of the right lower back, 21 inches below the top of the head, and 4 inches left of the posterior midline.
Yes,
So
posterior is back.
it is back, isn't it?
Yes.
And it was 4 inches to the left of the posterior midline,
Oh,
right?
yes, that appears to be a typo on my part. That should have been 4 inches to the right.
Okay. Stand up and show the jury. Let's forget all about the directionality and everything else. Show the jury where it was.
So the bullet was around here in the back.
Okay. So not only did the bullet travel from top to bottom in a downwards direction, it also traveled from left to right. Is that correct?
That's correct.
So could you show the jury how Miss Jefferson would have been facing the weapon that struck her?
Again, I can't tell you the position of the body in any given instance.
Well, did the bullet deflect as it entered her body?
I don't have anything to suggest that.
Okay. Well, then it traveled in a straight line path, right?
Generally, they do.
Okay, and they generally travel in a straight line path from the muzzle to the target too, don't they?
That's correct.
All right. So, would it be a fair statement that she had to have been facing the weapon in a somewhat crouching position?
It was consistent with her facing the weapon and leaning forward.
And also, she was facing it in a bladed stance, wasn't she?
I'm not sure what you mean by that.
Well, she wasn't facing it directly center on, was she?
Yeah, that would be consistent with her being turned somewhat to her right.
To her right, which is this way, correct?
Correct.
So relative to the bullet, she's down like this and twisted to her right slightly.
That would be consistent with the wound path.
So you described her being based upon your observations during the autopsy and also the investigative work that was provided to you. You understood that there was an intermediate target between the muzzle of the weapon and Miss Jefferson, is that right?
Yes,
And you understood that to be a glass window, correct?
that's correct.
So, based upon your testimony, tell me if this is a fair statement, that the glass window stopped whatever gunpowder was ejected from the muzzle of the weapon. Is that right?
That could be, that'll depend upon the distance of the firearm from the window.
But that's certainly a glass window would do that if the firearm was close enough to it.
Yes.
But then also at the same time, when the bullet entered the glass window, it created a fracture in the window, which caused the window to shatter and create these particles that we see on Miss Jefferson's face and upper torso.
Yes, that's correct.
And it would be a fair statement that based on the laws of physics, that when the bullet entered the window, that the material spread out in a cone shape from the window.
That's a common understanding of that, yeah.
So that from a small defect in the window, the size of the bullet, that's how it got in the larger pattern on Miss Jefferson's body. Is that right?
Yes.
Would you be able to make any statement as to how close she is to the window when she suffers the gunshot wound?
No, I wouldn't.
Do you have any idea how far the glass particles might travel?
No, there's a lot of variability depending upon particular targets, interposed targets, and there's a lot of variability even in like different types of glass, and I'm not familiar with those studies.
Well, in a case like this where you could open up your inquest and autopsy and order that the window be delivered to you, is that right?
I probably could make a request for that.
And the police department would probably even furnish you the exact weapon that was used to fire the projectile, is that right?
They probably would.
And then some experiments could be done to determine how far the glass particles are spread by the gunshot.
I would recommend that more be for a firearms expert or an engineer for that type of a study than myself.
It could be done, isn't that right?
It could be.
Now, your office doesn't just conduct autopsies, isn't that right?
We do have a crime lab as well.
You have a crime lab that contains a DNA laboratory?
Yes.
Do DNA comparison work?
Yes.
You have a firearms lab?
Yes.
You also have a trace laboratory?
Yes, so that's been discontinued.
You know when it was discontinued?
I do not recall.
What is a trace lab? What type of work does a trace laboratory perform?
Frequently they do examinations on things, trace evidence, things like hair fibers.
Gunshot residue?
Yes, so they will do scanning electron microscope to examine for gunshot residue.
In this case, when Ms. Jefferson's body was presented to you, were her hands bagged?
I would have to check my notes.
Please do it.
I don't show that they were.
What is involved in swabbing a person's hands for gunshot residue?
We use stubs to collect particles from an individual's hands to test those particles or any material that might be there for whether or not gunshot residue is present.
Was that done in this case?
The stubs were collected. I did not, we leave that to the police to whether or not to run them.
And what kind of evidence can those SEM, scanning electron microscope stubs, reveal?
They are used to detect the presence of gunshot residue.
And that can tell you whether or not the person was in proximity of a handgun, is that right?
Not exactly. Interpreting gunshot residue is very complicated. So, for instance, an individual may have a positive test, but they may have been in the vicinity of a fired weapon. They may have handled a weapon that had been previously fired. They may have had contact with a surface that was in the vicinity of a fired weapon. Or individuals who have washed their hands, we may not find it in that scenario. And there's variability based on ammunition. Some ammunition doesn't show up as well on gunshot residue.
Whatever the test you might reveal, that wasn't done in this case, was it?
Such testing would not help me determine cause or manner of death.
But the police department didn't ask if the testing be performed either, did they?
I don't know.
Who would know?
I would ask the police.
Did Ms. Jefferson, she had evidence of life-saving measures, is that right?
That's correct.
Okay. So, someone, MedStar, fire department, whoever it might be, someone made a valiant attempt to save Ms. Jefferson, didn't they?
Yes.
Back at the time that you performed this autopsy, Dr. Pirwani was the chief medical examiner of Tarrant County, is that right?
That's correct.
And Dr. Pirwani has moved on, and you all have, there's a new medical examiner that has been appointed for the Tarrant County Medical Examiner's District, is that right?
That's correct.
Now, Dr. Pirwani testified in these courts for many years, and one of the things he used to testify to in a case like this was that if this injury had occurred to this individual in the ER, it's likely that they would not have been saved. Is that the circumstance in this case?
Are you asking me what he testified to?
I'm asking you what, if this injury had occurred in an emergency room, a level 1 trauma center, for example, like JPS, is it likely that this individual would not have been saved?
I would not expect them to survive this even in that scenario.
Even if the gunshot wouldn't have occurred in the middle of an emergency room?
Yes.
That devastating injury?
Yes.
In addition to the therapeutic intervention that you saw, did you also notice that Ms. Jefferson had an insulin pump, that you wore an insulin pump?
Yes.
And did she also have a catheter that introduced that insulin into her body?
Yes.
And where was that located?
That was present on her tucked into her sweatpants.
Did you take custody of the insulin pump as part of your inquest and autopsy?
Yes.
Did you take any steps to download does the insulin pumps typically have a memory device of some kind?
Some, it depends upon the model.
Did you inspect this one to see if it had memory?
I did not.
Did you ask anyone to attempt to download the data?
I did not.
That it may or may not contain?
I did not.
We'll pass the witness.
Redirect.
No further questions, Your Honor.
Dr. Freeze, if you'll step down and just remain in the back for me, okay? Appreciate it. Who do you have next? Ashley Carr?
That's fine, but he's gonna mute it, and that's fine.
You raise your right hand for me. Solemnly swear or affirm testimony given this cause to be the truth, whole truth, and nothing but the true self to God. Have a seat. Is Ashley spelled in its common?
Yes.
Okay. Ms. Diener, whenever you're ready.
Good afternoon.
Good afternoon.
How are you?
Okay.
Turn to the jury and introduce.
My name is Ashley Carr. I'm the oldest sister to Atatiana Jefferson.
Tell the jury a little bit about y'all's family. Let's start with, are you the oldest sibling?
Yes.
All right, and I know I'm not supposed to ask a lady this, but how old are you?
38.
All right. And do you also have other siblings besides Atatiana?
Yes.
Okay, tell us about your other siblings. What are their names and how old are they?
After me, it's my brother Darius Carr. He's 34. Then after him, it's we have a sister named Amber Carr, who is 33, and then Atatiana would have been 32 this year.
And is it Darius, is he over there behind me or my left side?
Yes.
He's been here all week.
Yes.
All right, and Amber, she's also been here all week. She's also in a wheelchair, is that right?
Correct.
And that's Zion's mom, you said?
That is Zion's mother,
And so, y'all's mom was who?
Yolanda Carr,
Tell me where you guys grew up.
in the neighborhood of Dallas called Oak Cliff, Texas.
And when did y'all live there and pretty much raised there your whole life?
Yes.
And where did you go to college?
I received my Bachelor's of Science in Mathematics from Texas Southern University, and I also have a Master's of Science in Finance from the University of St. Thomas in Houston.
You have a bachelor's in mathematics?
Yes.
That was my worst subject. That's why I became a lawyer.
Currently, I work for Deloitte as a engagement financial advisor.
And so just your day-to-day, are you working like a 9 to 5 job?
Yes.
Okay. And what does that mean exactly? Like you said, what's your specific title?
I'm an engagement financial advisor. We have clients that hire us to make sure that they have whatever projects they have, that we make sure that they stay on budget on all parts.
So grow up in Dallas, and so tell me about Atatiana. Where did she go to college?
Atatiana graduated from Xavier University, I think in like 2014.
So right after college, where did she go? She moved in immediately in with Yolanda or go somewhere else?
After college, Tay came home. She moved in with my mom, and she stayed there for maybe like a year or so. And then she moved out to, wanting to have her own wings. But then when we started getting, our mother started becoming ill, she decided that it would be best for her to move home to help my mother, because it was a long drive from Dallas to Fort Worth of her coming out here to help, as well as for her to start saving so that she can go to medical school.
Do you know what kind of doctor she wanted to be?
She wanted to find the cure of diabetes, since she's had it since she was very young.
So she moves in with mom, you said in 2015 or so?
April of 2019.
2019, because
She moved, yeah, she moved in, moved out, moved back in.
So April of 2019 is when she had moved in, before this happened.
Mm-hmm.
But we get pretty far off of where all this, and anything from that is the subject of another report.
All right, let's kind of move on a little bit.
And Your Honor, I think to ask her about the neighborhood and the house. which
That's
is
fine,
directly
that's
related
fine.
to this case.
Yeah, that's fine, but what I'm saying is, let's move on.
Okay, so asking you about when she moved into that house, are you familiar with that particular neighborhood?
More familiar now.
Okay. Throughout the course of this trial?
Yes.
All right. During the time when this happened in October, were you living outside of Fort Worth, or where were you living?
I live in Houston.
Do you still live there?
Yes.
All right. Okay.
She's going to cure diabetes.
October of 2019, who all lived there?
Atatiana, Zion, and my mother, Yolanda.
How long had Yolanda, your mother, been in the hospital before this happened?
About a couple weeks, because Amber was in the hospital as well.
Amber's in the hospital, your mom's in the hospital, so who is taking care of Zion those few weeks that that's happening?
So Atatiana is taking care of Zion.
Is she working during that time?
Yeah, she works at home. She works from home.
All right. And so, did you hear Zion testify?
Yes.
And were you familiar, and if you're not, that's okay, were you familiar about the use of the front door, the side door in that house with the family?
Yes.
Okay. Tell me about that. Tell the jury about that.
My mom's side door is always open. It was one of those, you just pull up and come on in type house.
Would she leave the door unlocked?
Yes.
Did she keep that front door shut?
Yes.
Mayor, first, what's your honor?
Yes, ma'am.
Hand you what's been pre-marked as States Exhibit 90.
Hard to see how this is relevant. I mean, the
91.
responding officers are not going to know about the door habits.
And 92. Do you recognize those photographs?
Yes.
Okay, can you tell me States Exhibit 90? Who was that?
Atatiana.
And States Exhibit 91. Who is that?
Atatiana and Zion.
And who is this little boy over here?
This is our cousin slash nephew. Well, that's my nephew. I don't know.
Wait.
I'm sorry.
I think we have the wrong photograph. I thought that was Zion.
This is Zion.
It is Zion.
Okay, I'm sorry.
Yes, sir.
Go ahead.
May I proceed? Take
Yes,
care.
go ahead.
And then, I'm sorry, I didn't want to cut you off. You said Zion, Tatiana, and then who is the other boy to the left?
Our little cousin, DeLeon.
And then 92, what is that?
Tatiana at her graduation.
Okay. Is that graduation from high school or from college?
College.
Do these all fairly and accurately depict Tatiana in the way that she looked as an adult, close in time to when this happened?
Yes.
And tell me, States Exhibit 90, do you know where that was taken?
Yes.
Where?
In San Diego. We had did our first siblings trip to San Diego to see our brother because that's where he's currently stationed in the Navy.
Your Honor, we offer States Exhibit 90, 91, and 92. And these have been previously shown to the defense counsel and provided.
Okay. States 90, 91, 92 are admitted.
Permission to publish those exhibits?
Yes, Mr. Hicks.
Looking here at States Exhibit 90, you said that was a trip to San Diego?
Mhm.
Is that yes?
Yes, I'm sorry.
That's okay. And then you said it's where Darius brothers.
Hang on. May have gone.
Yes,
What branch do you know is in?
he's in the Navy.
So siblings all go? Is it all of you guys that go?
Yes.
And when was that?
The summer of 2018.
Now looking at States Exhibit 91, who are we looking at here?
Zion and Atatiana.
And the little boy to the left, is that who you
That's
said?
De Leon.
And now States Exhibit 92.
That's Atatiana at her graduation from Xavier University.
Are we smart to look at?
Sometimes.
Very possible to run.
Cross-examination. If you will unclip that microphone for me, just lay it right there on the desk, you can step down.
Thank you.
Councilman Halpert.
Well, that seemed rather pointless, or at least not relevant. Yeah, so she obviously had nothing to add to anything of legal relevance here. Maybe if there's a conviction in the punishment phase, they can, give a talk to the judge about the harm they suffered as a result of the death of their sister. But this has gotten no contribution to guilt. It doesn't go to murder, doesn't go to self-defense, doesn't go to recklessness. Purely emotional. And you can kind of tell how valueless it was by the fact that the defense didn't even bother crossing. All right, folks, don't forget the URL right there at the bottom of the screen, Law of Self-Defense. Free book.
So if you'll retire to your jury room, and I'll come back with some other instructions, okay? Thank you very much.
lawofselfdefense.com/free book. So the jury's being excused for a while. I guess they have some things to discuss with the parties.
All right, this is going to conclude court for the day. There are things that the lawyers and I need to work on, so y'all are welcome to be excused, okay? Thank you very much. Let me see y'all.
I wonder if the judge is pissed about that witness. Normally, I'd say that's not possible, but maybe it is. Maybe it is. This might be off mic. Right, so free copy, free. Look at the reviews on Amazon. Law of Self-Defense Principles, 1,200 plus reviews, I think, 5-star rated, but don't buy it there. Don't buy it on Amazon. They'll charge you $25 for the book, plus shipping and handling. We'll give you the book for free, real book, folks. We'll give it to you for free. We only ask you cover the cost of shipping and handling. You can get that at the URL right there at the bottom of the screen, lawofselfdefense.com/free book. And this gift giving season, you can get the hardcover copy for your loved ones who you'd like to keep out of prison if they are ever compelled to use force in defense of themselves or their family or their property. This one's not free because it costs too much to print, but it makes a wonderful gift. It's a lovely book. You can get this one at lawofselfdefense.com/gethard. lawofselfdefense.com/gethard. And don't forget the sponsor of today's content, and that is, where'd you go? American Law Courses, a law school level education in traditional first-year law school subjects at a fraction of the cost and time of law school and without any of the political toxicity of the law school environment today. AmericanLawCourses.com. We have 2 courses coming up in the spring, Property and Evidence, again, taught at a law school level, but in plain English. And right now we're in the pre-registration period. If you register now, you get half off those 2 classes, more than $1,000 each, while we're in this pre-registration period. So I would encourage you to go to that URL and take a look at what we have to offer at AmericanLawCourses.com. If you've ever wondered what the law school experience is like, ever wondered if you had what it takes to learn this stuff at a law school level, now's the opportunity to do it at a fraction of the time and cost of law school without the politics. We simply teach traditional American law in the traditional American way. And it looks like that might be it for the day. I guess I'll go through questions. Law and crime is down. Fox 4 News is down. WFFA, FAA hasn't been working all day, really. So let me take a look. If you have questions you'd like me to answer, comments you'd like me to share, they need to be, if you're on YouTube, at least a $5 super chat. And if you're a Law of Self-Defense member, I would encourage you to put it in the member chat. You can ask all the questions you want there for free. If you're not yet a Law of Self-Defense member, you're crazy not to be. It's less than $10 a month. Instead of these $5 and $10 super chats, every time you ask a question on YouTube, you could become a member for less than $10 a month and ask all the questions you want at lawofselfdefense.com/join. Also, I'm putting together recap videos, content, blog post and video for this trial. So there'll be a recap post. I'll probably finish it tonight for Monday and Tuesday of this case, of this trial. Let me turn off these darn beeps. And what I'll do is I'll have I'll chunk out the testimony for each of the witnesses, direct, cross, redirect, recross for each of the witnesses, and share my notes that I've been taking as we go along, so you can kind of get up to speed or refresh your recollection on what's been happening in court in a very specific, time-efficient manner. But those blog posts and videos will be available only to our Law of Self-Defense members. So, lawofselfdefense.com/join. That way you don't have to watch the whole, 7-hour stream in one shot we do in live streaming this trial. You can pick out the portions of the trial, pick out the witnesses, the testimony you think might be most compelling, and you can use my notes to guide you. So Monday and Tuesday will go up tonight. Probably today's will go up tomorrow. We'll have to see how things go. I'm not sure about tomorrow's schedule. I have to have a modest medical procedure tomorrow in the morning. I'm not sure what my afternoon is going to be like, but definitely I won't be streaming first thing in the morning. Maybe I'll start in the afternoon. I sent a message to Nick suggesting that he stream the trial tomorrow, but I haven't heard back from him whether he intends to do that or not. But I won't be streaming in the morning. So if you want to check out Nick's stream, see what he's up to, that's never a bad idea. And what else should I address? Oh, yeah, let me take a look at the super chats. I know a couple more came in. And also, of course, the member dashboard. So, yeah, my medical procedure tomorrow is no big deal. So don't worry about that. I'm just not sure if I'll be if I'll be functional in the afternoon or not. If not, I'll definitely be functional on Friday. So on Friday, unless Nick decides to take up this case, in which case I'll just join his stream, one of us will be covering live streaming for sure. I'm not sure yet how I'll do the catch up on the whatever I missed yesterday. We'll have to see. Let's see. Yeah, it looks like some table pounding from the prosecution, no substance. Dave writes, Your Honor, we ask that you place a time limit on the cross-examination of this medical examiner as he left his penny farthing double parked outside the courthouse and needs to move it before it gets towed. Charles writes, Andrew is only interested in Melon, the streaming software, because it's cheaper. He's not going to invite 12 people to join his stream. Oh, and they're not going to accept anyway. You know, I'm on these streams sometimes when there's 10 people, and it's really very difficult. I know I tend to overtalk people because I have stuff to say, but with 12 people, there's always somebody else talking. And it doesn't have like a raise your hand function. So you just have to start talking over people. I've gotten to the point where these giant collections of people I just don't find it productive. So no, I probably would never have 12 people on my show. What I'd like is for StreamYard, which is the platform I use for my live streaming, to have some audio controls, different channels for the stream, for me, for guests, so I could control audio levels. That would be nice. StreamYard. I don't know if Melon does that or not. I'll have to take a look. But if Melon doesn't do that, there's no point to switching. That's the only thing I would switch for. Okay, that's it for the member questions, I believe. Take a look at the super chats. Let's see. Maybe just one new one. Let's see. Kelly R, $10. Thank you very much, Kelly. This needs to change in our courts right here, presumably meaning that last witness, the sister of the victim. No information of facts, no weight to the trial. Yeah, I certainly agree. There is no value added there at all. At all. Pretty awful, really. All right, folks, I think with that, I will wrap up for today. Don't forget, become a Law of Self-Defense member at lawofselfdefense.com/join. Less than $10 a month. You can ask all the questions you want, and I will promise you to answer them. Alternatively, do the super chat thing every time you want to post a question. It's really more cost effective to be a Law of Self-Defense member. Plus, that way, YouTube doesn't take a third of the money. Every time you send $10 to me in a super chat, YouTube takes a third. You want to make YouTube richer? I don't know. Your call to make. All right, so folks, with that out of the way, I will just remind all of you, if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.